different types of IP are there for you to protect. So if we go by the dictionary meaning of the word intellectual, it's basically the creation of mind, right? And whatever is with you, whatever your belongings are, you will say it as your property. So intellectual property defines the creations of mind, like inventions or literary work or artistic work. Maybe there are some logos that you might have designed for your company, right? So to quickly get on to this, so first IP which is very well discussed and known to us is patents, right? So now patents as defined with the World Intellectual Property Organization is like it is a legal and exclusive right to the inventions for making, selling, using or offering for sale, or for importing the invention. So this is a very what you can say exclusive right given to the inventor for the invention for which he has filed a patent application, simply put. So now for what patents are can be filed or applied and are granted is the new invention. So basically there are three criteria for a patent to be granted. That is, first criteria is it should be novel. The idea or the invention that you are working on should be novel. It should be not obvious to the person skilled in the art, and the third thing is it should have some industrial application or industrial utility. So these are three basic criteria of patentability. So whenever you see an invention or you have an idea, you should have a look at these three criteria in order to say that the invention is patentable, right? Now patents are territorial rights, so it is bound by the boundaries of the countries, and every country would have their own patent law, and the prosecution in other countries as compared to India is different. So simply put, again, a patent granted in India will not be considered as granted in USA or for any other country for that matter. You will have to go independently in those countries and file your patent application in order to say that you have filed a patent application. Once it goes through the prosecutional steps, then you can say if the patent is granted, then you can say that you have a patent in that country, and vice versa also applies. So patent granted in US or Japan will not be having its effect in India per se, right? It's called a negative right because it is again excluding others from, as I said, making, using, offering for sale or selling the invention or importing for that matter. So it is a negative right. Now patents are granted to inventions, right, which is again having a technical advance in the invention. Then only you can say it is not very obvious to the person skilled in the art, right? Moving on to, so again, and then in India, the patents in India are are falling under the purview of Patents Act. So this is the law which would essentially give you an idea of how you should file the patent application, what are the procedural steps involved in it, right? Coming to the next IP is industrial design. So this is basically filed for new designs, right? So we have this mouse over here. So however you the mouse is the confirmation of this mouse is, right, if you feel that this is a very newly designed kind of a device, right, so you can file a design application for how the mouse is looking like. So it is basically again filed for new designs and utility models. Now whether to file a design application or a patent application will depend on how you have improved the product, right. So if you have improved the product and if you feel that the functionality of it is getting improved, then you can go for probably for filing a patent application. If you feel that the functionality is going to be the same, just the outlook of the product has been changed in order to accommodate this aesthetic aspect, or it is improved ergonomically, or from usability point of view it is very easy to use, then you may go for filing an industrial design application, which is again falling under Designs Act, right. Going to the next IP, it's copyright. So copyright is it's given to the original work, let it be creative or artistic or any cinematographic work for that matter, or let's say you have compiled a database for certain things, you could go ahead and file a copyright application. The thing with copyright is it is not mandatory for everybody to register for a copyright, right. So it is automatic. So as and when you have started working on or creating the work, the copyright belongs to you. So you can just write C in the circle and then followed by your year in which you have made it. So it's automatic registration, right? But it becomes useful when you are into a conflict zone, right? Somebody has copied your research paper or the work that you have done and they are publishing it. At that time, the copyright registration, if you have that certificate with you, it helps a lot during that period. So in any case, for a startup, the first and foremost IP that they create is the trademark, right? Whenever you coin a word for your company name, that is a trademark essentially. Later on, if you go and make a nice logo out of the company name, it could be again a trademark application. So trademarks are basically distinctive identification of products and services that the company is going to offer. So let's say there are multiple companies in one industry domain. They are providing the same services or similar products, right? But they are able to differentiate themselves from the rest of the companies. So that distinction is helpful with the help of filing the trademark application. So now the distinction could be in the form of how you have represented the logo, how you are going to develop the logo in a different artistic manner, right? Or there could be some lettering that you will be using in an artistic way, or any arrangement for that matter of the letters. These are the distinctive features of the trademark application, right? Moving on to next is geographical indication. This would not be very much relevant to the people who are attending this session, but then geographical origin is indication is one thing wherein you take the quality and reputation or characteristic of that product and the place of origin of that product, right? So there is very famous example of Alfonso mango. So recently they got there were three geographical indications for Alfonso mango filed by three different cities basically. So now they are Ratnagiri Hapus, Devgarh Hapus, and then there was one more Hapus. So they three had filed separate applications, but now they are combined and given as a one Hapus GI, right? So it would again depend on the quality, reputation, and characteristic of that particular place from where that product is getting originated. So Darjeeling tea is one of the famous examples in India, which I could cite, right? Moving on to next is trade secret. So trade secret need not be, there is no formal process of filing the application and then getting a grant of it, because the name itself suggests it's a valuable information. It needs to be protected. So there are ways by which you could have confidentiality agreements with which with the people with whom you would be sharing this information, right? So again, by having it as a trade secret, the person holding that information should have made reasonable efforts in order to not disclose that information anywhere else, right? So this is these are basic types of IP. These two again are like plant variety. So if you discover any new variety of the plant, you could protect it with the Protection of Plant Varieties and Farmer Rights Act, under that act. And but if you invent a new crop, let's say with some genetic modifications, you have changed the gene sequence and then you have incorporated it in the available plants. So you could probably claim for the process of how you are doing it, but then this plant essentially would not be considered as a separate patent application, right? So that would be a plant variety. Then comes integrated circuit layout. So it basically protects the IC layout designs. So the way you have designed the integrated circuits, that falls under this particular IP. So let's say now this is a device, this is a remote, right? So there are multiple IPs that I can think of here, right? So the design as it is would be filed as a design application for this particular remote, right? The IC layouts in this would be again a different IP, right? Now there is a trademark over here called Sony, right? So that would be again maybe filed as a trademark application. How it functions? So maybe if I improved it functionally, let's say if I can use this remote for any projector for that matter, right? And it is able to detect that that particular monitor, so I could file a patent application for this product also, right. So one product would have multiple IPs associated with that. So while you are going through the sessions, the upcoming sessions, you might want to think upon what you are going to develop in future, what are the products that you want to build or services that you want to build, and what respective IP is there for you to protect, right. So these are, like, in short, I have written the lifespan of a particular IP. So for copyright, it's creator's life plus 60 years. So once a book or a photograph or whatever that falls under copyright is issued, it is the author's or creator's life plus 60 years. Okay. For trademarks, it's 10 years from the date of grant of the trademark and can be renewed further, right. In the patents, 20 years from the date of filing. Actually, when you submit the patent application, from that date onwards, if the patent is granted, it would be valid for 20 years. For industrial designs, it's 10 years and can be renewed for further 5 years, right. For GIs, it's 10 years and can be renewed for 10 years. IC layout, 10 years from the date of filing of the application, and for plant variety, it is 15 to 18 years, and it depends on what kind of plant variety you are going to protect, right. So this is basically the gist of, or the maybe the introduction of IP. So this is from my side. If you have doubts, queries, yeah.
Now, where we have this expiration and renewal period,
Right.
it's what happens after that? Just take an example, industrial design.
Mm-hmm.
We have got first registration
Mm.
for 10 years,
Right.
and I renew it for 5 years.
Right.
So I get a protection until 15 years
Yes.
in total.
No. So
what happens after that?
yeah. So after that, that particular design application would be in the public domain and available for use by anybody else, right. So you basically lose the ownership in that particular case, right. So then anybody could make multiple copies of the patent.
And the same case is with others.
Of course. So as soon as you the period is lapsed, it's like your ownership is gone.
So what happens? What will happen to Alfonso Mango or say the Archidenti?
So they could renew it. They can keep on renewing it, the registrations.
Yeah. So for industrial designs also, after 15 years,
Hmm.
can I file an application
For the same.
registration?
No. So
GI can be renewed again and
yeah,
again.
yeah.
That's what I think it has to be clarified there.
Yeah.
The rest you can't. See, the whole deal between you and the government is that you disclose it to the public in the broader interest of the world. Okay. In return, they give you some limited
Protection.
time of exclusivity. Okay. So the whole that is what you do in IP. Okay. That's the trade-off, right? You can keep it as a trade secret, but then you run the risk that you can lose it, and also you don't get the assurance of the government that you can keep others out of it for some period, right?
Thank you, sir.
We will stop
Yeah.
here.
Yeah. Sure. Thank you.
Yeah, please. Question.
This in case of patent actually grant actually, how this obviousness decided?
Sorry.
Obviousness, second criteria, how
Uh-huh.
it decided whether it is obvious or
No.
not.
So
Briefly.
so once a patent is filed, these things are checked by the patent office, whether that invention is obvious or not.
No, which are those criteria actually? Basically,
So novelty-
my invention is obvious or not obvious.
There are
Or
different
it should be dropped for
mechanisms.
filing, or it should continue go ahead for further filing. How it is decided actually?
Right. So there are ways in which you could have a look at different patent documents in that particular area of research, of your research, and arrive whether your invention is still obvious or not, or it is not obvious. If you have improved the invention technically, from technical point of view, you could say that your invention is still not obvious to the person skilled in the art.
But
I think
sometimes we
what
say
we'll do a detailed discussion on this tomorrow.
Yeah. So
In,
there is.
track 2. Okay, but briefly, if you want to say something, you can say. His question is around obviousness.
Yeah,
Okay.
true.
So the basic argument there is this, that see, first, novelty is very simple to understand, right? That nobody else should have done it, right? Obviousness basically says that if you have a body of literature, if you think somebody has average person who understands the software can extrapolate, okay, to that invention, then it's obvious. Okay. Now that's a little vague, I understand, right? It's not entirely, you can't, like, it's not a formula, right? But it's the way you explain that this jump happened, basically makes it whether it is inventive or not. Okay, that's what this is what I'm telling you briefly, but there's a lot to it in terms of how you do it. Okay, one way of, so one thing which I think you're from NA. Okay, so in engineering there's a typical problem, right? Because people are putting together things which exist, right? So usually in an invention, I'll give you one example. So you wouldn't state the story as saying that I knew this, and therefore I got this, like in a paper. Okay, you would say I put these things together and surprisingly this happened. Okay, that's broadly what an inventive.
One more thing I just wanted to know, in case of the trade secret actually, let us some dispute comes in the future, how do you resolve actually? So what kind of law is followed there actually?
Yeah, so the government doesn't give you any assurances there. It's basically the trade secrets. If you have trade secrets, you are binding people through contracts that they are signing. Okay. So, for example, the confidentiality agreement an employee signs with a company, okay, will say that you will not reveal something, right? Now, that you can take that person to court if that happens. Okay. So, for example, you might have heard about the recent case where Google sued Uber, okay, for autonomous vehicles, right? And the employee shift moved from Google to Uber, and Google's argument was that he carried with him trade secrets, right, which he used in the benefit of Uber, right? So he was taken to court. Uber ended up firing him eventually. Okay, they couldn't retain him. So that threat is what keeps that trade secret a trade secret. Okay, but you cannot. Government doesn't give you any independent guarantee. It's just that you know under the law, just like any other contract, you can do it. Okay, so I think I'll continue with this. Shall I?
Mike.
By the way, this is only for the recording purposes, so just letting you know. So, okay, while we are doing this, quick count. How many chemists here? Okay. How many biologists here? How many physicists? How many engineers? Okay. So we have more engineers. Any other disciplines I missed out? Pharma? No. Okay. So, and how many are in startup mode, budding entrepreneurs or startups? Okay. How many are inventors who are standalone inventors or organization inventors? Okay, I think these two also. Okay, so let's start. So what I want to do is Ashutosh has given you a quick introduction to IP. Basically, just to trade secret part, I just want to tell you that that's where you're not disclosing anything, but the rest you are disclosing in return for certain formal rights. Okay, so I'm going to try and cover some broad ideas. It's also introductory in that sense. So, but before that, little bit about this base camp itself. Okay, so I told you about these 3 tracks. I don't want to repeat it. What we will try and do is that during each of those tracks, there are different things that you can look at. So I just wanted to give you a glimpse of those. Okay, so in track 1, for example, there will be if you can imagine that your company runs because there is certain know-how over there. Okay, so it can be large, small, doesn't matter. There is a certain know-how which makes you do what you can do as a company making a product or you know, if you are running a process, there is a know-how behind it, and there will be multiple components. Like this particular thing might have 50 different know-how components, okay, which go into just making this particular device. It could be the electronics in it, it could be the optics, okay, it could be the design of this case, how they make this dabba, so many other things. Okay, so there can be different know-how components, And you can imagine that you would want to map out your know-how components and know which is core to your company, which is not, right. Then you would also want to know what is the status of each of those know-how components, right. Do I own something, do I not own something, do I have rights for something, can I practice it, can somebody else, will somebody else stop me from practicing, all that you need to know, isn't it. And then the world is not static, okay. So things are moving as you speak, right, in your field. So there are developments happening, okay, and you know some of them, that this is how it's going to head. Can you anticipate those, right. Furthermore, there is also this issue that can you really work on this topic or not, in the sense has somebody already blocked you out, okay. And then there will be other things, like suppose you have to bring some technology from somebody, how do you do it. So these are some things which I am suggesting, those which in track 1 you might want to explore during the course of this workshop, and try to put together what are those things for your own company or your own technology, okay. There are simple things like deciding inventorships, okay, ownership and so on. What are the policies governing those ownerships? Have you put it in place as a company? Have you put those things in place, in the sense, is there a simple rule which says that anything anybody does in this company belongs to the company, right, and where is it, where is it embedded, okay. Issues like that. Track 2, you can think of different things. For example, track 2 is more about IP filing strategy and so on and so forth. You know, you need to do searches, you need to understand the landscape, you need to write your patent drafts in a certain way, you need to think through your claims, you need to understand what is patentable, what is not. The question he asked about inventiveness, about non-obviousness, has to do with patentability assessments, okay. You will need to know what is your filing roadmap, okay. When do you want to do what, where do you want to enter, which countries and so on. There will be some amount of portfolio planning and analysis that you would want to do, right. If you have 5 different patents in your company, do you want to plan your portfolio, and how would you do that, okay. There would be a little bit more in your engaging with other partners. Suppose you go and work with another company, right, which is that part which you do not want to work with them on, and which is the part which you want to work with them on, okay. You might need to have a strategy around that, especially as a startup. You know, your valuations are so closely linked to what assets you are building for your company, that you may not want to work on some things with certain other companies. But if it does increase valuation, fine, but otherwise it may not, okay. And then we have something called an IP strategy score, which I think we will talk about later as well. And then in track 3, you will start thinking about a different set of topics. By the way, I will be giving all this in the restricted site, so you will have it eventually, okay, do not worry about that. Okay. Now, you will need to assess your invention for attractiveness in terms of how you want to take it to market. You will need some technology marketing documents. You will need to understand at least have some thought on how valuation will be done, right, or what will be, whether it is agreed by the final buyer or not, at least some triggers that determine valuation you should know, right. That much understanding has to be there. And then how would you out license or sell your technology. And you know, one other thing you can try and do in track 3 is that you can simulate some of those deals, okay. So if you have an Excel sheet, can you simulate what will happen if something you do differently, okay. What will happen to your, is this a good deal or a bad deal, how do you decide, right. Is there a quantitative way of thinking about it? That is something which you might want to think through as well. Okay, so here are some of those things which you might want to do in day 3, okay. These track 1, track 2, track 3. So please think through this, and you can gather your notes as you go along. Some of this might be new to you, but it is okay. I mean, this is how we will have to learn along the way. On day 4, all of you are required to do a presentation, and this presentation will have 2 parts. One is about the technology itself, another about your strategy. The technology part is important even when you are trying to pitch to investors or to buyers in terms of what is the real value proposition you are conveying. Most inventors do not understand this idea of value proposition at all in depth. what they do is they just say that they focus more on features of the technology. Whether the features of the technology are relevant to value or not is not in their mind, okay, and they assume too many things about the listener. So these kind of things I think you should bring out. So we are suggesting 4 slides here and about 6 slides here, and the strategy part will touch upon many of these things which you will learn in day 1 and day 2. Okay. So the exercise for you for day 4, the presentation exercise is this, okay, and if you want to compete for the prizes, this is what you have to do very well. Okay. So let me leave this here, let me move on now. So I have called it practical IP strategy because sometimes you just need to be very practical about what you do when you are a startup, because you do not have all the resources in the world. You need to think in a very careful manner about this as well. Just to tell you, so every organization, a startup, when you are building a startup, actually needs to put this in place in some form or the other. Okay. You will have an organizational goal, a set of priorities, and a set of things which will emerge from that, which will be policy. Okay. And policy will guide the strategy of your organization, right. You can imagine how closely it ties up with your business plan. Okay. So it is really important that you think through this. So if some of you are CTOs of your companies, you are playing that role, you need to understand that this is very, very critical, and you need to document that, and then you put institutional mechanisms in place. So let me give you an example. Suppose you say that you are an academic institution. Okay. Your organizational priority is creation and dissemination of knowledge. Okay. You might take the view as a policy that we will decide that all IP shall be open source or open access. That is your policy as an organization, let us say. Okay. It need not be, I am just giving you as an example, right. And based on that, you might decide what you want to do as a strategy. Okay. You might decide that you will not file at all, okay, or you will decide that you might file, but you might make it open access, okay, whatever it is that you want to do, and then you will put some institutional mechanisms in place. If you were, say, a company, private company, right, what would you do as a startup? Your goal and mandate is to create shareholder value, right. So you are trying to increase value for your shareholders, that is the bottom line, right. That is what you are trying to do there. So you might say that the policy is that we want to say that IP protection is a culture in our organization. Okay. That means we will protect it aggressively, we will make sure that value is created for our shareholders using IP, right. And as part of that, you might actually say that we will, an example would be that you might say that we are okay with trade secrets, right. But a public institution might decide that we are not okay with trade secrets. Okay. You understand what I am saying? For them it might be that they do not want to get into trade secrets, right. There are some US universities who have a very clear policy that they will have nothing to do with trade secrets. So if they license, they will only license IP, formal IP, which patents and so on and so forth. Why? Because they are in the business of teaching. Okay. How do they maintain trade secrets? They cannot assure anybody of any trade secrets. Okay. So you have to decide for your own company and your own organization how you want to go about it. So it starts here, which is that you must decide your organizational priorities, which will come from your business plan. Based on that, you will have a certain policy for your organization, and then you will build a strategy. A typical these could be examples of strategy to implement certain policies. We might say that we will file aggressively in frontier areas to keep the doors open for the country. This could be like a NCL, for example. Okay. That might be the policy that NCL might, a strategy that NCL might pursue. Okay. Another strategy could be that we will file conservatively only when commercialization success is high. That means we take a view that we will invest only when I see money. Okay. This is a very different strategy. So, this will change the way you decide to go about filing when you take filing decisions, okay. And that is why I am coming to this, that you need to understand that very carefully. There are some UK universities, for example, who have said that, you know, we will not go into any foreign countries as long as we do not have a commercial tie-up in place, which means that they have to find a commercial tie-up in place within 30 months, because 30 months is the PCT window. You know, you have to enter national phase before that, okay. So, if by chance you have not found your partner in 30 months, you are basically deciding that you will drop it, okay. It is a big decision in my opinion, because it is not easy to decide value of patents within, you know, a very short period of time. You know, sometimes in frontier areas technology evolves over a period of 6-7 years. So, you are actually being careless sometimes doing that, but you know, maybe they are resource constrained, maybe that is what they have decided they should be doing. So, it depends on each organization, okay, in what you do, but all of you need to do that. You need to have a set of these things in place. A simple institutional mechanism would be that as a startup, every employee when they join, they sign an agreement which assigns IP to the company, right. That is an institutional mechanism which is put in place, right. Or you might want to put in place a mechanism where they do it where there is a different arrangement, okay. In places, in research organizations, it might be that in certain places the ownership rests even with individuals, okay, whether if they decide to do that, in which case they might have a different set of documentation and paperwork that they might put in place. Many organizations will have committees deciding that. In startups, you will be the you know, usually the CEO or the CTO is taking the call whether they should file, and only for money decisions they are going back to the board or the CEO, okay, in terms of how much to invest and where to invest, okay. So, this is broadly what happens in now for startups. There are many reasons why you should consider filing patents, and there is always a question which I will come back to, but why should you be filing patents, and some of these are not obvious, some of you may not be aware of this as well. So, in the very beginning, when you want to say speak freely to a funding agency, okay, unless you reveal, you cannot build credibility around your whatever you are pitching, right. And if you do not, you are not going to get you will not be even considered for any funding support. So, it is better that you at least decide, you know, that you want to file something, protect it, and then talk about it, rather than try and hide it, because then its chances are very high they will just dismiss you right in the beginning, okay. Another thing it does, it brings sharper definition and credibility to what you are at least you have thought about what could be patentable, at least you have tried to define what is formal IP, okay. This is very important, which many people do not understand, is that it creates a pocket of value which is independent of the inventor, okay. Imagine a startup, you are a single inventor holding trade secrets, right, and an investor invests in you, puts money in your company. Tough luck, a car hits you and you are gone, right. The company and the investor have lost a lot more, right, because along with you has gone a lot of know-how, right. In that worst situation, if there was formal IP, at least the investor can sell something, right, or find another taker for it, right. This is being very harsh, but this is the truth, right. So, an investor sees independent pockets of value other than you are reducing key man risk in the company, okay, by creating IP, right. So, one needs to think about such issues as well when one is building, because at the end of the day you have to create value for your shareholders. It is not about just you, right, it is about every shareholder in the company. It of course shows sensitivity to IP issues. All companies would want you to be sensitive, right. If there is an opportunity to create value for the company and you are letting go because of some ideology, you know, you are a clear no in terms of, people would hesitate going with people who are stuck ideologically, okay. Okay. it keeps doors open for you. Imagine you working for 5 years on a topic and then you realize that somebody else has the patent, right? So your 5 years of work was free work for him because that is what you have done, right? You didn't even bother and check that that guy owns it. So you went and published 20 papers on it. So it is great stuff for him to use for his work, right? Which of course, I mean, why should he care to give you those rights, right? And this is the story of many academics in India, by the way, okay? Because they don't know that they are working on things which are already protected by somebody else, okay? Uh, there are also tactical reasons. I'll show you an example later where if you want to get somebody to the table to talk, you need to have something to show, okay? And that something could be a patent. If you don't have that, you may not be able to even get the attention of that person. This happens in domains where there are large players and you are a small fish, right? They can, if they see value in an idea, they can pump in lots of money in a very short period of time to swamp the place, right? What are you going to do? What are you going to hold on to, right? You can't say I was first to the market, because it doesn't matter, because they can pump in money and get it done, okay? So and most importantly, I mean, of course there is a claim and visibility, but the last and most important thing here is it's a source of sustainable competitive advantage, okay? So all investors would want to have an edge for you in your company, right? You want to have a competitive edge. How does that come? How do you sustain it? If the guy is going to catch up on you so fast, you have lost that edge. So how do you build that competitive edge is what startups are, what patents can do for you. So broadly speaking, this is what I think you should keep in mind, which is that the most, if you were to track one single parameter for a company and which determines its valuation, okay, it is the absolute value of profits with time, okay? I am saying absolute, that means you are saying profits, don't say percentage profits, okay? It does not matter, it is absolute value, okay? So if your sales goes up very fast and your absolute number of profits goes up and your percentage of profits decreases, it does not matter, absolute profits growing is what matters, okay? So that is one single line you can remember. Now whatever increases that fast, your valuation goes up, okay? This is for an established company. There are companies which build assets which will do this later, okay? So for them the valuation goes up differently. For example, Flipkart is an example where they are building an asset. Basically they were building a piece of jewelry for Walmart, okay? That is what it was, okay? They did not bother about profits. They were essentially building an asset which Walmart will milk now to generate this curve, okay? So what you are trying to do eventually is that you will have a story which will say that you are building profits over a period of time, okay? Now when you do that as a business, right, you of course want to make sure that this is increasing, and there are two things you can do, right? One is increase the margins, another is increase the market share, right? That means you are increasing your sales and market share, or you are increasing your margins in terms of, both these patents can help, right? So you can easily imagine that if you have a technology which is protected, you could probably price more. When you price more, your margins are going up, right? If there is a technology which is protected and nobody can enter, and that is what is sought after by people, you can increase market share, right? So that is the primary reason why you are actually building IP, right? Why I am telling you this? When you look out for IP in your company, look for anything that does this, okay, which is helps you increase the absolute levels of profits for the company, and the moment you do that, your valuation starts going up, okay? Okay, so it is primarily a source of sustainable competitive advantage. Please keep that in mind. Look for things which matter there. Now while you are doing all this, something like patents, by the way I am going to emphasize patents a little bit more here, you please realize that there are two independent, almost independent but not exclusive pockets of value, okay? So suppose you are an inventor and you have built a technology, right? Imagine a case where you have no patents. What do you do there? You are essentially selling a know-how, right? What you are selling is, I know how to do this, you find it valuable, I will sell you that, right? The guy is interested as long as he has freedom to operate, right. That means nobody else will stop him from practicing it, then there is value, right. So, suppose you have made a new tractor, there is nothing new in it, but you know how to make a tractor and somebody wants to buy that, they will buy that know-how from you as long as it is using things which are all not protected or free from any IP constraints, it will sell, right. The second right which you create when you create a patent, when you file a patent, is a right to exclude others from practicing the know-how, right. So, it is a independent tradable activity out here, which is a right to exclude others. So, you have a tractor and in that you have a component which is patent protected. So, that component nobody else can use and therefore, the tractor may be more valuable, clear. Okay. Now, I can now think of another example where this matters and this does not. Anybody? Where this matters and this does not. That means the guy who is buying from you does not want know-how. He says you keep your know-how, I do not want know-how, I only want this. So, no, so licensing of patents, but what I am trying to tell you is that you can have value here without this, right. So, have you been following all these patent wars which have been going on in the news with all the mobile phones and all of those guys? Have you seen that they were trading patents? They bought out a company just because the company had 1000 patents, right. Why? Did you think they wanted to learn how to make a phone? No, what they wanted was only this. So, you can trade each of these independently, okay. So, there is a common mistake that people make, which is that they assume that this has value only if this is there. It is not so, okay, right. And this is something which is a fundamental mistake many people make, right, which is that you can have value for this without this and vice versa, right. If your patent does not get granted, you still have value in know-how, okay, and so on. So, you have to see both independently. This tight linkage between technology and IP is a flaw, okay. Okay. So, we will move on. Even like organizations like say NCL and so on, just want to briefly touch since we have some researchers as well. There is different value for them. So, for example, in a place like NCL which works on say cutting edge science, the way of thinking is different, okay. We do filings for keeping doors open for our scientists, okay. It is not necessarily because we tie it up with the technology, right. You can imagine a scientist say takes 5 years to make any dent in a field, right. In those 5 years, if others have filed patents elsewhere in the world, you are out of the game, okay. So, you cannot participate in that game anymore, right. So, why would you not file, okay. So, that is something is a very different philosophy than what say somebody else might think. So, you have to think through these things in terms of what is your reason for filing and protecting some of this IP. I am just giving you multiple reasons, now figure out what is it for you, okay. There can be other things which I do not want to spend too much time, but let us move on. So, there are different kinds of analytical reports you will hear about in this workshop as well, and there are many things which you can think through. There are things like patentability assessments. This is the kind of question where you are saying whether it is patentable or not, okay. We will hear about FTOs and FTPs, freedom to operate, freedom to practice. Basically it says can I practice this know-how freely in a region X, okay. Some of these kind of reports and analysis you have to do as a CTO or get it done for as a CTO for your company, so that you are clear. Very often in startups it is the CTO doing all of this, okay. So, you have to do it yourself, but it is okay. I mean it is even doing a little bit is better than not doing it at all, okay. you might have be doing patent landscapes, you'll hear about white space analysis, something called infringement and assessment. I think you'll hear about all this during the course of this few days. I'm not going to spend much time, but there are many things which you can do, and this is where all the analytics come in. Many people focus only on analytics and all the in IP, but what I'm trying to tell you is this: as a CTO, you're supposed to use some of this. Okay, so a key lesson I want to point out here is every report, as a technology head, you need to know is meant to answer a given question for you. Okay, if it doesn't answer that question, it is useless. Okay, so the question that you pose is very important. So if you are leading your company's invention and technology strategy, learn to pose that question, right? Okay, so you need to ask, I make this, I want to sell it in Japan, can I sell it? Right, very clear question. So what would you go and ask attorney firm, right? I want an FTO for Japan for this product which has this know-how steps. Understand? So you need to identify which is that particular analysis you need for before you get in there. In certain jurisdictions, the cost of getting into a litigation is very high. Okay, so you should be careful. So for example, if you are entering the US markets in medical products or some of these products, people do that last after they have established themselves everywhere, because it's a litigious society. Okay, and you can easily run into trouble and it can bankrupt you entirely. Okay, so there's a case of a stent company, okay, Indian stent company, which went bust, okay, because they were over ambitious and went into the US market, okay, at some point, just because of litigations. Okay, many of these things the places like IP Phase do, and many other IP firms as well do. I just to give you a little bit more, something like we'll hear more about it, so I think I'll leave this out, but I wanted to point out that even funding agencies today like BIRAC is asking for FTO. Okay, that means you propose a technology in your proposal, saying that I'll do this. They're tell us, do you have freedom to operate? So if you are pitching for money, you better be aware what is an FTO, right? At least do know how to do that analysis. Okay. Okay, this is another part which is very critical. As a technology head, it's important that you be able to spot inventions, right? You should be able to see what could be a possible invention. A very typical error that people make is they think it's not big enough for a patent. Okay, they think it chota lagta hai, I mean it's not, but if it's something which is very key to your technology, please look at it more carefully. Okay, most patents are incremental. Okay, what if you go through the patent literature, majority of them are always incremental. Don't think and don't glamorize so-called breakthroughs. Okay, as long as it's creating value for your company, it is worth patenting. Okay, and if you think it is doing that. So this is one issue where people coming from scientific backgrounds tend to look for a big leap. Please don't do that. Look for small jumps which might generate some IP for your company. I tend to look for, usually I look at my know-how and then I look for the most technically challenging aspect of what we did. Okay, if there was something which is hard for people to do and we cracked it, there might be some IP there. Look for it, in terms of where that IP lies. And if you are a senior person and a young person comes to you with an idea, okay, don't shoot it down. Okay, it is well known that people have not been able to predict what will be a winner in terms of IP. Okay, so for example, Google's patent, right? Nobody really thought too much about it. At that time, it was just another search engine. A patent was filed, okay, but nobody predicted that will be anything big, right? So it's very hard, and it's well known in the history of inventions that it's extremely hard to predict which one is going to be the winner. So this notion that you can sit in judgment and figure out that this is important or not is sometimes not correct. So you have to take a different approach where you're building, it's an options approach. What that means is that you have to create some time for you to decide whether it's worthwhile or not. Okay? Take your chance without too much investment, take it little further ahead so that you have greater clarity, and if it's clear that it's not valuable, drop it. If it's valuable, take it ahead. Okay? So it's a slightly different approach of thinking about how you go about with patents. So one other general framework for many of you which you must keep in mind is that see, inventions, a very simplistic way of looking at it is that all inventions, there is a problem and there is a solution. Okay? You can define it in terms of a problem that you are framing and a solution that you come up with. Okay? And if there is novelty somewhere in that, you should look, it is an invention, whether it is patentable or not is a different matter. Okay? But you should look for an invention where you are solving a problem. Now, do not expect high science in it necessarily, right. There are simple inventions like the zip or the velcro, very creative, novel, there is no great science in it, but it works and it made somebody a lot of money. So look at inventions without whether there is science or not. Okay, it might still have in your own SOPs that you develop for your company, there might be one step which is critical. You can decide whether you want to keep it trade secret or an IP, that is a different matter, but if there is scope for IP, you can consider that as well. Okay. Even the bundling tie is a patent, the one which is used by in our shopping markets and all of those. The first Indian patent was just a pankha pulling machine. Okay. So you do, I just want to give you a sense that please look for patentable ideas in very simple things, not necessarily in very complicated things. Okay. It is very important to have clarity in ownership and rights when you are a startup. Okay. There are many agreements which people put in place, you will be hearing about these as well. The first one is about ownership, that means who owns it. Okay. So these are two please understand first the terminology of ownership and exploitation rights, right. It is like if there is a piece of land, there is an owner and that owner might give a right to somebody to build a building on it, right, but the ownership of the land stays with the owner, the license right to build that building has been given to somebody else, right. So it is similar. So here you are talking about ownership. The first thing of course you do are contracts, right, employment and consulting contracts. As companies you need to ensure that you write good agreements, get it done such that your rights are secure, right. Your employees need to have confidentiality clauses, IP clauses, non-compete clauses. Okay. That means they can't go and set up another company doing the same thing, right. Clearly investors would hate it if you did not do all of those. So in fact investors, when they are doing due diligence, one of the thing is they ask for contracts of every employee who is senior employee, okay, key employees. They want, even if you are a founder, you have to have a contract with the company which assigns rights to the company. Okay. There might be co-development agreements you sign up with different people. How are the IP rights decided there? There might be IP sale or assignment rights, you are getting ownership rights. There might be NDAs and confidentiality and kind of agreements which also influence your ownership. And you know, this is another thing which people do, which is sometimes you do not want to file a patent, but you do not want others filing it. So what you do is you do intentional formal disclosures. Okay. So do not be surprised about that. So be careful when you are talking to others that they do not do an intentional disclosure of your stuff to mess around with you. Okay. So there are big companies who decide that certain IP they are going to file, certain others they are going to put it out in the open so that nobody else gets to file IP on it. Okay. So this is by the way, or you encourage somebody to write a paper publication, that is another formal disclosure, right. It is a good way to do that if you think that you want to do it. Okay. Exploitation rights, they are often defined by things like licensing agreements, option agreements, right. your material transfer agreements can have certain constraints on how you exploit and don't exploit. If you are, for example, today getting a CRISPR cassette, okay, to do some work, there are restrictions on what you can do with it. Okay. CRISPR is the gene editing tool that is in the news these days, right? In fact, today's newspaper, somebody has, Chinese guy has claimed that he has done it on a human baby. I don't know if you saw that. It's big news right now. Of course, raising a lot of ethical questions. Okay, so if that, right? So if that CRISPR kind of cassette, if you want to buy it today, you can't commercially exploit it if you're licensing it on a academic basis. Okay, partnership agreements, in licensing agreements, for example, and even open source agreements put constraints on you, right? So if you use an open source software to build something, your thing also has to be open source. Okay, so you automatically agreed to open sourcing that. Okay, so please understand that these are things which
not every particularly. So Apache license would
yeah
enable us to do that.
yeah.
Okay.
So there are different formats, there are different types of agreements under open source. Okay, and you have to read the agreements carefully, but keep this in mind that a generic understanding of open source is that you will have to build, whatever you build on it will most likely be open source. Okay. Okay. Key questions which startups ask: should I file IP or keep it a trade secret? Okay. Ask the question, is IP important to your industry? Depends on your time cycles, cost, R&D, how much time it takes, right? I think I have something here. For example, drug development process, right? It's long, expensive, you know how long it takes, you know the success probability changes a lot as you go along the timeline. In this kind of an industry, you're silly if you don't file IP, right? But if this was shrunk to an IT industry where everything happened in this time frame, right, you need to really think what you're achieving by filing, right? Because all it's about speed and getting there first and fast, right? So how do you really make the most of it is an important question, right? How important is it for you to talk freely with investors, partners to gain their support? If you have a very committed investor who just believes you and is willing to support you, it's fine. But if you have to go and pitch everywhere to raise money, right, are you better off filing? Perhaps. Okay. When should you file is another question. Okay. There are different views on this. Okay. My view is that for most people who are going to raise money, who don't have internal resources, okay, who are going to go and talk about it and pitch everywhere, right, as soon as the scope of the invention is clear, you should file. Okay. This is my take on it. Okay. But there might be differences of views. The reason is that for you, you have to talk and raise money. You don't have a choice. Very often you are dealing with domains where there are large players involved, right? You will get attention only if you have something at least which you have protected, right? You can't afford to wait. So many of us in the startup mode and many of us in academic institutions, research institutions, this is the only way to go. Okay? If you have a dedicated source of funds like a large corporate, right, you can be a little more strategic on deciding when you want to file, okay, coming there later and so on after you have got all the things sorted out. But you have to be clear that after you file, within 12 months you have to create enough data to at least do a complete filing. Okay. But that said, it's a very tricky question, but you have to sometimes raise there if you are in a cutting edge area. Okay. The thing gets patched up so quickly in terms of all the different people filing inventions anywhere in the world. So patent file anywhere in the world can be prior art for your patent, right? So anybody filing anywhere might mean that your patent won't go through. In not so competitive fields, you can wait. Okay. Sometimes people wait in a strategic sense to extend the lifetime of their patents. They'll do one, the next one will come after a few years and so on. observe, but you have to think what risks you can take depending upon. Sometimes you have to do filings with the government and so on. I would be very careful if I was filing anything in anything which could get leaked. This, so you have to worry about that as well. Okay. A common misunderstanding is people think that filing patents is very expensive. Okay. If you are writing it and filing it yourself, it's actually not expensive. Okay. The government costs in India is nothing really, the government filing fee. So, but if you are hiring an attorney firm, yes, you have to plan for those costs as well. But if you are an inventor and willing to do that, the resources should not be a barrier for you going and filing. Okay. Many garage inventors in the US file patents on their own. Okay. It is not that it is not heard of. So, one must think through, people get disheartened looking at the bills from say, or a quotation from an attorney firm. Actually, if you are the technical and the inventor, and if you can learn a little bit on your own, you should be able to do it. It may not be the best, but still it's okay. Also, another important strategy is to stage your costs, okay, rather than trying to do everything in one shot, right. Very often somebody comes with a patent filing decision, they start thinking, oh, isme 5 lakh lagega, because they are thinking of next 5 years cost. Why? Why don't you think of the next 1 year cost, and if it does not pan out, drop it, no, right. So, stage your costs. So, we tell many of our startups to think in staging, okay. Think of staging costs and raising money as you go along, okay, and with a positive frame of mind that you will be able to raise money. Okay, not necessarily thinking in a negative sense that, oh, this means this and therefore you are paralyzed and do not start at all. If you do not file, you may not be able to even talk to investors, and it's like a vicious circle, you'll get sucked into it and you'll head nowhere. Okay. So usually this is the typical sequence: month 0 provisional filing, month 12 complete specifications and PCT filings, and month 30. This is a formula in the sense which works fairly well for many people. Okay. So you can consider this approach, right. Okay. There is a lot about portfolio planning. You can have different types of IP, you can have different coverage in terms of scope, you can have different regional coverage, you can have strategic and tactical purposes. I will show you one of those. You can be doing it for defense against a competition. Okay. You could also be attacking the competition in a way, or getting attention from a strategic partner, okay, with your filings, right. So, we will go through this as a simple exercise, right. Okay. So, let us take a case where we are talking about a company, right, which has, this is the scope of know-how. I am just showing you graphically. Okay. So, they have many parts to their technology which is in this cylinder out here. Okay. You can see that they are building on a base which is primarily a lot of free prior art. What does free prior art mean? Stuff which is more than 20 years old, stuff which is not protected, stuff which is outside of valid patents, that means those which are currently valid, right, and in your country, right. If it is filed in the US and not filed in India, you can still practice it, you can copy it, there is nothing wrong in that. Okay. So, much of it that this person is building upon is this. Ignore this for a moment. Okay. He decides that, look, on this there is a pocket here where I can file a patent, the patent 1 out there. Another pocket here, he files another patent which is patent 2. Then he decides that this part is a process step which, unless somebody comes and works in my lab, in my office, my manufacturing facility, he is not going to figure it out, and it may not be patentable. Okay. So, he says, let me not disclose it at all, I will keep it as a trade secret. Okay. And then one other thing which he decides, that this is something which I do not want to file a patent, but I do not want anybody else filing a patent, so I disclose it. So, I write a nice paper and I say, here is all my results, right. I put it out in the public domain, right. So, he has created a portfolio of 2 patents, a trade secret, okay, and there is a disclosure, public disclosure, right. So, imagine this is what his portfolio is. He could have also done a design, he could have also done a trademark, whatever, but as of now that is the situation, right. So, consider that scenario. Now, we will build on this to try and understand what happens, right. So, you understand the concept of building a portfolio, right. Okay. So, this is what I told you, he has planned a portfolio around this. Everybody is with me? Okay. Now, let me take a next situation. You find out, right, that there is another chap who has a patent here, okay. He has covered a different area, you just happen to be using some part of that know-how here. You did not realize that it was so, right. So, you do not have freedom to operate because this guy can sue you, right, because it is a negative right. A patent is a right to exclude others, right. So, he comes after you, so you are worried about it, you want to have freedom to operate, right. So, what do you do in these circumstances? Yeah. So, one option is you go to this chap and say I want to license it, okay. This guy says I am not interested. What do you do? He happens to be a bitter enemy, bitter competitor, right. So, you have to now figure out a way to do that. One option is you decide this part of the know-how you are not going to practice, you create another piece of know-how somewhere here which does the same job, is not it, okay. So, you will have to work out the space where you can work without this guy. So, you have to understand a couple of things out here as well. This idea, very simple idea, that there is some base IP and yours, you cannot necessarily practice this if you know that is covered, right, if somebody is covered, but it can also have multi-level dependencies, okay. So, here take an example, there is a chemical process which uses a catalyst. Somebody developed a batch process using that catalyst, there is a catalyst first of all, a given catalyst, then there is a process built on top of that using this catalyst, right, and then somebody comes up with a continuous process, that means it is not a batch process, a continuous process using the same catalyst, okay. Now, this has expired, let us say, or this has somebody has dropped it, abandoned it, right. This guy says, oh, I can copy it, right, but this is still valid. So, he has to still get rights from this chap, understood, to practice it, because the catalyst patent is still valid and protected. Okay, let us move on. So, here is another situation, okay. So, I will come, we just take that same graph, we had that previous one, we did not have, this is the new one that I have added, okay. Now, here is a competitor who wants to kill your business. So, what he does, he comes and files a patent here, right. So, he is essentially covering this space out here, and he says, look, either he puts exorbitant terms, so you are not able to practice, or he files something which is blocking you. So, you could have, if you were proactive, you could have filed something here in advance, but you decided not to. So, that is a cost of it. So, this would be an offensive filing, okay, an example of an offensive filing. Here is a tactical filing, okay. So, now this chap who was doing this is having a patent which, say, he built something on top of it, and these are his patents, let us say these ones, okay. Now, you want to get him to the table, right. So, what do? You file something which blocks his activities, right. You have a patent which you have filed which blocks him, and therefore, now he has a reason to come to you to talk, okay. So, this is where what happens, what they call cross licensing happens, okay. So, two parties decide I will give you this, you give me this, and both of us will be happy, but we will keep the third guy out. Okay. So, I am just giving you these illustrations. I mean, it is a simple block illustrations to just understand that this is how the game is played. Okay. So, it is important that you be savvy about it rather than just be innocent as far as this is concerned. Okay. Okay. Let us move on. So, I have talked about portfolio planning. I should come to a close now. So, if you are building a portfolio, right, try to define various technology components, see what you can file. There might be different things, you can look at composition, structure, processes, different steps that you are looking at. It could be even design of a machine to make that happen, okay, to make that implant. If also see if there are any barriers relating to things like raw materials, for example. Okay. Sometimes your access to sourcing, your sourcing might be blocked, your access to raw materials may be blocked. So, you may need to worry about how you get access to some of those things as well. And sometimes there are barriers to end markets and applications. So, you need to think through that as well when you are considering how you are filing your patents. Finally, let me just quickly close with this, which is, I think this is the probably last few things. So, if you are developing some of these things ahead, commercial development of some of these this IP, there are a few simple rules to follow. Okay. One is, it is always better that you have clear and predictable decision making as far as what you will do with the IP. Okay. So, what does that mean? That means that whatever, if your ownership is clear, right, and it is not fragmented, chances of it succeeding in terms of taking it ahead through a decision process is a little better. So, we have cases where suppose there is joint ownership between 2-3 parties and the parties do not agree that it is a good deal, bad deal, and so on and so forth, you have a problem, right. So, if you are considering entering into joint collaborations and there is splitting of IP rights, especially ownership, please think through that a little bit more in terms of, is it a good idea. Okay. Well, the fact is that one other problem we have is that some places the decision making is too slow or it is multi-layered. Okay. This is one of the reasons why for startups investors often do not like the IP owned by an academic or a research organization. Okay. They would tell you that please try and get them out first, right. They would prefer if the IP and is owned cleanly by the company before they come in for investments. They know that there is a lot of unpredictabilities and risks which add up when such ownership is there. So, this is something which we have learnt in many different situations. This is true, and even in the US it is true, not only in the Indian context. So, be careful in defining and limit the scope of partnerships. So, if you are a startup, your core IP, try to keep it with the company, right. Applications IP, if you need to collaborate, that is fine. Okay. Consider looking at limiting the scope of what IP is done in collaboration mode with the other organizations and other companies as well. Okay. Please remember that if you have a joint IP with some party and you have an agreement which says that either of you can't act independently, okay, then if there is an opportunity for you to sell your IP to another party, the other owner can just decide not to because they have other interests, right, and you will go nowhere. So, any such joint ownership of IP with corporates, you have to be careful that there is a good chance that unless they themselves buy it out, you are going nowhere. Okay. So, in such cases it might be better to just sell it right away in the beginning and not have to do anything with it, and rather than hold on to IP with a larger corporate as a joint owner. Okay. There are different types of agreements that you will have to do, like licensing, sale, all of these, which you can which you learn along the way as we go ahead. Okay. So there's an interesting book, I want to just close with this, which has just which came up last year. It's called Camels, Tigers and Unicorns, and they talk about how technology progresses in such, especially in science based startups. The reason I bring this up is as inventors we often overvalue the inventive contribution, okay, the creative aspect, the initial thing, effort that is put in. But many startups actually have to put in a lot of slog work and work after that to take it to the market, and very often the value accrues at the later stage. So one barrier to come maybe we are going to use only this side, so you can choose maybe one of those seats. Yeah, come here, you can come here. So one of the things which you have to keep in mind is that you should have a reasonable expectation as an early stage startup or as an inventor regarding, say, sale of technology. Okay, don't think that it is everything. A very common mistake is that the early stage inventors think that that they are the sun and the moon, right, and therefore the deals fall through. Okay. So in this there is an interesting graph which talks about different chasms at different levels. Okay. So it talks about 3 chasms where this interesting thing about this book is it is based on real data. It is not just business school professor putting sketches. This is real data. So they have taken some 6,000 companies, early stage startups, and done some analysis with that data. So this on the if you look at customer growth and where people stumble, okay, most of the startups which are at early stage proof of concept, pre-proof of concept, prototype stage and so on are still here, in somewhere here in this region. Much of the value creation happens here. Okay. So the art for many startups is actually to get to this point here where you are participating in this value creation, right. So many of us in incubators and so on are all trying to get to this point out here. Once action begins here is when the real value creation happens. So when you think of that, your role even before, say, a startup creation as a person creating IP is even in the earlier part out here, right. So your expectations regarding what can accrue to an early stage entrepreneur or an inventor should be reasonable, okay, and that is a showstopper very often. So if you are dealing with large corporates who are interested in buying your technology, or you want to raise money or sell your company, please remember that these are important things which can be showstoppers at some point. Okay, so I'll stop here, right. Final couple of questions and we'll go for tea. Any questions? No? We can tea? Yeah.
So I just had a question regarding the open source.
Yeah.
Okay, I'm coming from the electronics IT background, so I'm
Yeah.
not able to talk about
Yeah, go ahead.
safety and all those
Tell
things.
me. Yeah, I'll
But
try
when
whatever.
doing software, open source software,
Yeah.
of course they disclose while using the open source software, they disclose the agreement that it's an open source. We maintain the declaration and we can use it. We are free to use it as it is, and also for commercial purposes.
Yeah.
Anything developed using that open source can be owned by the developer. Say, for example, me.
As he was saying, that depends on the type of agreement which you sign up to. So there are different types of agreements available.
Yeah, yeah.
And which you GNU and so on, which you'll find online. Yeah, go ahead. Yeah.
So the question is, yeah, that's what I wanted to ask. Some do not have any kind of commercial, even the word itself, commercial usage or commercial purposes, but some do have. So then what happens?
So see,
Is it
the simplest version of the open source is that whatever they have given you the source code, right?
yeah,
Whatever you build, you also have to keep it open source.
yeah,
On top of that.
yeah,
Okay, that's the simplest version of an open source
Yeah.
software, right. Now that's it's a little different philosophy, and it works very well for certain things where you're actually working on a platform which enables a lot of other people to build on it. Okay, so that kind of a model works very well, but you can't very often build a company on top of it which is building proprietary software, okay, and raise money for it unless you have certain elements which you can bring in which can be proprietary. So for example, Red Hat, okay, has recently has been bought, right? Who has bought it? I'm forgetting. IBM. No. IBM, right? Yeah. So Red Hat built on Linux, right? But the what they have kept out a niche which includes setting up things on top of a Linux platform, which is what I think IBM is interested in. Okay, so that has value, but if they were only focused on building that platform further, that they would not have been able to find a taker or a thing. It will continue as an open source activity.
It's very simple for that matter. As you said, that there are licenses out there, there are open comparisons out there. So the most favorable license for a commercial enterprise would be Apache 2.0, which is very widely used, and then you can keep you can build application on top of it and keep your your software proprietary. But then there are the GNU other one, which is deemed you have to make it public, and then there are other which are hybrid, that is CC0, CC1, CC2.
I just wanted to get clarified.
Yeah,
so using the open source, that there are always a risk factor.
So it is very conscious decision what platform you're using and what is your intention. It is very important. So people built entire stack on something which was a GNU license, and then realized that they have to rework all again.
Yeah. One other thing to keep in mind. So sometimes people make a virtue out of it. Okay, be careful about that also. Okay. So for example, some years back, Tesla announced that it's open sourcing all its battery patents. Okay. So my question at that point was, why did they not abandon those patents? Why did they open source it? Okay. Can you think of why? See, they are in the electric vehicle business. Okay. Whoever does well in battery, they will make money. Right? Now, if they open source it and anybody uses any of that, if you assume for a moment that they also have to open source it, right, they have nothing to lose, right? So it's actually a very smart move, right? It came in the news as if he is a pioneer who is sort of doing good for the world.
It was a strategy in terms of there was no battery supply, and they would get more
Basic,
battery supply.
yeah, see, it is very clear that the batteries are the key to the future right now, right? Anybody who has a breakthrough is going to make it. So if you were a battery developer, right, you would stay clear of some of those patents, at least until you have clarity, because if he is willing to give you a free license, fine, or abandon it, even better. Why would you open source it? Okay, so you have to think through that a little in terms of how what they have in mind when they are doing any of these things.
I think this example falls. That's where you stated intentional release it intentional public
Well,
domain or something like
yes, no, but see, suppose he had put, so another kind of intentional public disclosure is what IBM does. Okay, so what they do is they file a lot of patents. They also have a domain where they put everything public, okay, which they don't want to file, right? Maybe you'll talk about it a little bit as well, but yeah, so they just put it out there so that nobody else can file. And that is different from open source, because open source also has an agreement that goes with it, which says that you are agreeing to make your things open source, right, which you may or may not want to, right? So think through that. Okay, I think, yeah, question.
How is this know-how defined, sir?
Know-how.
Yeah, how to define the know-how actually for practicing the invention, if it's a patent?
So we will be talking a little bit about it tomorrow, but see, when I am talking about know-how, I am just saying that anything that makes your technology work, including different components, I am calling it as a bunch of know-how, right. Now, out of them you can, the boundaries of it, right. Suppose you are making a car, there might be thousands of pieces of know-how, making small parts to a design, to an engine, to everything put together, right. If the other extreme that I give people is, you know, when your mother makes very good idli, you know, she has know-how, you know, she knows how exactly to do that, and by the way there is science in it, it is microbiology, right. But the point is that that is whatever makes your technology work, right, is the scope of your know-how. You put all of them together, if you can construct a set of boxes saying that this is one part of the know-how, this is another, then you start analyzing for each of those boxes what IP you can create around it, okay, or what rights you have for those, right. Okay. So, anyway, we will come to that. I think Dr. MGK will be talking about that tomorrow in track 1. You can see if you cover some of it. Last question. Yeah.
Go and talk about the scope of your invention. In that case, if you are going to disclose about your invention, how are you going to later file your patent on that?
No, I think I said that file your patent the moment you know that you understand the scope of your invention. Okay. So, if I have an invention and I understand broadly the boundaries of it, okay, it is a good time to file for most people first, then you go and talk about it. You do not talk about it before, but you, yeah, when I say scope, think of it like this, there is a farm, right. The first experiment you did was a small patch of say 10 by 10 meters where you grew something or you did some pest protection, but then you understood that there is a whole boundary that you could have covered. Because of that, you understood the scope, the whole boundary, right. That scope is clear to you, it might be a good idea to cover in a provisional. So, for a provisional, your scope you should cover, not details. In Indian provisional, all details are not needed, okay. So, you at least need to get the scope right, okay. So, we will break here for tea. Yeah, those who are there signed up the entire 4 days, Nikita will be issuing those booklets, but first start with tea. In the meantime, you can come back. Okay, okay. Thanks. Let's.
I did notice that the group is pretty quiet. I mean, if you really want to get something out of this, I would really encourage you to speak up and ask questions, because that's the best way both you and me will get something substantial out of the talk. Because I'll just whiz through the slides and I'll be done in about 45 minutes, but I don't think that's the ideology behind this exercise. So my name is Jaya, and I'm an IP consultant. I've been to NCL many times, and I've been fortunate to come back here another time. So these were the topics that I was asked to cover. So the 4 topics are knowledge mapping, technology gaps, FTO, and licensing. And what I'll do is I'll start off with giving some background for these, for every topic, so that you'll be able to relate to what you have heard in the morning, because Premnath gave an overview of what you're going to hear during the course of the day. So these are some of the topics that I'm going to cover, and this will be in context of what was covered in the first session. So yeah, just I've got too many things. Thank you. What I'll do is I'll use the lower part of the board to fill up what you'll be hearing today in my talk, and how they cover the picture, something similar to the graphic that Premnath presented earlier in the day. So if you just look at this as a blank sheet, you know, your blank sheet is your technology, right? There's a lot of technology, all kinds of subjects. So any startup or any entrepreneur or any inventor is first going to start off his journey in the subject area of his interest. Yes? So when we start off with a broad base, what we are trying to do is to identify the knowledge that you have and the people around you have whom you are going to work with. So the first thing first is map the knowledge. Now, while this is done to an exhaustive extent in corporates where I have primarily worked, I want to scale it down to more like an individual or a startup level where the number of people are much fewer. So in most corporates, you tend to have knowledge management systems. You have expert locators where people from the entire company put down their expertise, their background, their qualifications, the kind of role that they do. And these kinds of systems tend to be searchable, where any new inventor or previously existing inventor in the company as well wants to look up people to figure out whom he can have a meaningful conversation about a certain topic that they are working on. Now, if you scale it down to a startup where typically fewer number of people are there and the manpower resource is also limited, if you look into the ecosystem outside of your residence or outside of your incubator or startup, you do have the advantage of leveraging other resources. But if you're only going to look in-house, the first thing you'll start off with is, of course, yourself. And hopefully we all know what we all know. So once you start mapping out what is it that you are trying to work on, it's always good to take it one level up and see what are all the different subjects that you first are aware of and have a reasonable expertise in. The reason why I'm saying this is, once you map out all the knowledge that you, your co-PIs, or the other employees in either the startup or the incubator or this resource support that you have, once you start mapping it out, a picture starts to emerge, which gives you an idea of whom and how much you can reach out to or work in as you are preparing or chartering your journey of becoming an entrepreneur. So I picked a few things off. Much of this is open software or openware that I picked it up from, because I didn't want to start talking about how it's done in corporates. I don't think that's going to be very helpful in this setting. So first, identify the knowledge areas. So you will have, one. It's just a random graph that I'm going to draw. Okay, so first identify the knowledge areas. First of all, ask everybody in the ecosystem the right questions. First of all, start with yourself. List out what are your areas of interest, what are the areas that you have reasonable expertise in, and what are the areas that you are planning, or the technology spaces in which you are planning to invent. Okay, so having that background is going to help you take it to the next level, which is drafting the knowledge map. Typically in corporates, what we do is we ask the managers or the directors, or it starts at the vice president level where you ask, okay, give me a knowledge map of who are all the guys working with you, the technical guys working with you, and what is their expertise. They roll it down to the directors, the managers, and this is usually the job of the managers to collect the qualifications, experience, and areas of expertise from the individual contributors, which gets rolled up all the way up to the company level. So that's how it works. But if you're scaling it down to a startup or a limited enterprise with fewer number of people, you would have to go and ask every one of them yourself, because if you're the one who is the CTO or the one who is leading this organization, you better have a good idea of what people know. And you sometimes will be surprised with the answers you get. You think that you know the people you work with very well, you'll be surprised. Because I've heard very surprising answers when I sat down with my team and asked, okay, so what is your expertise? And things just came out that I had no idea, because people do a lot of things outside of their job description. So once you draft the knowledge map, you have to start evaluating the risks and identify opportunities. Now every risk is an opportunity in hiding. That's the best way to look at it. The risk in the sense that you have an idea of creating something, and the biggest risk is you don't have adequate either resources or knowledge base. So that is the greatest risk that you can run. So which in turn becomes the opportunity, because that is where you start leveraging the ecosystem outside of your core group. You start talking to places like NCL or other resources that the government or funding agency or an investor might be able to provide. And then you start acting on the map. So that is where something like this starts coming up. You'll have knowledge. Now each box is not an individual. It's a knowledge base. It's a technology space. So there'll be one person who will be an expert in 1, 2, 3 areas, another one who just has one course, someone who is completely remote. The easiest example I can think of is a financial person. You're always focusing on technology all the time. You completely forget that your dollar figure, the numbers really need to add up. Otherwise, you're not going very far. The first thing first, you'll get hit with an audit. So make sure that every expertise that you need is there. And the expertise that you need is not just technology, it's more than that. There's technology, there's infrastructure, there's IT, there's finance, there's databases, there are login IDs, passwords for scientific information, non-scientific information. There are 20 different things that you need. Please do not underestimate the resources that you need. Okay, so for corporates, especially if you have worked for corporates and have come out, you know what you would need. Because all this is developed in-house for corporates, because hundreds of years ago or decades or years, or an established establishment always they have already done this and they have systems in place. But if you are starting off on your own and have not worked in-house, this is where I would encourage you to start talking to people. Your best bet is somebody who has worked with corporate, because they'll give you the best idea of what are all the different ecosystems that you would need. The reason why I'm saying that is halfway down the line, when you're busy with your work and your technology, if you're going to go back to the drawing board and start looking for a finance person or a chartered accountant or a login ID password for some database that you would need, you might be a little late. You would have to undo a lot of work, and I have seen this happening. People get passionate about their technology. Oh, I'm going to invent this, I'm going to start up this company, and the one big thing that they forget is the finance. It also leads to identifying knowledge gaps. So this is the knowledge gap. You have to first put down the identity. The next one is, I picked this up from, I really like this slide, so I picked it up from somebody's slide share. So what knowledge is needed? Who has it? Who needs it? Where is it? Is it tacit or explicit? Is it routine, non-routine? What issues does it address? And the different kinds of expertise that you would need. Now this would typically look different for every startup, but you would know about your domain much better than I can even hazard a guess on. So you can use something like this as a template. Keep it simple, start simple. When you're starting off, keep it simple. You don't need $20,000 databases with all the bells and whistles. When you're 5, 6, 2, 3, 10 people working together, you don't need anything more than this. So please cut your costs and use something simple. So first carry out the knowledge overview, evaluate the valuable knowledge and benchmark it. Somebody might have knowledge, but that doesn't mean that it's enough. The knowledge needs will be revealed once you start filling up your Excel, And then that's when you start your knowledge management activities. That's when you start acquiring expertise. Now, acquiring expertise doesn't necessarily mean that you need to hire. You can collaborate with other people. Incubation center is a great place where you can acquire expertise without really paying for it. But you need to have your agreements in place. You're not going very far if you do not have the right agreements in place. In a startup atmosphere, the key to your survival are good agreements. If you mess up your agreements, you're not going anywhere. Your startup is not going to start off, putting it very bluntly. Any questions?
Elaborate a little on what was your first columns, like in the matrix? How do you go about what is system analysis? What do you mean by database design?
This is an IT example where this is from an IT startup where they were looking at different programs actually. They were trying to code something for an industrial application, and that's why they were looking at different architecture.
Different know-hows, and then you
Map
have
it
these
out.
columns for each know-how that
Yes. So this can be depending upon what your technology is. This is an IT startup where they would, I actually picked it up from SlideShare, and I saw the reference for this in an IT paper that I had once read. So that's why I went back to this, because they had filled it out and there was some IT architecture that they wanted to do for some industrial application. But I like this slide because it keeps it simple, and it is very basic, but it's very effective. So if you are a small startup with just a few people, this is the right place to start. Because the bigger you get, the more you will have commercial databases that are available, HR management systems and all. Much of this is maintained by HR in a commercial enterprise. But in a small scale enterprise, I think the CTO is the HR in most cases. All right, so once you know what your knowledge base is, there's a technology space in which you're working. Now you know how much expertise exists in your startup in that technology. So the next step to do is to identify the technology gaps, because everything is a blue ocean, right? So you cannot obviously invent in a blue ocean. What is it that you're going to invent? Or if you already have an idea, how do you take it one level up to see whether somebody else has done something in that area, or somebody else has intellectual property already that exists in that space? So the first thing to do is to first know the technology landscape. You might have an idea, but it is great if it's a unique idea, but the likelihood of that happening is pretty low, because every technology, a breakthrough novel technology, probably comes once every 20 years. It's fastening up a little bit these days with a lot of people on the entrepreneurship startup mode. But even then, somebody coming with a breakthrough idea that's going to revolutionize the technology landscape is still a needle in a haystack. So it takes time, and if you have an idea, please don't start with the assumption that nobody else has thought of it. Especially when you do patent prosecution is when you'll see the kind of prior art that is cited against you. I've heard of cases where Disney cartoons were cited against somebody because Disney cartoons always have fantastic innovative ideas, and those were actually cited against patent claims, saying that, okay, you're not the first one to think about it. Apparently, Tom and Jerry thought about it before you did. Now, while that's not a usual case that happens, the point I'm trying to get across is that you may not be the first person who's thought about it. So the first thing to do is to evaluate the technology landscape. Right. So I think you'll hear more about this in the afternoon session, but just for the sake of completeness, I started it because I would be talking about these steps. So I wanted you to know these steps. You will hear more about this in the afternoon sessions. So where did I? Okay, good. It writes. Okay, to identify the knowledge gaps, we first need to know the technology landscape. So how do you know the technology landscape? You first design a nice search strategy. You put down all the concepts that you can possibly think of in your area of expertise, the area in which you are planning to put up your startup, or you have already initiated it. It's fine. You don't absolutely need to do this right before you even think of an idea. You have an idea, you can still go through this. You have started your startup, still fine, you can still do this. But at any point in time before you commercialize, please do this, because you'll be surprised with what you can find. So first, come up with a search strategy, then do the patent extraction. When you are actually constructing a technology landscape, I normally advise people not to restrict it to just the patents, because publications also have a lot of information that you can get, and non-patent information is as critical as patent information when it comes to understanding what the knowledge base or what the person having ordinary skill in the art, so to speak, has. But since I'm going to cover FTO next, I'm focusing on patent extraction. So use multiple databases. No database is comprehensive. Every database has flaws. And electronic databases probably cover 70 to 80%, so no search is ever comprehensive. Please don't ever go to any analyst asking, have you covered all the bases? It is simply not possible. Okay. There's a lot of information that is not in electronic form. There are a lot of non-English languages, information in non-English language which cannot be searched by using an English interface. And there are a lot of databases in countries which are not hooked up to the rest of the scientific information database, especially some of the former Iron Curtain countries. So no search is ever comprehensive. Your best bet is to get the best search that you can get. Screen for what you want. I mean, you're a better expert at this. Analyze, figure out what you think you're looking for. You know, some of these approaches have been discussed in the morning. You know, problem solution approach, you know, which technology has what applications, and optional literature analysis. You know, if you're anyway going to file for a patent and you are going to launch your product, you know, for FTO you really don't need this. And this is where the interpretations start. You know, who are all the people that you need to go after?
Excuse me, ma'am. Can you please give one example for the how to identify technology gaps?
I'm coming to that. So why do you need a technology gap analysis? You know, many reasons, but the top reasons are, obviously you want to create differentiated products. If you are going to launch the same product that somebody else already has, so what's wrong with that if you launch a product that somebody else already has? If it's a non-differentiated product, what do you think can possibly happen? I'm sorry?
Success is unlikely. Or maybe chances of litigation.
That's what I was looking for. Chances of litigation, because if it's an undifferentiated product, somebody else already has an existing product, they are likely to have intellectual property on it, which you are likely to infringe, so you get slammed with a lawsuit. Identify market needs to launch new products. This is nice, but I know a lot of business schools and leadership, they keep harping on, market needs, market. Well, at least in my limited experience, I've seen that it's not market need. It's what your customer wants. So if you're going to start surveying the market, well, you'll survey for the rest of your life, because you never know what somebody wants, because no second person is going to say that they want the same thing. If you give them an idea, would you like this? Then the answer is usually yes, I would love that. And 10 people will tell you that. So I always say, identify market needs with a twist. Have your list of solutions and then ask for a survey, and here are some of the ideas. What do you think? Do you think this will solve some of the issues that you have? And if you're going to talk to customers, ask for their problems. You'll be surprised about some of the things that you hear, and you may be able to design some solutions for them. And this, licensing and enforcement of patents, this is for both. If you want to license somebody's patents, which is licensing in, or you have built a portfolio and you want to license out. So the idea of doing a competitive gap or a technology gap analysis is to create the competitive differentiation between them and us. And it helps, recognize new business opportunities, you identify promising new technologies.
So you just said when you are discussing about the market needs, I do agree with your opinion and experience that the market needs may be different with the customer needs, but that kind of study may be able to help. The point number one is to create a differentiated product. What do you think on that?
I agree, but you have to work with a problem or a solution in mind first. Because if you're just going to start talking to customers about what you need, every person is going to give you a different answer.
No, I know, but when we are into the field, having certain idea or
That-
product launch in mind,
Yes.
then
Your first hurdle is already crossed, because if you start identifying market needs with a solution that you already have in mind, it makes your job easier, because you can come up with the differentiated product much faster, as opposed to people randomly asking what is a problem that I can solve. Because I have come across a lot of people who ask those questions, and typically they are either in college or fresh out of college. Now, if you ask me, for me, my microwave isn't working, and that's a problem for me. So what is it that you want? If you ask me what is the problem that you want me to solve, it entirely depends upon what's happening in my mind on that day at that time, and it can be nothing to do with what you are offering or what you're thinking about. So be very specific when you ask what problem you have. So that's the only point that I was trying to get across. So I think these are obviously fallouts of any analytics that you would do. So I think this, Archana, I think this is what you were asking, right? So this is taking an example. I just took a random example that I once worked upon, which is switchgears. Don't ask me about switchgears. I don't know too much about it, but I had drawn a technology map once. So this is what, a technology map would look like. It starts somewhere. It will start somewhere, right? Unless we're talking about very commonly known products which have been there for centuries and centuries. most technologies that we work on, they start somewhere over the last 2 or 3 decades or even 4 or 5 decades. And then they will, each one of them will form and follow their own paths. Trying to make sense of this takes some time, and each one of this is, patent family. It's just easier to club it by patent families rather than individual families. Most of the databases give you these options. So this has been pulled out of a database. So you can make some interpretations from this, these are some, by the way, some random interpretations which are not technical, but it's more for an illustration purpose. That okay, there are some companies which are, which started somewhere, but those are not the guys who are now doing. So what happened? So this gives you an idea as to what happened, who are the players, what happened in the technology, what form did it go through, and what are the different alternatives to that technology that have emerged over the years. So here this red line was the primary technology and the others were similars. So you might have a solution in mind, but that doesn't mean that there are no other solutions which can do about the same thing. So this is a country analysis which tells you which countries are most active. So this is useful for preparing your patent filing strategy. Which countries do you want to enter? Now this is an interesting graph, and this is usually one of my favorite graphs, which tells you how the patent filing by which company has progressed through which years. Now you'll see that almost every technology that ever existed goes through this graph. There will be filings, the filings will go up, they will come down, and then they'll go up again. It's always a two-peak curve, always. For any technology, if you look at the progression of technology from conception to where you are, it will always have two peaks. There have been a lot of interesting management theories around that, but the fact of the matter is you have to figure out where the peak is, and that gives you an idea of where your technology possibly stands at this point in time. Is it in the first peak, or has the peak already happened? Or if it's after the second peak, it usually means it's a mature technology. So might as well give it a rest and go fish somewhere else. There is some other exemplary analysis. It's just for illustration. I've pulled up some that I've worked on over the years. It usually gives you a lot of different information about a lot of different things that will help you figure out what your technology landscape looks like. And this is where you start, finding out about the gaps in the technology which make more sense. So you've got all this expertise, and then you figure out that, oh, there are some gaps over here, gaps over here, gaps over here, a big gap over here that I can work on. So once you start preparing this graph, you'll start realizing what are the intersection points, or you can use this as a Venn diagram too. So you'll see that some of these fall within the core expertise that lies in your group or in your team, and there are certain things that lie outside. So now you know where you want to start focusing on building your solution. The expertise that lies in-house and the technology gap that exists, that you have identified in the market. So this is the other one that I wanted to talk about, that in any invention life cycle, we all know about the technology S-curve, yes? Anybody who doesn't know the technology S-curve? So this is what the curve that every single technology takes up. That there'll be an initiation, then the takeoff point, which is where the return on income starts, and then it plateaus out before declining, and then a new technology will start off. and there will always be an overlap between the previous S curve to the new S curve. And number of inventions, this is what I was talking about, a double peak. It's always a double peak. You know, the invention will take off, then there'll be a peak, then it'll plateau out, and then there'll be another sharp peak, which means that that is when the market has responded. And this is where the most money starts coming in. And this is the complexity of invention. You know, when any technology field, when you first start off, tends to be pretty complex because it's new, right? So nobody knows anything much about it. So it's complex, then people start figuring it out, then it hits a trough. And then you do more research, you know, bigger, better solutions start coming in before it starts fading out and, you know, something else starts taking off. And this is probably where most of you would like to be, yes? This is where inventions become most profitable, and this is also where the IPRs peak. Because now the technology is making a lot of money, there are a lot of solutions in the market, and there are a lot of players who have intellectual property on those solutions. So this is where, yes, the money is peak, but so are the risks. So we've talked a lot about, you know, there's know-how, there are technology gaps, you're going to invent something. So let's start with the intellectual property piece. At this point, I'm going to assume that you have a solution in mind, which lies somewhere over here. So that's your solution. Because once you start talking about intellectual property protection, the first thing is you have to have a solution in mind, otherwise you're not going very far. All right, so the main type of intellectual property analysis, you'll hear them, you know, 25 different terms, but they pretty much fall into 3 big buckets. There are other things, but for the sake of legal analysis, I'm just going to stick to these 3. There's patentability, freedom to operate or freedom to practice, and validity. So once we start with a solution, the first thing that you're thinking of is having it protected. So you're looking at patentability of an invention. An invention is patentable if it meets the criteria of NUN, which has to be novel, it has to have a use, and it should be non-obvious to a person having ordinary skill in the art. The unicorn animal over here is Fossita. So, you know, I'm just quoting 35 USA 101, which is from the United States Patent and Trademark Office. That's what I've known. I'm a US patent agent, so I'm going to follow the US patent law. So what are the inventions patentable? Whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, we tend to call it COM, or any new and useful improvement thereof may obtain a patent, therefore subject to the conditions and requirements of this title. So there are 4 statutory classes in which you can have an invention. It's a process, a machine, a manufacturing process, or a composition of matter, which actually is the strongest claim that you can have, or any new and useful improvement thereof. Now, typically, laws of nature, laws of physics are not patentable. And so, you know, I don't need to tell you this, but just for the sake of completeness, I want to mention that laws of nature, physics, properties, anything that is inherent in a given process or procedure is not patentable. Inherency, again, is not patentable. So This is probably the most important thing that's, even if you don't take anything away from this 1.5 hours, if you just take these 2 lines off, I'll be happy. It is, patent is an exclusive right. It gives you the right to exclude others from making, using, selling, importing, or offering for sale. I didn't put that down. Your invention. It does not give you the right to do anything. It only gives you the right to exclude others from doing it. It's an exclusive right, it's not an inclusive right. Now, the reason why I'm covering patentability is it will be difficult for me to cover freedom to operate if we don't cover patentability first. What is freedom to operate or practice? It's an action like testing or commercializing a product which can be performed without infringing the valid intellectual property rights of others. Yes, no, maybe. Why do we need an FTO when we have a patent? Because a patent is an exclusive right. These are the 2 most common questions I've come across in my career, and that's the reason why I put those down up front. That FTO is, when you perform an action, this is the consequence. If you infringe the intellectual property rights of somebody, that's when you start a litigation. Very simply put together, Newton's 3rd law. Every action has an equal and opposite reaction. You infringe, you'll get sued. Straight and simple. So that's the reason why freedom to operate is that important. And why do we need an FTO when we have a patent? Because a patent is an exclusive right. It does not give you the right to do anything. It only gives you the right to exclude others from doing something that you have already invented and protected. How to do an FTO? Analyze the active granted patents from the last 20 years in your jurisdictions of interest. If you're going to file an Indian patent, there's no point in wasting your time and looking at patents in the United States or Europe or anywhere else. However, if there is a chance of your invention or a component getting exported or getting offered for sale in any of these jurisdictions, you better include those. If your invention is never ever going to leave India, don't look for other jurisdictions. But if it is likely to, then look for the other potential jurisdictions where it can be sold. Focus on the claims, because claims are the only enforceable part of a patent. Only claims can be enforced. The specification is just a technical document. It doesn't do anything for you. But your invention is only protected by the features that appear in the claim. If your claims do not cover your invention adequately, it's just tough luck. So rethink your patent strategy. Make sure that your claims actually cover what you want it to cover. I can't stress that enough. If you put it in the specification, oh, it is there in my patent. Well, not a solution. Is it there in your claims? If it is not, your invention is not covered. And I have seen patents where the actual claims had got nothing to do with the invention. So you're basically wasting your time and your money trying to put together a document and filing it and going through a prosecution process to protect something that is not even your invention. And please don't think that this will never happen to me. It's more common than you would think, especially during the prosecution process. Much of this starts ending up happening. And I don't know about Indian patent law, but at least in the US patent law, there is prosecution history estoppel. So if you disclaim something during the prosecution process, you cannot claim it ever again. It's dedicated to the public. Yes, MG.
When you said you focus on the claims, would you look only for direct infringement or would you also look for DOE? Because that would be
I'm going to come to DOE. I'm going to come to DOE. Actually, 2 slides later, I'm going to come to DOE.
It covers that also.
Yes.
Look at that also.
Yes. And get a legal opinion. And please go to an actual lawyer who will give you a printed legal opinion. Please don't talk to somebody at the water cooler and get an idea out of it. It's more common than you would expect. I can't tell you the number of individual inventors who have come and asked me at a water cooler whether or not they can do something. And if I don't sit down with you or sign an agreement with you that I'm going to give you the legal opinion for this amount of fee, it's not a legal opinion. First of all, I'm not even going to give you one. Okay, so this is where I would say invest your money. If you have money to invest, this is what you should be investing it on. Get a legal opinion. Searching, analysis, everything else, if you want to cut costs, you can either use an incubation center like this or do it on your own. But a legal opinion, please use an attorney.
What are the typical costs that I involve to get a legal opinion?
Depends. It depends upon technology, who you're using. If you're using a big law firm, they'll cost you more.
Yeah, ballpark number?
Depends. It depends upon the technology, the number of claims, the elements of claim, and how much you're asking. Every attorney would have their own cheat sheet. So it depends upon the technology, the number of claims, the number of patents, the elements of claims. And it also depends upon which jurisdiction you're going for. If you're only going for India, your rates will be different. If you're going for 20 different countries, it will be different. Because it entirely depends upon how many patents they have to screen and look at before they give you an opinion that you have a go or a no-go.
So for startups, what will be the startup fee for a legal opinion?
Yeah.
I really have no idea. All right. Here are some examples. A plus B plus C is the prior art. A plus B plus C plus D is your invention. Is your invention patentable? How many say yes? I want hands. You don't even have to talk. Up.
Is it non-obvious?
Is your invention, no, we're not talking about obviousness right now. We're only talking about A plus B plus C plus D. Is it patentable, yes or no? Yes?
Yes.
Anybody who says no? Okay. I'm sorry? Yes. Yes, your invention is patentable. Do you have freedom to operate?
Depends on
Where the person has filed.
I have given it very clearly, A plus B plus C, A plus B plus C plus D. There's no area of ambiguity over here. Then the answer for the second question is a no. You do not have freedom to operate because you cannot have your A plus B plus C plus D if A plus B plus C is not a part of it. So what's the potential solution?
Licensing for A plus B plus C.
Yes.
Claim on the D.
Yes, you license A plus B plus C from the guy who has the prior art, or you come up with an alternative solution. There's no way around it, because if you actually go and start, if you put a patent, no issue. You start marketing it, lawsuit. Before going to the next illustration, I'm going to draw this. Any guesses what this can possibly be? I don't think it's. It's a periodic table. I'm not worried about the rest of the periodic table. I'm only talking about groups 1 and 2. Okay, you have a prior art which says, sodium plus X gives you product A, which is the prior art. Potassium plus X gives you A dash, which is your invention 1. Is your invention patentable? All right, I'll have to go to the fundamentals of a periodic table. Now, group 1 and 2. The reason why they are in the first group is because they are chemically very similar. The properties are almost identical. Yes, high school chemistry? Now answer that question. Is your invention patentable?
One will not, two might.
It will most likely not be patentable because sodium and potassium are very similar chemically. So your product is not going to be very different from the prior art, which comes under the purview of doctrine of equivalence, which means that a solution which is so similar to the prior art, by using just a small change in a critical component which does not perform any differently from what is given in the prior art, still is covered by the prior art. Comes under what is called as doctrine of equivalence, or DOE. That's what MG was talking about. Now, if you look at calcium plus X, which gives you A double dash, it's a possibility that it can be patented, but it's difficult to tell, because while group 1 and group 2, they behave pretty similarly. First of all, your equation will be different. It's not going to be Ca plus X, it's going to be Ca plus X2, 2 plus, yes? And as far as the properties are concerned, they would still fall under similar ballpark because they're not identical, but related. They're still related. But the likelihood of anything with calcium in it behaving differently from something with sodium in it is high. Yes? But it may not be radically different, because somebody who is a person having ordinary skill in the art, a Fosita, will be able to envisage the differences. Now, I'm a chemist. I know that the likelihood of this calcium product being similar to either potassium or sodium, I can predict what the properties and what it can do, because I have ordinary skill in that art. However, if this comes up with a radically different answer, or it offers a solution that I have not thought of, then it becomes patentable. That's where the person having ordinary skill in the art, who is the rare unicorn animal that everybody wants to chase and nobody can find, is a standard that you need to meet. Now, if you ask a chemistry solution to a chemist, yes, they are going to give you the answer that I just did. But if you're going to ask a physicist, the answer is going to be very different. He probably derive an equation out of it. So the point being, if you're talking about a Fosita, it has to be somebody from that art. So if you're looking for an opinion, ask for somebody who has a background in that art. Please don't go and ask somebody else, because they're not going to give you the right solution or the right answer. And when it comes to FTO, again, it depends upon what the situation is. Every situation will have a different answer. Freedom to operate, very strictly speaking, potassium should have freedom to operate because it's not exactly sodium. But having said that, because it is chemically very similar, almost indistinguishable from sodium, you might get a freedom to operate opinion saying that it's a no-go. So it entirely depends upon the person who is writing the opinion. They can give you a go or a no-go, depending upon who is drafting it. That's why I said now the Fosita is a unicorn animal which is very difficult to catch hold of, and every person has a different opinion of who a Fosita can be. So that's where the gray area starts. Now, while I don't want to delve too much into this, but I thought I should highlight this before I go ahead. So that's when you have an invention, you have a doctrine of equivalence that surrounds that invention, which is something which is very similar. You cannot substitute something which is identical or has a very similar property or function in your invention and market it saying that it's a different solution, because it's not. So this is your invention, this is your DOE. This is your invention, this is the DOE. So all this is prior art.
Ma'am,
Yes?
so while determining FTO for a particular invention, do we need to check for non-obviousness?
Yes. FTO is not only anticipation, FTO is also non-obviousness, because DOE does fall under the purview of non-obviousness. So the likelihood of just having one patent in a technology space is pretty low. So that's when you start ending up with, you know, a nice looking messy graph like this. Now once you start populating this is when you start realizing just how much activity is going on in the space. You know, you might think that you have a good knowledge base, you found technology gaps. Well, there's news, and there's plenty of it. And that brings me to the next topic, which is validity. Now what do you do when you have a patent blocking your way? So now, you know, you have your solution over here, and there are, well, quite a few patents around there. So you get a validity analysis, which is a legal opinion about the likelihood that a patent claim will be invalid in light of the evidence suggesting obviousness, lack of invention, unenforceable. There are many other parameters. There are many tests that go into it. Well, I don't want to, you know, convert this into a law class. There are many other factors that go into a validity analysis. So this is where you get a legal opinion on to the validity of these patents. And the other solution is licensing. You know, you approach these parties and ask them for a license. Which brings me to the next topic. Intellectual property in most jurisdictions follows property law. Now, this has got nothing to do with intellectual property, so can anybody define or just give me a highlight of what it can be that we are talking about? What is licensing, basically?
Authorization to use or for commercial purposes.
It doesn't have to be commercial.
Or individual purposes.
Yeah. It's just a permission. It's just like property. If you own a property, you can do whatever you want with it because you're owning it outright, right? You can sell it, you can rent it, you can live in it, or you can just abandon it, right? It's your property, it's your will. The government has given you the right to do whatever you want with it, as long as there's no antisocial activity happening. Okay, that's the only caveat. And the same caveat holds for licensing also.
Now, if I license technology and I developed a technology over that and I license it to third party, then is it?
You're talking about indemnity. I'm going to come to that. So licensing is giving another party permission to use your intellectual property. So essentially, you can sell it, you can license it, or you can rent it. As licensing is essentially renting it for a fee. Or you can abandon it because it's your IP. You can do whatever you want with it, as long as it does not break the law. The same situation that goes for property law goes for intellectual property as well. And it's contextual. You know, you always hear of two things, right? Licensing in, licensing out. For me, they both mean the same thing. It's contextual. Contextual. If I license, then I'm in licensing it and you are out licensing it. If I license a product to you, then I'm out licensing and you're in licensing. It's just contextual. So yes, you know, there are two, and the strategies for both are different. When you're trying to in-license something, your strategy is very different from when you're trying to out-license. So when you're out-licensing, you're trying to get revenues in. When you're in-licensing, you're trying to make sure that, you know, you're not spending too much. So this is something that I picked from somewhere. I think Ernst & Young, an economist, you know. They said that licensing has grown from 110 billion to 500 billion, which includes copyright and trademark licensing. Now, every form of IP can be licensed. It's not just patents, trademarks, even trade secrets or know-how can also be licensed. Normally, patents and trade secrets go hand in hand. When you license out patents, you also tend to license out trade secrets. The benefits, it's cost effective since the financial burden of product development is shared. You're not the only person who has to reinvent the wheel, every one of them. And more than that, there's also the infringement aspect. You might want to reinvent the wheel, but if somebody has a patent on it, the wheel is not happening. It's a lower risk option for the company buying, as it can make deals based on promising results. So you can always defer your payments for the future. You can license it saying that I need this to develop my technology, but I'll give you a share of the sales or the profits that I make. So you're deferring the payments to the future. So there are two ways of doing it. You can either pay your license fee up front, which is, I'll come to that, which is a lump sum, or you can have shared based on profits or number of units sold, or you can have a combination. It entirely depends upon what your risk appetite is and how confident you are about your product hitting the market and becoming a huge success. So what rights are being granted? To make, have made, use, sell, offer to sell, and import. So these are the rights which are usually part and parcel of a licensing deal. And the territory, it can be anywhere. Depends upon which jurisdictions the patents or the intellectual property rights, it can be trademarks or copyrights also, they are covered. The duration, it's entirely up to you. You can license it for a few years, for a month, 2 months, 3 years, or the entire term of the patent. Licensing of inventions versus patents. Like I said, one of the biggest risks that you run if you don't license is an infringement suit if you do something substantially similar. And if you reproduce a patented invention in your lab which falls under the jurisdiction of the intellectual property right, then you are opening yourself up to a suit. So, or you find a design around strategy which is, an alternative if it's cheap enough, or if it's not going to take too much time, or if you're dealing with somebody you don't want to deal with. And you can incorporate other IP rights. It doesn't have to be just one IP right. It can be a bundle of all IP rights or as many IP rights that the owner is willing to license out. Now, one word that I would like to include is that an exclusive license, should you take one, bars the patent owner from practicing their own invention. Unfortunately, a lot of licensing in folks don't know this. They ask for an exclusive license and then they don't enforce it on the patent owner. If the patent owner is pretty savvy, they would know. But if you're licensing it from another startup or someone who's not a savvy inventor, they think that oh, I'm giving an exclusive license, so they do it and I do it too. Well, no. They do it and you don't do it. So the way around for both parties is, if both parties still want to practice, it's a non-exclusive license. Give it a non-exclusive license to the third party or the party to whom you're licensing out, so that you retain their rights and they also have their rights. However, you can put clauses saying that, yes, I will take a non-exclusive license from you, but you cannot license it to a third party. That's doable. So that's why I said, it's the contract that you sign that can make or break your company. It's all about contracts. It's, yes, the technology, yes, but make or break of a startup is the kind of contracts that you have. And the contract is not what you're signing right here, right now. You should be able to project into the future and then sign your contracts accordingly. If you can't look down the line, get somebody who can look down the line for you, which is where the mentoring comes in. Where is it? Yeah. So the performance standards, they can be sales or royalties or failure of licensee to meet the standards. Now, if you're licensing in, remember that you have obligations to the licensor. It's not that you've just given them the money and you're done with it. No, you also have obligations to the licensor to ensure that you're using the invention the way it is supposed to be used, especially when it comes to manufacturing of devices, implants. You would be required to indemnify the licensor. That's the answer to your question. Indemnities, all licenses usually indemnify the licensor against the action of the licensees. If you are going to mess up, there is no reason why the licensor should be paying for your mess. Put very simply. And this is important wherein the licensee is making a product that can damage others. By others, I mean people or environment or animals, if incorrectly manufactured. So the licensor and the licensee, the relationship is not just money, but there are other things that go beyond just the money that changes hands. And you can have a lot of royalties, it depends upon how you want to do it. Different people do it differently, depending upon your risk appetite, where you are on your TRL, where you are on your funding, and how confident you are about your solution becoming a success. So you can have a one-time royalty, you can have ongoing, but yeah, usually licensors always have a right to audit. So don't be shocked when the licensor says, I want to see your records. They have a right to it. So bringing it all together, it's a cycle. So that's pretty much what I was trying to depict over here in a messy page, that they're not independent of each other. All of these always come together to create a diagram for you which will help you understand what the risk analysis or the risk appetite that you may have and the potential solutions that you can come up with, which will help you get from the lab scale to the big scale. So you have an idea, create a knowledge map, you identify the technology gaps, then you figure out if you can actually sell your idea and make profits, and then get others to help you in your journey. And if that idea doesn't work, you come up with a new idea. Thank you.
Can we go back to the slide where you have explained the example of sodium plus X?
Yeah.
Yeah, okay. You have given a chemistry example, but what I see is there is some ingredient called Na and an ingredient called X, which is a prior art, it's an established thing. And now one inventor wants to propose that use ingredient K and X and show that it's a new invention. Now my basic question is, just take an example of chemistry. So sodium chloride, the common salt. Why KCl has not been used as a common salt?
Yes. KCl actually is an ingredient in one of the 3 ingredients of a lethal injection. And sodium chloride in excess quantities performs the same action. So chemically speaking, they are both very similar.
Okay.
But concentration wise, potassium is more dangerous than sodium because of the makeup of your body. Your body is less tolerant of potassium concentration as opposed to sodium concentration. If you have a lot of sodium, you will get blood pressure. You have too much potassium, you will die. So
Okay.
that's the difference. It also depends upon the ecosystem into which it's going. But the chemical aspect of both are pretty similar because sodium and potassium are very similar. And in excess, they are both harmful to you. And the point here being, because they're so similar and the function that they do is also very similar, they are chemically indistinguishable. I'm not saying that they're identical. They're not. You know, they have a different chemistry altogether, so to speak. And in some places, sodium works better than potassium for a variety of reasons. Yes, you know, chemically speaking, each one has its own rights and limitations, but they're still very similar. Okay, a chemical reaction using sodium is very likely to happen if you use potassium instead of sodium, with pretty much the same results. And that's the point.
This question because it's relevant to the example given. Now I come back to my question now. There is one process or some system, say a product or machine that has been in use in place using the prior art or existing database. Now I am coming with some new ingredient into the process, which shows a betterment in the output result.
That's the point. If you just put something which does not really change anything, if the output or the way in which the operation is being performed, nothing really changes. And like for example, you know, if you know you're performing this with 6H2O and you perform it with 8H2O, nothing substantial is going to change. But if you change the concentration, you know, the pH will change, and that will trigger off other reactions. Now, that is going to make a difference because at a lower pH, this reaction is doing something that it would not at a higher pH. So that's
we mean if the output is same and then they are changing the variables, then it would be an obviously not an.
Or it would fall under the doctrine of equivalence.
Yes.
If you're using exactly the same thing that the prior art states. Now for finding the solution, if you're using something completely different, you know, instead of, you know, if I want to make common salt, but I'm using 3 different processes and, you know, I'm incorporating 50 different schemes and still coming to sodium chloride, that's a method. You know, I am, you know, inventing a radically new method to make sodium chloride. My end result is the same, but the way I did it is different, which makes it a method patent.
Process or method would be patentable rather than the product.
Technology to a company which is there in India. So the same technology, though the patent has not been filed in India, can give a license to an Indian company, and the Indian company can work, or we can say can sell the product in India.
How can they license to a jurisdiction they don't have patent rights there?
So the patent rights, so they cannot exclude others, but they can give a license.
How will they give a license in India when they don't have a right in India? They have never filed for a patent in India. You cannot license to a jurisdiction.
So even for the cell, they should have they should file the patent in India.
Yes, if the US company
Even for the
is
cell.
planning to sell in India, it is ideal if they file in India too.
Yeah, but they don't want to exclude others by selling the technology. Means what I'm saying is, even though means they haven't filed a patent in India.
Okay, let me put it this way. Your flat is 101, okay? Your neighbor's flat is 102. And you have no rights on 102, right? Can you rent 102?
No.
That's the same answer. If US has no patent in India, they cannot license rights in a country that they don't have rights in. If you're not the owner of the flat, you cannot rent it.
Okay.
It's the same.
Yeah, simple sell. I don't want to exclude others. Yeah, yeah. So I think we can.
If you're filing in India or anywhere, yes, any pre-published art becomes prior art to you. It may not exclude you from practicing in India if they don't have rights for that invention in India, but you cannot patent it. Nor can you export your product to the United States because they already have an existing.
Okay, so same will be reciprocated if somebody applies for the same patent which is filed in India. So
I didn't get you.
So if he has a patent in India and somebody tries to file it in US, will it stop them from filing because
Yes.
the
Prior art exists, yes. See, if there is a patent on a certain technology in India but not in the US, if it is in public domain, then they cannot file a patent in the US on the same technology. However, they can practice that.
That means it's published.
Yes, it has to be in public domain.
So before publication, they can go
Yes.
and file.
Yes.
So it's not so we have to be careful to disclose it before publication.
No. If you disclose it before,
Publication. We have filed but not published.
Not
The
avoided.
patent office hasn't
it's not
published.
required. Whenever it gets published, they're going to look at it.
Okay.
And if they deem that the US patent was filed after the Indian patent was filed, then that's where the holy number of the filing date comes into action. But however, having said that, in the US there's a 12-month grace period which can be interpreted and used in many different ways. So I really don't want to go there right now.
Okay. Before filing, there is a 12 months.
There's a 12-month grace period.
Yeah.
Relating to this filing period, we actually file or submit an application for patent, say in India, but awarding the patent takes a longer time. What happens when we do that?
After 18 months, your patent application gets published anyways, irrespective of whether it has been granted or not. So it becomes public information.
Yes. So, for example, if it is the same set of people trying to use the same product in two different geographies, so then is PCT the normal way of going, like to protect the rights in both the countries?
You can go the PCT route or you can just file in both countries.
Both
Why
countries
do you need to go
same
PCT
time.
route when you're only talking about two countries?
Both countries at the same time before each of them becomes a prior art for the
Not
other.
necessarily. You can file one and within 12 months you can file in
File
another
that.
jurisdiction claiming priority to this application.
Okay.
And it goes via Paris Convention, which is the mother of PCT, but it's a mother.
So there's a notion that you can file in like country like US, it's much more easy for you to enforce it than doing it here.
Not necessarily. Enforceability has a lot of criteria, and most of the patents that are actually granted are not enforceable. So your enforceability potential has to be pretty high.
So, if you have filed the patent in the US and it is not covered by Indian jurisdiction, how much time do you have after you have filed the
12 months.
That's it for all. And in this like 12 year, if someone has started practicing of
Tough luck.
there's no
There's
other way
nothing
to
you can do
proceed.
about it.
So you have to decide in those terms where all you want.
Yeah. That's why most people file a PCT because that gives them 30 months to think about it.
Can you see slides of the report?
Which one?
With this previous one?
This one?
Yeah.
Or this one?
No, the next one.
Oh.
So, what is the information that we can extract out of this particular chart? So,
It tells you what are all the jurisdictions in which the invention is active
Okay.
and how many there are. So it helps you populate this map.
And then what would be the after this insight, what are the desired actions that we would usually come to, or the conclusions that we would come to?
Well, it depends upon whether you want to enter that
okay.
jurisdiction or not.
Okay.
And if you do, then you have a cast of characters against whom you have to go against.
Okay. Okay.
Can you go down 2 slides? One below. Next. Yeah. The second figure you have,
This one?
that second peak, does it mean that the technology has matured and perhaps you look for an alternative or a better one? That's the good time to do that?
This is usually where the next cycle starts. This, around this zone, is when the next.
So that's what you said, that look, I need to look for a better solution.
Yeah, because if this is only in isolation, but if you look at the actual technology adoption map, you will find, lots, every time there's a double peak, and by the end of the double peak, the next technology has come in.
So in say healthcare, how long typically these critics period that is to
This is not technology wise, but every single technology would follow this. It's like a Gaussian curve. So the standard deviation would depend upon the technology and the maturity. I can't predict it because I have no idea what medical technology is. But this is the peaks that they would follow, and it's almost technology independent. There have been many studies in this space, and they found that this is technology independent.
So mostly the ones we coming after the first peak would be more of incremental.
Yes, yes. This will be incremental until again a big breakthrough, a great alternative comes in the same technology, and then it starts tapering off until something else starts. Like you had, if you look, you had CRTs, you had a big TV, nice TV, there's black and white TV, and then you're starting working on the how it looks, the size, and the voice, the volume controls, and then it starts peaking out, and then suddenly color televisions come. So that's the next big peak.
You also had
And
one more slide before this where you had map for multiple years.
which one?
Very complex looking. The first graph that you scared us.
Yeah. Okay, that was not the intention.
So here we are talking about only one technology, right? Right through from there.
Yes, this is one technology and its alternatives that
So there are
came.
so many. All these are the patents which are filed in these years.
Yes.
So similar technologies, there were so many patents filed.
Yeah. This is, if you have a core technology, and then there are solutions which are similar, and they all go hand in hand. If you have one solution, that doesn't mean that it's the only solution in the market. There are several other technologies that run parallelly.
Which also means that there would be space in market for.
That's why I said that's where your technology gaps come in. Yes, you have a running graph, but that doesn't mean that there are no technology gaps.
And in that, does this range also plays a role in giving the patent? Let us say somebody has claimed the broad range, okay, and I'm giving the narrow range, something like that. So does it qualify for the patent?
Only if that narrow range is giving you something special that the broad range was not talking about.
Then it is patentable.
Then it's patentable. But that doesn't mean that you have freedom to operate.
That's okay, but so my claim will be approved only for the narrow range, not for
Yes.
the,
Yes. Only if your narrow range is giving you something that the broad range is not talking about, and it's something unexpected, and you've actually done something to identify that narrow range, saying that, hello, this is giving me a blue peak when the rest of it is giving yellow peaks.
But that earlier person has claimed that narrow range also in claiming the broader range.
Yes, but okay, there's a lot of case law in that. But however, if the broad range has an example which falls in the middle of this narrow range that you're talking about, then it's not patentable. Because if you're talking about 1 to 100, if the broad range is 1 to 100, and you're talking about 25 to 30, if they give an example of number 28 doing something, then you won't get the 25 to 30. So better look for 45 to 50. So the point being, the person who has the broad range has experimented in several areas of this range. So they already have prior art. So that becomes prior art for your range, saying we have performed in this range and gave these results, and in this range it gave these results. However, if they say that is the ideal range, of which 25 to 30 is the ideal range for the best results to come, and you say that, okay, you might say that, but 45 to 50, if you do these XYZ steps, is going to give you much fantastic results than 25 to 30, then you qualify for the patent. However, if you say that 26 and 27 give this fantastic result, you will not be eligible for the patent. So it is kept in context with what the broad patent talks about. It's not a standalone. Your range is not standalone. It will always be looked contextually to the prior art that exists and what the prior art has claimed and talked about. And the thing about patentability is it's not restricted to claims. It's anything and anywhere. It's like I said, even a Disney cartoon can be a prior art to you if it has talked about something similar.
Also, when we are talking about processes, does it limit to a physical process, or let's say we have a mobile application which forces the user, or which asks the users to follow a certain procedure to get something done. Would that fall, or would that be patentable, or?
See, pure software patenting is a dicey issue. Just software is usually not patentable unless you are linking it with a hardware which is something tangible. And if it is just software, I would encourage you to think of copyrights rather than patenting.
So even if it is changing a real business process?
You see, the thing with copyrights, the thing with software is the same code which gives you the same answer can be done in 20 different ways. 20 different languages coded in 20 different ways gives you the same result.
Same thing goes with copyright also, in terms of.
No, that's why I'm saying. That's why if it's just a software code, it's better to go with copyrights rather than patents.
No, I'm talking about not the code. The code is not important because, as you said, it can be done by 20 different ways. We are worried, we are more concerned about the process change that we have got. So the idea is the process, and how we are getting it done through the software is.
In the US context, he may be able to do that. So what he's trying to do is the utility he's showing of the software is a business process that is taking place.
Oh, yeah, business process, yes.
Yeah. So he's saying that the business process executed through a software, or in case some hardware is used, you can do it with the hardware. So in which case you may be able to go for utility patents in the US.
Yeah, business process in State Street.
Yeah.
But not in India?
Not in India.
Not yet.
But to get the dates, you might have to file something, which might never get accepted. But then go and file in the US. Right?
Yeah.
There are some tricks of trade in terms of what she was saying, that you can write it in such a way, software written in such a way that it looks like a process or an implementation with a hardware. Right? So it's a matter of how you write it.
How you present it, and it's basically a negotiation between you and the patent office.
Are you done?
Yeah. Any other questions? I think we've run over time.
Let's give
Thank you.
Dr. Jaya.
We'll break for lunch now.
A, C, and D. Why not new combinations?
I'm thinking from the IP perspective.
You're thinking right. So please go ahead. Yes, that's the point. So new combinations. New combinations of what? Everything, right? So new combinations are not patentable. New combinations are not, they cannot have a design protection. New combinations cannot be copyrighted as well. New combinations, I'm saying, no. So if there were two existing things, you just combine them. So the correct answers would be A, B, and A, C, and D, right? Not B. Okay. The public policy tool that encourages investment in innovation and entrepreneurial risk taking is what? And you thought I was not prepping up you for all this? I was. Yeah, tell me. Intellectual property? Everybody? Everybody with me? Okay, I agree. You have the right answer, but no prizes for that. Huh? Then, intellectual property management became important when more patents were filed, they became more knowledgeable about legal processes, patent practitioners realized that IP must be managed, companies started making money from IP exploitation. Huh? C and D. So patent practitioners realize that IP must be managed. So they might be feeling, but what if companies don't come to them for protecting their IP? By patent practitioner, we don't mean the companies that hold the patent. Patent practitioners are professionals who are handling IP for somebody else, right? So you answer now. We are on the third question. Intellectual property management became important when more patents were filed, they became more knowledgeable about legal processes, patent practitioners realized that IP must be managed, or companies started making money from IP exploitation. Huh? More patents were filed? Why were more patents filed? Because more knowledgeable about, okay. But legal framework was always there. You mean to say they got information about that and they started following. But there must be some flashpoint, right? What was that? When they started making money. When the first person made, then they realized that yes, it can be exploited to make money. IP can be treated as a collateral. It's an investment, not an expenditure alone, right? So the intellectual property management became very important. How do you manage? And that's why we have a talk on this today, right? So creation of value from IPRs. How all can we, what are the ways can we generate wealth, which is the ultimate thing for entire this paraphernalia of protecting IP? How can we do that? We have heard couple of them in like today's earlier talks. One is practicing or exclusivity. That means either we practice the invention, we make products, we sell in the market, and have a market share and profits, right? Or exclusivity, only we are doing it, nobody else is doing it. Without our permission, I mean to say. Licensing and cross-licensing. So licensing in, licensing out, I think is pretty clear now, right? So these are contextual words. So if somebody is giving in, other person can, well, then only take, right? So there may be capabilities, there may be supplemental capabilities wherein one company may help others. In that case, we have cross-licensing. You take this, I bring this on the table, let's share and make something out of this, like IBM does. Litigation. So if you decide that like if you're at a level wherein your IP is very, very important, it has been well thought out, the claims, etc. are well managed, then you can think of litigations also. That means as a strategy, you can file infringement suits against the people who are practicing your invention. Then deterring. Deterring is stopping others from practicing your invention. Use of IP as a collateral and in exchanges. So now IP is shown on the balance sheets as well. So now we have to talk about IP strategy. So tell me, if you have an invention, what would you do? Immediately file a patent? No. What will you do? Search. Okay, then? So you get a patentable invention. Then what do you do? Sorry? Commercial potential you evaluate. Okay.
And then I will evaluate whether I am in a position to manufacture,
Okay. Give it out to somebody. Okay. What else? So I have a patentable invention. I have a commercializable invention as well. So do I go ahead with the patent filing? Yes. What if I don't have money? Look for investors. Why will investors come to us? Potential in it, right? And in between evaluation of patentability and evaluation of commercialization, what if somebody else comes up with that invention? Mm-hmm.
IP already filed on that.
So already IP should have been filed on it, right? Before so many evaluations. This is one take. Other is I don't have money. Anyways, right? I have to spend on attorneys for getting a patentability search done, for getting commercial evaluations done. So what if I file already? One stand is this. Other is, okay, I have a potential invention which is commercializable. I see a strong potential that it will go to market. I can proactively approach the investors, but again, what happens? I run a risk of disclosing my invention and somebody else knowing it and start practicing it. So in any case, a priority date is preferable, right? But suppose the money is directly going from your pocket and not company's pocket. So what, you will be more cautious? So suppose you have two inventions. Which one will you focus on? Right, and you would leave other one because the amount of investment is less there and resources are limited. One scenario. If you are a big company, you are being awarded for filing patents. What will you do in such a case? File more and more, right? That comes naturally. So that all depends upon what the IP strategy of the organization is, in which the organization to which you are belonging. As a startup, the financial crunch might be there, especially for investing in IP, which you don't see immediately being granted also, like 3 or 4 years that money seems to be dead. We are just paying to attorneys for every formality. But the whole idea of investment there is that what if this turns out to be a blockbuster? So, to have a uniform policy in order to help the stakeholders in taking such key decisions for IP protection, we need a IP strategy. Right? IP strategy, basically, there is a business strategy, there is an IP strategy. And both have to go together, right? For a good business venture to flourish. Then IP strategy can be internal as well external. So internal IP strategy means you are receiving disclosures, you are reviewing it for patentability, you are reviewing it for potential commercializations and deciding to file or not to file, right? External IP strategy is what happens to your patent after grant. Is somebody infringing it? Are you enforcing it? Right? So these are the external IP strategies. Again, every place you have to take a call, whether or not you will sue a person who's infringing, or you let it be because it doesn't matter to me, because I have a big business. If one person is copying, it doesn't help me, or it doesn't bother me, right? So that's the IP strategy. So we need to have a formal IP strategy in place so as to help us in taking such key decisions and making most out of the IP information we have. So IP strategy can be first. If you remember Dr. Premnath's that graph, that picture in which there was a big background prior art, over that know-how was placed, then small prior arts, then there was a white box this side. So coming to the same thing, why do we need an IP strategy? One is protecting inventions and getting recognitions, obviously. Manage competition, design freedom, that I have freedom to research around the area, market development, deliver revenue, and a business strategy over top of everything, right? So the diameter indicates the coverage or the importance we are giving to a particular aspect. So protecting inventions is the first thing, and accordingly this follows, right? So first is to build your portfolio. What is a portfolio? What is a portfolio? collection of IP, identifying.
Identifying which areas
So basically, portfolio is a collection of IP which a company sits on or generates over a period of time, right? It so necessarily it's not only patents. Strategic patenting, purchase patents. So this is how you build portfolio. That means I have my researchers have worked on it. They have generated substantial IP. Fine. If there is any lacuna which I feel, then I can purchase patents from them. Others, whosoever is owning them, right? Okay. Then deploy a portfolio. Okay, you sit over portfolio, but what do you do with it? One, design freedom, that you have the freedom to work around a particular topic, manage competition, enter new markets, and deliver revenue. Of course, that's the ultimate thing. When people invest, they look forward to revenues, return on investments, right? So enter new markets and manage competition. This is very, very crucial, especially when we are talking of areas of national importance, right? Suppose and national importance, especially for like organizations like NCL who are supposed to work on areas of national interest. So we have to file certain patents strategically so that we keep the doors open for the technology. A private partner or an MNC doesn't close the doors on us. So we have to have a priority date for a particular area which we feel it may not be immediately important, but for coming 10, 15 years it may be important. So we need to have a patent filing for strategic reasons as well. Okay? So hierarchy of IP value, this we have discussed already. So that's a business strategy driver. This should be the way, and the potential returns follow. So potential returns come here only when IP strategy and business strategy are working in tandem. Okay. Now we come to IP culture, because IP culture will more or less be in dynamics with the IP strategy. So trying to make it simple, I have just portrayed it in form of a house, because we understood that IP is also like property rights, right? So first thing is the basement. Basement is unprotected. Basically, it's a know-how. Know-how which we are sitting over. We won't file a patent on it. We will not disclose it, right? Then is the ground floor, which is defensive. So if somebody comes inside the house, what do? We'll first open this door and come out, right? So this is the defensive patenting which we do. So this may be a defensive patent tip, this may be a defensive publication, right? Then in the second floor, it should be, okay. Second floor, now comes the savings. So we have an IP portfolio, we have couple of patents, trademarks, etc. But what do we need to do? We cannot let them be forever, right? So we need to have some cost optimization as well. So that comes on the second floor. Third floor is profit earning. That means I have started licensing out. I get revenues, I get royalties, so I'm earning now, right? While there is an underlying technology already in pipeline. Getting my point? So this penthouse is an integration of what? It's an integration of all lower floors plus the visionary aspect of seeing where the technology trend is going and integrating it with the IP strategy, and this particular thing keeps changing in dynamics with the requirement of the, say, the country or the society. Okay. So unprotected level is confidentiality, access to complementary assets and lead time advantages. That means that's a know-how basically, wherein we are just working on it. We know that this is the basic of it, and upon that only we will be developing. This is something you can correlate to the 80s GSM technology of Motorola, right? They worked with certain operators and they just were the masters then. Okay. So they had the lead time advantages. Before anybody else could come in, they had that advantage and monopoly until certain time. So defensive level, when we are on the defensive level, what do? We quietly work. How do we? Creating an awareness of the role of intellectual property. And so we incentivize our researchers. We say that this is the IP policy. You should file more and more disclosures. You should be more IP savvy. You don't publish before you patent, right? You don't present your work before you file a patent application. Obtaining intellectual property. Maintaining IP rights. That means you have to carefully prune your IP portfolio. So So you have to maintain also, you have to give money to the patent offices to keep the patents live, respecting IP rights, especially patents of others. So that's a goodwill you generate. So if you look at certain Japanese companies, I will show, they have in their IP strategy, respect IP rights of others. Because that's a mutual thing. If you respect others, they will respect your IP rights as well. Willingness to enforce patents when necessary. So certain companies, what they do, they buy patents from others and they keep filing infringement suits against other companies, right? Which the primary company would not have done. So these are called patent trollers. They just sit over it and file suits and take money out of it. So that is another way of making money out of IP. Cost saving level, focus on how to optimize cost for the patent portfolio. You cannot keep on investing it. It has to be a calculated decision whether or not you would like to invest further. Then the profit generation level, utilizing the IP portfolio as a corporate asset, extracting value directly from the intellectual property portfolio, that is by way of revenues, by way of licenses, cross licenses, increasing your assets, merger and acquisitions, non-core, non-strategic IP having tactical value. It may not be immediately valuable, but if over a period of time, it may be valuable. Then IP again for profit levels, organizes high profile campaign against infringers. So you have an agenda that I will file infringement suits against whosoever is infringing my patents or my portfolio, right? It may be a product in the market which has a trademark or trade dress similar to yours, right? Then, develops active patent and trademark licensing programs. So you put on your website, this is for sale, come and talk to us. So like the lithium-ion battery which was developed, which the patent of which rests with CSIR South Africa. So they have a standard template. Whosoever wants to work on lithium-ion battery, they go and sign that particular licensing agreement with them and starts working. So that is the level of things being streamlined. They have made it a profit center actually. Makes more good sense oriented R&D efforts. So you don't reduplicate the efforts, but you are on top of things. You know what is novel, what is the need of the market, and then you accordingly plan your R&D effort. That means your IP strategy is well integrated with the business strategy. You know where you want to go. Begins or improves active screening watches for patent infringements. You'll get all the slides. I'll share copies, no issues, right? Okay. So when the people are treating us as a profit level, they have to invest into things like infringement tracking, which requires a lot of money and resources, right? Then only they can say that, okay, they are infringing my patents, we'll have to take a call on this. So if the infringer is somebody like Microsoft, we'll be very happy. We'll go for, okay, you are infringing, please take license from me. But if it's a small company, then okay, you get a notice from me now, right? So that's a tactical decision you take. In tough cases, prepare to litigate against infringers. Then licensing, we have heard a lot about it today. The integrated level, or we say this is a visionary center, wherein you see the technology 15 years, 20 years down the line, what would be the need. So see, after 15 years, it may be ready. So we keep on preparing for that right now. So this is called a market push technology. It is not a market pull technology. So it's a market push wherein the market will, market will be pushing it. So again, just to summarize that particular house, first is the defensive one. The basement is not here. So build portfolio, protect market, technology, cost control, optimization, improve productivity, profit center, licensing, revenues, etc. Integrated, that means you license in, license out and integrate it. And then the visionary, the drive growth. That where are we going, analyze it, go back to the drawing board and then come back again from top to bottom. Okay, so portfolio planning. So generally when we review an IP portfolio, we may find something is not required right now or something is outdated. So we need to keep removing it so that our portfolio doesn't become too costly for us and we can generate the amount of money we are investing in it at least, if not make huge profits. So the kind of questions we ask for portfolio planning typically, so this is a standard which I have tried to collect from like various organizations including R&D, academic institutions, etc., which says an application file today defines what protection the business has 5 years from now. Okay, So 5 years now, what will be the market? What products and processes will the business be selling? So is there a business in the patent application we are filing? Is there a business? So we have to contemplate a situation 5 to 10 years down the line. What product and processes can we expect the competition to be selling and using? What will they be doing? The answers to these questions go to the heart of company's business plan and portfolio planning, therefore. So this is another there are 8 aspects of IP which are known to be, but unfortunately we understand more about patents, right? But when we are trying to define an IP strategy, it includes all aspects of IP, right? Some things which relate to function, like a patent or trade secret, that goes inside this, which is the closest one. Then comes the expression, which is copyright, and then is the brand, which is the outermost circle, like mark or dress. So a classic example of this is aspirin. So aspirin's patent expired way back, but still we know which company manufactures aspirin. No. So any idea? Okay. So they integrated it with their trademark. So they say, so that's a arrow coming like this. So that's a trademark they have protected. So the trademark has outlived the patent. So they say, ye hamari hai. So that's theirs. So that is the best one. That is how they have marketed it. So here it's a mark and a dress. Okay. And a very close example, which I think all of you could correlate, is the Amul girl. Right? What's that? Brand image. What else? There's some jingle also with Amul coming. What's that? So that's one product. That's not the entire family. Utterly Butterly Delicious is only for butter. What else? The Taste of India. Right? This is one and then every major event in the country is also marked by a Amul ad. So what do they do with it? They reinforce their trademarks. They reinforce their market presence. So that's the way of their strategizing their IP. They may not have a patent as sure, right? They may have some particular product which may have some trade secret or something inside it, but they market it like that. That's and anybody copies can be sued by Amul, right? So that's the importance. We may not have a technology, really a breakthrough technology, but it's a way they have marketed it, they have put it up and maintained the quality also. So this is how. Then, so this is the IP atom which a company may decide to agree or disagree. So they may keep the core things as a trade secret, layer it over with the copyright and other design patents as well. Then there can be a trademark, trade dress also. So another good example of this is that Gillette Mac razor, right? So in case some of you may not be aware, the USPTO accepts something called Gillette defense in support of obviousness. When examiner comments that the invention is obvious, the applicant comes up with something called Gillette defense. What is this Gillette defense and why is it having a background? Because Gillette has it has multiple patents on its one product, the Mac 3 razor, wherein the single performing razor is there, and these edges, lock system, etc. Everything has been patented, right? So if we look at as a very superficial thing, we will say this is obvious. That why these all patents have been granted to a single product, because they seem to be obvious over the others, right? When one patent is granted, but that is not the case. So that is a separate matter, but I wanted to reiterate here. What I want to reiterate here is, so Gillette has these patented things, has a design registration on it. The packet in which it comes, the packing, that is also a trade dress. And the kind of noise it makes when you just take it out, so that is also protected, right? So this is a kind of the IP continuum theory adherence they call. So this is called IP continuum theory, wherein a patent may end in 20 years, a copyright may end in 65 years, mark or dress may continue forever, right? Getting my point? Everybody with me? Any questions? No questions? Slow or fast?
Combination is more stronger than the individual.
Exactly. That is why it's called IP continuum theory. So that means the protection continues even if those 20 years have expired. So that's a strategy which a company has to plan around the product, considering its investment in it, considering its long-term plan, its business strategy, how whatever it is planning, right? Very busy slide, huh? But what to do? We have to. But I'll try and make it simple at least. So we have a market need. Okay? So we have a technology in-house, yes or no. So we follow the yes first. Let's be affirmative. We have a patent applied for yes, then we are prosecuting it. So this is a straight line here. Right? No issues. Then we have not applied for a patent. So here, if we don't have a technology in-house, what do we go? We search for in-licensing opportunities, right? So, or invent. Invent is another option. And if we are inventing, we have to evaluate new patent application. Is that clear? Okay. So, the current market is this. There is no market. Currently, immediately there's no market. We have a significant future market, say 10 years down the line, right? So, what do we do? If there is no market, then out license or hold, because others may not see a value proposition there. So we may end up selling something which is very, very important at nominal prices. So we may keep it in reserve for us only. But suppose there is a market, then we will evaluate a new patent application. We can file, right? And filing a patent application here means we may have one broad patent. Suppose that's a crowded area, we can go ahead for the patents which has narrower claims and try to build a sort of a wall around that particular technology which we are trying to protect, right? So this is again a defensive strategy of patenting. And suppose there is a current market, then we start with innovation, and then this goes back to path A. Clear? So this is one of the strategic planning. Then when we are starting like from the drawing board itself, and we are just contemplating what to work on, we analyze the market, as you guessed, right? Then we look at the likelihood of commercialization, the path we discussed few minutes back. We look at the competitive analysis, what is the competitive edge we are having, what are others' offerings. We look at the prosecution cost, and we check with our IP strategy, is this aligned, this particular invention, is this aligned with our IP strategy, right? If it is, then we decide on filing, decide on filing. Then this is a filing in a particular region. What are we ready to commit for the cost in other countries as well, right? Does the technology have market in other countries? So that again we need to analyze. So these are the market barriers. Something related to the FTO Jaya discussed, which we will discuss in some details. This is a figurative way of indicating that these can be like the crowded areas, wherein the market, the entry is quite restricted, right? Okay. So an IP strategy, when say many of the startups would be in the process of designing an IP strategy for themselves, or others may be working in organizations which have IP strategy. So basically, or you may be contemplating to formulate one for your own institution, etc. So an IP strategy should be answering these questions supposedly. One, what capabilities do we need to build an IP, for creating IP, for administering IP? Like somebody said that we may not have the potential to take it ahead to the market ourselves. We may have to look out for licensors, right? So especially in case of pharmaceutical inventions, so the developing countries may not have resources for the control trials, etc., and the kind of investment which they need. So they may out-license the drugs, the molecules to the companies outside. For managing the commercial roles of our IP. Commercial roles, you understand? The houses we discussed. What is the commercial role of our IP? For managing the legal roles for our IP. So what our IP is good for? Can we file an infringement suit? How will we approach managing our IP? So what will be our approach? We will be a cost-centric one. We will be a visionary one. We will be an integrated one. How will we approach? What will be a mix of commercial versus defensive activities? What will be our rules of the game? right? Then what will be our sequencing and speed of IP activities? We may not file patent on every little thing we have. On the other hand, certain companies may have the view that we need to build a fence even with claims with little breadth, instead of going ahead with like entire fence with one claim, right? So they may develop portfolio like that. Then speed of each, how will we measure our success? Eventually, if we have an IP strategy, we need to see whether or not it is successful. So how do we see that? What are the elements of success for our IP strategy? Maybe we are looking at revenues, licensing deals which we have chalked out, or even expression of interest which we are getting, right? Or the quality of patents we are generating. So all these may be part of the matrix by which you see how your IP strategy is working. Okay. So when we come to protection of IP, you remember the strategy 2 that we need to go ahead. This slide I was talking about, this one, filing decisions, right? So when we decide that, okay, this is patentable, this has commercializable aspects, what do we do? So the questions again we ask, why do we need it? Is it fitting in our bigger plans? Where do we need it? We may have some particular, say, process which may be used in n number of things. Suppose we have some process for for preparing a polymer. A polymer may be used in, say, drugs. It may be used in some spray sort of things as well, right? So do we have multiple applications for it? What will it cost to us? This is a most important decision. What has it earned or will it earn? So is there already an expression of interest on this technology, or there is a likelihood that the market will be interested in taking up this technology? What business objectives does it support? Does it align with the business strategy of the company or the organization? Who is it using it and how? So what is the end product, the value proposition? Who is using the product? So the technology may be related to a diabetes drug. So we may find many people there who may be end users of it, or who may be supplying it or manufacturing it, right? Why is it important? Who else has some, and what it is worth? So when we say worth here, we talk of the value proposition considering the few years delay when we see actually the market or the results of the technology would be there, right? Very black slide, no? But yes, I'll make it simple again. So these are, I'll just give you a background. So that's a practical guide to managing IP. You don't have it in your folder, that folder here. So this reference, I'll try and provide you with the soft copy. Ashutosh, can you help me with this? I just missed on giving it to you. So basically it's taken from there only. I haven't done anything except putting it here. Okay. So step 1 for managing IP is ensure that every employee from CEO, CFO and board of directors is aware of the strategic importance of IP. So this goes back to making people aware of IP in our organization. Ensure that there is individual department of patent attorney firm charged with the responsibility of preparing and maintaining IP audits. Put in place a company-wide education program so that the importance of IP is understood, right? So top 3 are related to IP awareness and following the IP policy or IP strategy in the organization. Then internal strategy includes IP audit, IP policy, IP protection and maintenance. IP audit, what we do to maintain our portfolio. And to this I would recommend there's a course on WIPO, which we will share the link with you. So there you can learn more about licensing and IP audits as well. That's a free course, online course you can do sitting from your home only. Then enforcement and competitiveness is the external IP strategy. That is how we decide to enforce our patents. Are we willing to go and file for infringement suit against whosoever is infringing our patent, right? And the kind of competitiveness. Then step 4 is that book value should be placed on all company IP, and this value should be reported. Whatever IP is there, it should be reported, and a certain value should be assigned to it. Expiration and renewal dates of all IP should be managed, independent watching and reporting services considered. That means each IP has to be monitored for its validity as well. Expiry date for patents has a separate mention. Company trademarks, brands, royalty payments for both in and out licensing, that somebody might have taken a license from us but he's not paying us back. So that also needs to be monitored. Undertake a full audit of all your IP and place a value and grading to its importance. So generally it can be say a 5-star, 3-star sort of thing, right? What is most important. Then This can generate good revenue streams from IP that is not in use. You can just put it off shelf. You can start paying the renewal fees. Then seek independent advice from a patent attorney through IP search agent on the management and enforcement of IP. That means you can start infringement activities, tracking infringements. Okay. So it's a very simple scientific quote amongst everything related to IP. So if you give me a lever of sufficient length and a fulcrum in the right place, I can move the world. So here the lever of sufficient length is the background information we have about a subject matter, and the fulcrum in the right place is the IP database we would be searching to make meaningful information out of the database, which has lots of information there. So this is just a pictorial representation that there's a patent coverage, we have the business advantage, and the competitive environment is like this. We can go anywhere, right? So those who are, so yeah. So a question I asked today was a way from NCL innovation to railway station, right? So I could see here 3 options. So any comment on these options? Distance, yes. What else? 4.9, 5.4, 4.6. Time required, yes. What else? Congestion. What else? Okay. What if I'm here, like I'm here, suppose in NCL, I'm in NCL, I'm typing this in NCL, right? So for me, the best option would be this route should I take, right, instead of these 2 routes, right? So this is asking right questions. So if I say NCL innovations to railway station from or through NCL or through Dr. Homi Bhabha Road is a better question or not, right? So this is a simple thing which we know about. But in a patent document, in a patent database which is being added by voluminous information every day, single day, we may end up getting nothing out of entire information if we don't ask the right questions, right? Okay, now, so I chose the first way because this was closest to me. So these are the options again, right? So how do we choose them? We may have something very heavy with us, right? So we will prefer to travel by a car, right? If we are health conscious, we would prefer to walk, right? If we have a bicycle only, we will cycle down. And like if we have options, we can have an Ola or Uber or any hired cab as well. So what are these options actually for us? Urgency, requirement, different ways to get, which all depend upon what we need. So basically what we need here is IP strategy, right? So what is our IP strategy? What are the questions in our mind for which we are scanning the databases to get relevant information for it, right? So now with this we come to patent landscapes. How is this? Very crowded? Easy to go, maneuver? Worth doing it? Would you do at 5:30 or 6 in the evening? How about this one? Huh? It's a better one. How about this one? Even better, right? Detailed. This one? Less of reds.
Yeah, but it also indicates some other avenues, you know.
So that's a finer representation, agreed, right? It's also representing that's a better way, and these reds are reduced. The traffic congestion is reduced, so we may reach our destination quite earlier than we expected otherwise, right? If we took a different route. Okay. So the way we see it, this is a normal like Google map representing our journey for a company which is looking for certain answers from patent database. This may represent a patent landscape report, which I will discuss like in few minutes. So these landscape reports, or in general any report which is being commissioned for patentability or FTO, so everything is relative to the kind of question and who is asking the question. So an individual asking a question is different, a government asking a question is different, and an intergovernmental organization asking a question is different, right? So just from just a vague example, like we may not like to go into crowded areas, so a company may decide that it is very difficult to go ahead with such crowded areas, so market entry is restricted here. We will prefer another way of entering the market. So one thing we discussed in the IP strategy, that we have to offload the IP which is not no more relevant to us or which is not aligned with our business strategy. So here it goes. So company products and services may have patents there. So company products and services, now they have still have some overlapping patents over a period of time, but eventually we see that the company products and services and patents are delinked. Right. So again, what has to be done from an IP strategy point of view or portfolio planning point of view? We have to go back to the drawing board, see how our business strategy or IP strategy, that to internal and external, will be aligned, and how we need to realign our R&D efforts. So the tools to do so would be patent landscaping, innovation capture, patent acquisition, IP health checks. So landscapes, now we finally come to landscapes. So what's a landscape? We just saw, right? So that was a normal landscape which we normally see in our phones and then just maneuver through. So this, when we talk of pattern landscape, so that's a pictorial representation of describing or interpreting is a research process that creates an overview of the patterns that are pending or in place in a particular area. Can help companies decide where to focus their research. Areas of high like competition, companies may not like to go, or big companies may like to like buy out companies or patents in that particular area itself, right? Then a landscape contains a snapshot of the patent at a particular time of a specific technology, either within a given country or region or globally. Right? If we are looking at various markets worldwide, then we may look at it globally, or we may look at even like say India or US or EP, wherever we feel that a potential market is there. So now we would discuss 5 W's and 1 H of the landscape. So the interest, basically what is a landscape? So that's a EPO definition here. Pattern mapping is essentially the visualization of results of statistical analysis and text mining processes applied to patent documents. How WIPO defines is, a patent map is the visualized expression of the total patent analysis results to understand complex and various patent information easily and effectively. Right? Anything, that's a common experience we have. Anything which is like pictorial helps us to understand better rather than such busy slides. Had it been small here and there things, you would have appreciated. Like this itself says, no, it's just not worth going ahead. So Japanese Patent Office describes current, this definition is very, very important, and everywhere normally we see this is quoted otherwise also. So current technological development necessitates conducting searches of patent information to avoid unnecessary investment, as well as gaining the seeds for technological development and the applicable fields contained in the patent information. In order to accomplish this, that is reinventing the wheel and investing in it, the visual representation of related patent information, hereinafter patent map, attracts the attention of the person concerned. A patent map is produced by gathering related patent information of a target. So who defines the target is important, and what is the target, that has to be understood. So why do we do a patent landscape report? So as a startup, you would like to know whether or not there are technology gaps, as Jaya told today, to identify the technology gaps and maybe try and fill it with your R&D, right? Then an investor may look at a landscape and see which areas have already got funding or which technologies would mature in coming, say, 10 to 5 years, and they would like to invest in those. So there may be like relative questions from each side. So a patent landscape can help companies develop their business plans and research and development strategies. Patent landscape can provide companies with information about how likely they are to get a patent approved. Helps companies to understand the intellectual property risk involved in the research, that is the likelihood of that another company will claim ownership of the same technology. So if that's a very crowded area, you may end up sort of infringing somebody eventually. And suppose you have a product and you want to launch it. So the normally what the companies do, they do a FTO. So they do a FTO, or they do white spaces to see if any company has already launched, or there's a product in the market already there which may be overlapping with their product. So sometimes as a strategy, they sort of earmark certain patents which may be infringing, and not right now, but eventually when they actually launch the product, they go back and check if those patents have been commercialized and the products are already in the market. So that's a job done like over a period of time. So they keep monitoring what are the patents, what is the technology in the market, are there any related products. So this is an extremely important exercise before you enter the market. Otherwise, we may end up paying money during the infringement suit eventually and just getting no profit out of whatever we have invested in the IP. So then the landscape reports helps us to assess risk, freedom to operate, product clearance also. Information on technological solutions, like new technology, new uses of our own technology we may find there, right? We may find technology gaps in the patent specification itself. Identification of business opportunities, that means somebody else may have some technology and that might complement your whatever IP you have. So you may like to talk to them for further collaborations, etc., which generally happens. We have seen that happening. Then comes the competition analysis, that means patenting and internationalizing strategy. So if you remember the chart which Jaya showed, you saw the priority date and the kind of companies they have been filing in, right? So you know that these companies generally are the areas or the market for such inventions. So if you are dealing with the same technology, you would like to go ahead in filing in those countries as well. So that gives you sort of flavor of what kind of market exists there. Analysis of technological trends, monitor research collaborations in technology area. So generally this is very, very important. Monitor the area of research collaborations and potential white space in the marketplace. So big companies generally spot one, they start working and they keep the basement ready, the basement of the building I showed, wherein the trade secrets, know-how, etc. rest. So that's the strategic things. So again, the question depends like who is asking the questions and why do you need a landscape report to be done. It can be global efforts, it can be regional efforts, it can be national efforts. So these are very, very top level things, but what we are looking at right now is the investment opportunity. So people may look at landscape report and see like what kind of research is being funded currently, what is the trend, what is the investment opportunity, then competitor intelligence, what are our competitors doing, where like Apple would like to know where Samsung is filing, knowledge transfer and geographic profiling, like which country has more patent filings, etc. there. So these are the various objectives which can be achieved by a technology landscape. One is the patenting activity, of course, like whether or not your work is patentable, major companies and universities which may be working in a particular area, the key patents, the top 10 patents, the new players, new collaboration networks, exploited fields or rather exhausted fields, uncrowded areas which can be potential, new entry areas for bigger companies, in licensing opportunities and out licensing opportunities. So how do we do it? We gather the data, coming up with the alternatives, developing the intelligence, and then bringing everything down to concise results, forming an opinion and developing a hypothesis. I'll show you the example. So we tried to do a little exercise with two companies. So how do we scroll down with this? Do we? So whatever I told you. So everybody is aware of IPCs, International Patent Classifications? Okay, just let me tell you very quickly. They are sort of index of the kind of technology your patent is being filed in. As soon as you get your patent application received anywhere in any patent office of the world, they will give you an IPC. Now a CPC, which is a cooperative patent classification, which is internationally accepted, right? So we did, so that indicates the sort of core technology in which your patent application is being filed. So I tried to, with the help of Pradina sitting here, I tried to compile this. Major filings of HP, Canon and other players which emerged during this area. So, in this particular year. So, 1988 we find that HP had no patents. Okay. Canon had patents like with this IPC B41 which relates to ink supply systems. So, these numbers are also important. So, another couple of patents were there in preventing or detecting of nozzle clogging, cleaning, capping or moistening of nozzles etc. characterized by ink handling. So, you understood what IPC is, right? You are getting my point? Okay.
Something like trademark classification?
Yes, but this is a patent classification. So, depending upon technology, they classify your invention with respect to these. So, it will accordingly go to those examiners who are expert in those fields,
So
right?
Class of the trademark.
Class of the trademark in this, more or less, right? Okay. Then we see Canon also had patents in articles, guides or smoothers and all this. Okay. So, for then this class also this particular classification evolves in case of Canon's portfolio, which is for exposing, that is image wise exposure by optically projecting the original image of a photoconductive recording material. So, this is a IPC classification which exists. Those who are attending the track to tomorrow's talk will get to know how to do all this, but just now, just for understanding sake, please just take it on this only. So, example digital copiers. You getting my point? Yeah. So, Canon is emerging here in digital copiers, 1988. So, 98 we see HP has started working here, B41 etc. right? And we see there are some new companies coming here, right? Here you see here. So, these are the new players coming in, and this is just one type of analysis we have done. Okay. So, 2008 we see that HP has diversified, Canon has further, so here, then we see all these are Japanese names. So, who is filing in like printers, copiers etc.? Had your invention related to something, some cartridge or some printer or some copier, where would you file? In Japan, first priority, right? This is not the whole sum. This is just one bit which I picked up to explain things to you, correct? Okay. Then you see 2018. So, this is a new, this is a further diversification which Canon is experiencing using a processing cartridge, whereby the process cartridge comprises at least 2 image processing means in a single unit. So, this if you go back and see, this particular patent would relate to cameras also. Duplex is done, it's here. So, this relates to, this one is here also, right? So, this relates to camera. So, we know of the presence of Canon in camera, right? So, this is how we see the technology evolving, and then a toner pattern or a powder pattern is also emerging. So, and again if you see here, so these are again all Japanese applicants, right? But they may have their offices in US too, right? So, we have, this is not the whole picture I am showing. This is how much you can like assimilate in one talk of 90 minutes, not more than that. You cannot absorb things. So, this is one example I have shown how one particular information bit on patent information can be, patent document can be used to predict the technology evolution, kind of information which we get on the product development line. Similarly, we have done analysis on Apple and Samsung as well, but it has not turned out to be that well. But Deepthi, anyways, thanks for that. So here the conclusive thing what I found was, so 1988 Apple has no patents, then nobody has any patents too, right? 98, Apple has 58 patents. 10 years, 58 patents. And if you look here, the IPC relates to arrangements for executing specific programs, digital output to display device. Digital output to display device, what's that? For producing a permanent visual presentation of the output data. Then pointing devices displays are positioned by the user, mice, trackballs, pens, joysticks. So this is the touch, yes. So it's coming from there, okay. And then if you look here, the new brands, and here if you see, look here. So this is the same period where GSM was, right. Then there was one important Mitsubishi's here. You'll see a trend later. So again, if you look at the number of patent filings, now 2008, 2581. So it has increased many-fold. And how many new players? Almost none. Almost none. Now in 2018, 7488. No, we are still ahead. Okay, then you come, now we'll see Samsung. So in 1988 itself, they had 836. Now look at the umbrella of the companies, right? How good are we doing on time? Okay, still some time. Okay. So 1998, if you 1998, just look at the number of filings, right? New entrants. Hitachi is there. This is there. LG is there. British Telecom is here. So if you go back and see these patent applications, you would find couple of merger and acquisitions as well. This is an interesting trend. So 2008, number of filings. So now tell me, if you would have to invest in this industry, say related to phone, etc., would you do it right now? Do you feel it's already exhausted? Yes. Suppose if you have to build upon something new, you want to collaborate with somebody, right? If you have this particular table before you, with whom will you do? Samsung, very good. Quite hopeful.
The other players.
Which players? Name one. Large, I agreed. But why would large player would be happy working with you? You must be bringing something something great on the table. Yes. So in that case, can we look at these? No.
Academic.
Yes, that's the option. Actually, I especially looked at this. So this one, Electronic and Telecommunication Research Institute. This one, academic collaboration. So these are likely to work with you if you propose something really good, and provided you have that kind of patience. So this is one bit of information again which you can pull out from the patent database and patent related information. Is that okay? Okay. So I told you that I would be showing you one IP strategy. So there are a couple of patent reports which there are two which have been given to you in the booklets which you have. If you, in case you haven't seen, just see there's some related to stent you have already. And for those who are not attending that track 2 thing, for them I tell you that all this information, how you do, is there in the first 2 compilations related to WIPO, which helps you to search and how to use the patent information. So you can just go through and it's still doable. Okay. So this is the, like I was telling this, the Japanese company's intellectual property strategy, which we discussed initially broadly. This is one example I want to show. So our code, protect IP, mission, values, code of conduct, That means the business strategy. Maintain superior competitive position. Ensure business flexibility, that you can always go back to drawing board and address the market needs, customers' needs. Secure business profitability. Okay. The key thing which I have been telling is linking IP strategy with business strategy. So linking business, R&D and IP strategies. So business strategy, R&D strategy, all comes down to IP strategy. So the key 5 points which Fujitsu majorly maintains is secure, maintain, utilize rights, which may be patents, trademarks, industrial designs, copyrights, as per the continuum theory we discussed. Measures to ensure respect for rights, including those of competitors, that is the key thing. Carry out thorough management of information, including trade secrets. Everything has to be brought on the table and value has to be assigned to it, so that people don't feel that no, it's just a booklet. No, it's a booklet with information. Actively engage in external policy making activities. So you may be working on something which may be outdated because of some policy later. So you have to be in sort of a dynamics with those policy makers as well. Cultivate and maintain strategic human resource. This we will not discuss. So these are some of their key focus areas which they have been working on. Linked to business and R&D strategies is like palm vein authentication device. So this is established at priority area for securing patents. And if you note, actively working to secure rights for use of technology in such applications as bank ATMs, room access control, e-government services, digital medical records and travel systems, right? So their potential customers would be government. So they may have a patent on top of everything, but there may be a baseline know-how related to everything. So that authentication system cannot be compromised by those who should not be doing it, right? So that's the IP strategy. That may be the IP strategy, that's what I guessed. Then, Then is the next generation networks. This is like 2016, so we see 3.5G here. So we are already talking of 5G. Semiconductor for miniaturization technology. So basic stance on patents. So again, patent finds a separate mention out of the other forms of IP. Obtain influential patents. That means we have to have strong patents. We just cannot have frivolous patents, right? Then obtain patents that impact competitors. Either they are forced to take license from them, or their market barriers are there, so they cannot enter the market without taking permission from them. Increase patent hold overseas. So that's a multinational company, so they have to have patents in various countries as well. Utilize patents, don't sit over them, utilize. Actively utilize patents in our business, increase income from licensing royalties, avoid infringing on competitors' patents, that's underlying things. So somebody may be doing it, but we as a policy will not infringe somebody's patents, right? External strategy may be linked that they will sue the person who's infringing their patents. So this is another use of, so this is the portfolio I was talking about, right? This is the global patent portfolio of Fujitsu. Issued patents 40%, pending applications 60% out of approximately 81,500 in total, right? So this is the split. These are like pendings. These are issued in Japan, North America, Europe, Asia. It may be India, China, etc. here, right? So this is the split of what patent portfolio which Fujitsu holds. So their strategy is to increase their overseas filings. So if we see, these are the Japanese applications and these are overseas applications. So number is ever increasing, like European and North America, US applications have increased, right? So this, they come back to IPC classification. The evolution of research in that particular organization can be always be assessed by IPC primarily, just to start with. So if you see this G06 we just discussed, which is digital data processing. In the published applications also, 27% is this, 25% is again here the electrical digital data processing only. So their basic portfolio is related to electrical digital data processing itself. So we go back to the key areas, the Wi-Fi, the GMAX, and the 3.5G, etc. So that's there. Then transmission of digital information is another big portfolio for them. And then there are little bit bits here and there wherein they may be trying to get hold of the markets, or they are like initializing their efforts there. So efficiently obtain patents in priority fields, like what is their priority and how well they have got the patents granted. So efficiently means how well they have got the patents granted and no sort of in this oppositions, etc. So G06 is their priority area. This is how they have got the patents granted. This is their strategy. There is a master company which will absorb everything, umbrella company, and these are the Group A, Group B, Group C companies, which are subsidiaries, right? And they all own their separate IPs, but this is a major umbrella which will protect them against anything else. So again, this IP strategy, as we discussed, when we say that this is a cost saving strategy, then they come to like make people or the employees aware of their IP policy, importance of IP, how they can commercialize IP, etc. So newly hired employees, patent basics, mid-level employees, information management and IP, information management also, the work we are doing here right now, the patent landscape reporting, what is the meaning of IPCs, what information can we draw from there, and senior managers for leveraging IP, like how can we use IP effectively to generate revenue for the company.
We talked about companies, so organization structure particularly. So is it for restricting the liabilities of operating in certain areas with respect to IP to file in or to bear with the infringement claims or something like that?
No, I didn't
or
get your
area
point.
geography of operation?
When we say overseas applications.
No. When we say the subsidiary and the
So it's about all, absorbing the risks also. And then there's like certain companies may like to focus in a particular profit center, and then certain subsidiary company may like to focus on certain area of research only, right? And then they may eventually think of startups and spin-offs within the company itself. So that can be their IP strategy as well. So this is what is printed, rest we have to interpret only.
But then the prime objective of such arrangements, would it be particularly from respect with respect?
So it is like as simple as saying that we don't rest all the eggs in one hat, right? So if one company goes bust, at least some other IPs left, and other companies and other risks are also there, so that it's there. So incentive policy for inventors we had discussed initially, utilizing intellectual property. How do we do it? Strategic alliances, licensing, promotion activities, standardization, promotion activities. So it has to be a top class program wherein people are sensitized about IP, made aware of IP, leveraging IP, licensing, technology sales, intellectual property disputes as well. This especially comes into picture because of ownership issues when you are working in collaborations. So you'll get a copy of this. This is available freely online as well. Okay, so but anyways you'll get the copy. So if you see, this is what I was saying, standardization of promotion activities. Like if you go to say a collaborator and say this is like ISO certified process which I am following, or this is GMP which I am following. So this product meets all the standards. So obviously you will have an upper hand there while negotiating. So whatever activities have to be done, they have to be benchmarked as well. Okay. Another exercise. Should we do another exercise?
Can you explain the last slide?
Which one? This one? So that's what I'm saying. Establishing working group in IP department to promote standardization activities company-wide. So there should be standard. So like wherever we do it, the lab to lab variation should be minimum, and it should meet the international standards as well.
It's product standard?
Product standard. That depends upon whatever.
For the IP thing.
It's a product standard. That's what I'm saying. When I say that we take suppose a product into the market, we say it is like we are following GMP or GLPs, etc. in the lab. So we are not talking of IP standards there. We are talking of market standards there. So which everybody would respect. So landscape reports can be of like many types. Two have been shared there with you. One I have shown you. This is another one, single pager, don't worry. No, this is not a single pager, sorry. So this, as I told you, is commissioned by government, for discussing intergovernmental issues. You'll get a copy in case you're interested. So if you notice, this is also available freely online. This is a WIPO resource. So, Office of First Filing. So generally as per the patent law, each individual from wherever he or she is, he has to file in the country he has worked on, the research is generated in. So if we look at these graphs, what do we infer? What else? Yes, yes. That means the major work on ritonavir has been done in US. One inference. Like you could read graphs now. Percentage of authorities as office of second filing per authority. So we see this is WO is WIPO, right? PCT application. So we see a maximum number here. That means almost all applications have been filed as PCT as well. Right? Almost all. I'm not just counting exactly on the numbers, but this is what we can interpret from here. That means whosoever is working on those particular drugs, they are interested in worldwide markets. So a PCT application has also been filed simultaneously, apart from the first regional filings. So, most common assignees. Huh? Leading. Almost all are US based, right? Okay, now a really small one pager. Sorry, I know it's too much for you, and post-lunch session. And apologies to those engineers who are sitting here and bearing up with all this related to biotech. Okay, so just a general thing, that's why I have picked up topics which don't need too much of technology depth here. A simple reading from the graph, from the landscape report. This is again available on WIPO itself. So top 20 origins, which is a country where most inventions regarding this vaccine? US. Then followed by this number and this number. Yes.
We have to also look at which are the patents that are most commonly filed through PCT channel, and
that's a study you can do. Your database is free. So, okay. Then they have also analyzed it with respect to the BRIC countries. Top 10 applicants, I will show you. This is interesting actually. So, top 10 filers, who are the applicants? US government. That means US government is funding this area of research. Yes, that is why then only they will be the applicants. No, if they fund the research, they will be the applicants. Then followed by GSK and this Russian Scientific Institute as well. This is again a government intervention there. That means this is a high priority government area. That is why a WIPO has commissioned a report on it. Okay, so that they can discuss it centrally as to what measures can be taken so that the duplication of efforts in each and particularly developing countries is avoided and everybody can be benefited out of it. Right? Sorry?
DRDO is also there. DRDO India.
Human typhoid conjugate vaccines hai. DRDO generally we don't see patent filings. It's here.
That means health sector.
Huh?
That means health sector.
Yeah, it is there. That's why I put up this specially. And then top 3 applicants, if you notice the split, we talked of vaccines, right? Here we see the typhoid conjugate vaccines. Here we see pneumococcal and human influenza virus. And if we notice, so human influenza virus, we have total 516 applications. So if we go back and just try and see the date of filings, etc., we will find that maximum number have been filed in around 2005 onwards. The maximum filings have been done around that period. So that helps us also to assess that where the technology is evolving again, right? What is the need of the market? What is the need of the hour? So sometimes we may see Tamiflu-related inventions also being filed or in and around Tamiflu drug. Okay. So this we talked of everything related to IP strategy, then IP portfolio management, etc. Then when we as individual researchers or startups say, when we come down to the drawing board, for every invention we may need to discuss few things, which is called IP map, which is better if we maintain that right from the word go, which discusses each component of the IP. This is somewhat similar to the know-how database or know-how sort of map, which we may try and put it over every invention. So the inventor or the creator of each component. So if there are multiple parts of the invention, we have to designate who the inventor is of each part, the current owner or licensee. If it is like the organization or it is by somebody or it is in collaboration of somebody, we need to put it out there. Each link in the chain from inventor to owner or licensee. Got my point? Who is the owner, whom they have transferred, are the documents in place or not, right? So you need to have that streamlined so that all these things are ironed out before you take the technology to another level or for licensing out. Or rather, even if you are taking it in, then you need to have these things in mind so that you have an IP map over everything you are taking in or selling out or working on also. Then cross references to each supporting documents that validate each link. That means if that is an employee working on a particular project, he has assigned the rights to you as a company, right? Then if it is a co-assignee there, you have the agreement, basic agreement, which says that you will be sharing the IP rights, correct? Then the lab books, etc. also come here, such as employment contract, collaboration agreement, joint venture agreement, assignment from a student, assignment from a contractor, consultancy agreement, material transfer agreement, consent from a joint owner as well. So these are very, very important for startups. Then prior art citations, what is the background work, and the forward citations, if at all your work has been cited by anybody else. So this is the IP map, which I recommend that every invention you are working on should have to start from, so that things are pretty streamlined right from the word go. So this is the kind of the summation of the entire thing which we have been talking about for past 1.5 hours. So one is the analysis. We have the databases. We can punch in the IPCs. We can punch in the keywords. There are various ways to do that. But the key is asking the right questions. So then we get the data. We have to analyze it as well. What is the link? Like we all of us analyze the data right now. Like which is the major one? Where is the entry barrier? Which cannot be filed and all that. And then visualize it. We have to see it and report it. Report in a form which is easily understandable. And just not clutter the information together, because we have to make the data as information so that the person reading it can conclude whatever the question was posed, that whether that has been answered or not. So this is something which all of us can correlate. Stanford startup, around 800 patents, then developed data capture and scalability, filed patents on their own developments, patent filing and acquiring, we know of that. Advertising becomes core, Google, and then IPs aligned with the business strategy, right? Then Motorola, IBM patents, Android, all this goes. And still, this is going on. Why? Because the IP strategy, business strategy are being aligned and they are being reworked depending upon the changing business strategy or market needs. Right? So this is the link for that Fujitsu one. You can just find it yourself. This is something for IBM I pulled out. You can see there's a blog on IBM. If you want to read, you can just read about their IP strategy. Dr. Premnath mentioned that they have pulled up, like IP.com, they have put up everything on the website saying that this is there. You can use. Then this is about Tesla. Open source, sharing patents to speed up inventions. Then there are certain ventures at the governmental level, intergovernmental level, like the medicine patent pool, wherein people have decided to come together and work around for general benefit of all.
The DRDO.
DRDO?
The DRDO also offers not many patents.
Yeah, but DRDO as a policy doesn't patent everything they are working on.
But the toilet and all is
Yeah, that's a general thing. But there are areas of national interest wherein they avoid filing. So that's their strategy. Yeah, any questions?
Madam, how to find the status of the issued patent, whether it is in force or something expired, something like that? When the patent is issued, how to count that?
So we have to calculate the date, calculate the time from the filing date, 20 years. We have to do it manually.
But if somebody is abandoned it?
So that in case of abandonment, the information is available separately on a separate database, which is like in USPTO we have this fee database where we can see that the fee has to be been paid up until certain period, and it has been lapsed, and the period for regularizing that lapse has also gone. So we may keep it on a watch list and keep watching it over the period until that period is lapsed. So generally, the people who are watching a certain patent portfolio of a competitor, they do that. So we have to calculate it manually, whether or not 20 years have passed, and in between whether or not the fees has been paid regularly.
Okay, then one more thing. What will be the strategy for invalidating the granted patent, something like that?
Strategy?
For invalidating granted patent. Let us the patent is issued and it is in force also. How to invalidate that patent?
So in Indian law there is a provision called the revocation of patent, which we can do. In US also there are provisions. In EP there is a post grant opposition period for 9 months wherein you can revoke the patent as well. And US, I think you can tell more about the US invalidation proceedings.
Yes, there is also a 9-month window in the USPTO, which is been a recent change after the AIA. So it's open for 9 months after the patent is granted. And there are also re-examination and inter partes proceedings that happen. But per se, a patent cannot be invalidated in a court of law by the USPTO. You have to file an appeal and then take it to the court for getting it invalidated.
What are the different grounds for invalidation? Let us say somebody wants to challenge the patent, granted patent. What are the different grounds?
If you can prove that there is prior art
Okay.
that was granted before, or at least was published more than 12 months before this patent was filed for, if the invention doesn't work, you can prove that the invention
So I
doesn't
think
work.
in like India and US, the grounds are more or less same there.
Similar.
Except for in US they say that they need a written prior art document. That is why TKDL was created, right? So in India, anything related to traditional knowledge, which has been passed on through generations, is also accepted as a prior art. But still, people present prior arts in written documents as well. So working, if the invention is not working, the grounds can be lack of novelty, lack of obviousness. Then the invention is obvious. Invention is not workable as per the specification. The proper permissions were not sought for using the biological origin. Something related to traditional knowledge was used. Then the invention relates to statutory non-patentable subject matter as per the Indian Patent Act. All these are grounds.
So there is one tricky thing when we are about to file patent in defense particularly. There is something called a license review. So we have to opt for a license before, or
Which license?
so to apply for a license patent pertaining to defense.
Oh
Anything.
yes. So generally, section 3 says anything related to, section 4 says anything related to atomic energy, etc. has to be taken permission of, but they have to be informed in advance that this may be related to, and patent office separately assesses that and sees if it is of national importance, and in case it is, no patent will be granted on that.
Any only just related? It's just related to atomic energy or anything pertaining to defense.
Defense related is also.
Okay, then anything with respect to this e-governance or any other channels or any other security
Defense
forces.
And atomic energy, that too 6 elements which have been notified in Atomic Energy Act of India.
Okay.
And they are updated regularly, so you need to see if your invention is covering that. Then there is a strict no from patent office. If you indicate this is related to defense, they will assess that. They will keep it aside from normal processes, and unless a decision is final on that, a patent will not be granted.
But let us say invention having something like dual use application. In that case, the invention is something like dual use application. It is can be used for even civil application also, other than the atomic energy.
So again, that's the way how you present your work, right? But again, if it is related to defense and government it is also related to defense and government feels like it is related to defense, they may take it over. The ownership can be taken by government.
But I may file application on the civil application basis.
There is no civil or defense application.
No, I will not quote that it is for the defense application. I will say it is for civil application.
That's what I'm saying. But you also ask for infringement, right? So if somebody says this is under section 3, section 4, or it is related to defense against certain laws, they can revoke your patent as well, and a government can take that invention. That's it. So you may not tell it, but even if somebody interprets and lets government know that this is related to defense and this is happening, they will say okay.
Intended use is what?
Huh?
The intended use is what is taken.
Intended use is taken. So you may not write it there, but yes. Any other question? Thank you so much. So in case you have any queries, you can write to me, and the databases, etc., whichever are used for landscape reports, and actually tomorrow's session we will be doing one landscape.
Is presentation shared by email or what?
Nikita, what is the plan? We will be sharing with email, or what?
Your presentation. So we'll have everything up on a restricted website. Those passes will be sharing it to you by tomorrow. So you can view everything.
So you'll get all the things.
You can get it copied to printer also if you need.
No, it's going to be on a restricted website.
Which will be available only a certain period. You can download it, save it, but no pen drive business. Okay, thank you.
So we'll be breaking for tea now, and we'll be back by 4. But a few announcements before that. We have an open house from 5:30 to 7. That is to discuss your discovery of key needs that you have. So you'll be meeting a mentor for a slot of 10 minutes. I'll be giving you the slots, and you'll be meeting the same mentor on day 3 to carry forward your queries or your concerns. So today is just going to be a very brief meeting to discuss what queries or concerns you have. And we have dinner after that at 7 p.m. Everybody is welcome to join us for that. And please get your laptops from tomorrow, because we'll be working on your presentations. I'll be sharing the templates that you can use for your presentations by tonight. So if you can download it and bring it tomorrow, it will help you with your work from tomorrow. Thank you.
Okay, let's get started. So thanks to Venture Center for the chance to share some thoughts on this topic. My name is Kaushik Gala. I work with the intellectual property group at Tata Consultancy Services in Mumbai. I have had some experience with IP and licensing strategy at TCS and other companies in the past. So, this is not working, it seems.
I think they are not using it for volume. They are using it for recording.
Oh, okay. All right.
Do you want a mic?
Actually my throat
Can I
is a
use
bit,
mic with it?
it will echo. Okay, I'll speak louder, no problem. Okay. So what I'll do today is, I actually have a lot of slides, and the plan was that I would like to expose a lot of concepts to you that hopefully you can go into deeper in the next 3 days with help from the mentors. Because I think there are a lot of aspects to IP licensing and strategy which at least at a high level you should be aware, and then if we don't get a chance to today to get into depth, or if I can't answer all your questions, then some of the other faculty members including Premnath can do so. So consider this kind of a whirlwind tour of IP licensing. Okay. So this is the outline that we have. So I'll start with TRLs. You may be familiar that TRL stands for Technology Readiness Levels. So this comes from the space agencies in US and Europe, this notion of technology readiness level that if you want to build something that's going to go into space or something, then you have to do it in a very proper stepwise fashion. So you do some research, try to prove whether the technology works, then do some POCs and so on and so forth. So we can consider using something similar for science startups and ventures. But then since we are talking about IP licensing and commercialization, just talking about technology readiness level is not enough, right? You have to talk about market readiness levels also, because you are finally wanting to commercialize the technologies that you are developing. And so you could think of market readiness levels as something like this. This is just illustrative. The actual readiness level may be different if you are a biotech company or a software company or so on. But the point is that again you have some idea, you do some proof of concept, and if the proof of concept works, then you try to create a prototype of the product, and you do some pilots with some early customers, and then I'm going to use some phrases here from the Silicon Valley startup world. If you're not familiar, you can interrupt me. But product market fit, this is a phrase from the Silicon Valley startup world that I have a product, does it fit the market? And it's considered an important milestone in the journey of a startup, including science companies. And then whether I have a valid business model, which means I know what to sell, whom to sell, at how much to sell, how to sell, and I can repeat that sales, and I can generate certain revenue, and I can generate profits. So that's sort of a notion of market readiness level. And the point is that the technology readiness level by itself may not be sufficient, since we are in the commercialization business. And invariably you are going to have to raise capital along the journey, and so investors have their own notion of something called investment readiness level. So I have taken this from again a person in Silicon Valley who runs a very useful blog. His name is Steve Blank, and he was one of the early proponents of what is called the lean startup model. And as is the lean startup model may not apply to science, but he has put a lot of effort in making that relevant to science startups, whether it is biotech startups or material startups. And in fact, he's even figured out how this might be applied to innovation that happens in Department of Defense and NASA and so on. So it's a interesting way to think about it, that investors have their own notion of whether you are ready for an investment or not, and this is what it might look like, that do you understand the market, do you understand what the problem is being faced by your potential customer, and then are you working towards that, and is there some product market fit, and is there a revenue model and so on. So one of the things you see here at the very lowest part is business model canvas. I don't know how many of you are familiar with this. This is again a tool that has been developed as part of this lean startup movement in Silicon Valley. It is just a template, but it is a useful way of capturing what you think about your company at any given moment in time. So if you haven't had a look, just Google business model canvas, and it basically talks about all the various aspects of a typical company at an early stage, and it's categorized in 9 categories. And the way to read or fill the business model canvas is from the right to the left, right being the market or the customer, and left being whatever R&D or IP or technology that you have. So it's a useful tool like any other tool. It does not necessarily capture all aspects, but it's useful. So how mature that business model canvas is in terms of understanding your business, that's the investment readiness level. So the point of behind all of this is that when you are trying to develop some technology and then commercialize the IP, you are dealing with uncertainties, and primarily there are 2 types of uncertainties: technology uncertainty and market uncertainty. So depending on which uncertainty you are facing, you have to use the appropriate method to deal with that. So if you look, for example, in the top left hand corner, LSM stands for lean startup methodology. So why this is relevant for software startups is because the technology uncertainty is relatively low. If I am developing an app for food delivery, chances are I will more or less be able to develop the app, but being able to make money out of it is very, very difficult. Whereas if you look at something like space, then market uncertainty is not much, because the government is funding it because they want to send something to the moon or Mars, but the technology uncertainty is huge. So you use a very robust stage gate model, which is what that TRL talks about. And I think for science companies, for a lot of you in this room, it's sort of the worst of both, because there is both technology uncertainty and market uncertainty, right? And so that's why we call lab to market, and it's not an easy thing to deal with, and hopefully I can share some concept that might help you with it. So lean startup thinks of things like this, that if the problem I am solving is taking a person from point A to point B, then I should first provide them a skateboard, then a cycle, and then a car, instead of trying to assemble a car from day one, right? So this idea is okay, but if you imagine Elon Musk and Tesla, he didn't think like this, right? Otherwise he would never have an electric car. So then there is a evolved version of thinking of this, that okay, if I understand the problem that I am trying to solve, then instead of just focusing on features or what benefits they might bring to my customer, can I think about finally what value the customer wants. So at the leftmost, if you see, which a lot of people who are doing first time technology startups tend to do, is that I have this cool feature that I have developed, rather than thinking about what value am I adding to the customer. So can you go to the other extreme, that can you create value for the customer without creating any features, right? Again, I mean, useful way to think. I am not sure how much it is relevant for pure science and technology companies, but to give you an example of what this might be, you might ask that how can I deliver value without creating features. So if you have heard of a company called Airbnb, anyone has heard of Airbnb, right? So Airbnb uses a software to match people who are looking for a place to stay with people who have a place to stay. But the way they got started was the two founders used to go in New York from door to door and knock on people's door and say, do you have an extra bed or extra bedroom, and how much will you rent it for per night? And then they would turn around and have a phone call, and they have a number where you could call and say, I want a bed or a bedroom in this area. So they were delivering value from early days without having any features, because there was no software, they were doing it manually, right? So consulting is an extreme example of how you can deliver value without any features from a product point of view. But again, I want you to be familiar with these concepts, but also not get carried away too much with the hype, because some of this is probably more relevant for software than science, right? And you can decide where you fall in there. So science startups are more like this, the famous valley of death, right, where you have put in a lot of money, lot of time, Lakshmi hai, Saraswati nahi hai types. So let's talk a little bit more about this, that it's not so bad, because if you look at, for example, biotechnology, it's not that if you are creating a new drug molecule, you are going to be the company who is branding and packaging that and selling it into the market through hospitals or pharmaceutical stores, right? There are a lot of milestones along the way that you can aspire for, and invariably when you have such a complicated capital driven business, rarely does the same company do everything, especially a startup. Usually you will start at a very early stage, and then at some intermediate point you will probably end up licensing the molecule out or selling the company as a whole, and someone else will take it from milestone C to milestone F, and then it will be some Merck or Pfizer or someone who will eventually end up taking something at say phase 1, phase 2 and selling it. So rather than think of technology readiness level or market readiness level, I think it is better to think in terms of value inflection points, that today I have a company or I have some IP that is worth so much, what is the next milestone that can meaningfully take my value to the next level, 3x or 10x. So what is that inflection point? Have I defined it well enough, and am I working towards it? So if you, this is again from the same Steve Blank blog, that he lays out that how a typical biotech or drug discovery journey works. And obviously the same startup cannot possibly, or it doesn't make sense to go through this. So how do you say that, okay, I am at the very first stage on the left, and I need to raise some money, and can I get to the next stage, and my company is worth 3x or 10x, and then at that point I will take a call that can I, or do I want to raise the next round of funding and take it to the next one, or do I have an exit opportunity along the way? So thinking in terms of value inflection points, again, this may not be relevant as is to all of you, but this is probably the best way to think to deal with this combination of market uncertainty and technology uncertainty that you might be facing. In digital health, the things are less complicated, take less time, take less money, but even there are relatively well defined value inflection points, and what's the right time for me to exit or license out, given my resources, given how much capital I have, given how much time I have put in, right? So hopefully the message you can take away from here is to think in terms of value inflection points and defining those very well for whatever you are doing. Now let's talk about technology assessment. That okay, you have some idea of value inflection points, but when you are now trying to go and license this to someone or commercialize the technology or sell the company, then the person sitting on the other side, how are they going to assess technology? So this again, I have created this sort of taking a combination of what generally is used in the defense and space world, which is a very well defined step by step. You can see things like field trials and subsystem integration. This comes from the defense world of things. So it's a good starting point. Again, space and defense are different in that they are not as worried about commercialization, and so we cannot use this as is, but it's a good way of thinking that this is how technology starts getting assessed. That if you were trying to sell a defense or space technology, the questions you will be asked are more going to be that okay, have you done field trials or have you done system integration? But again, coming to the startup and commercial world, probably the way technology is going to be assessed is not just going to be in terms of does the technology work and does it work at scale, but many other aspects, like probably the first one is going to be how big is the market. Do you even know which market you are targeting? Do you understand your customer and their problem, and how many such customers are there, and how fast is that market growing, and what are the economics of that market? And I'll come to that a little bit more. And then of course, what does the competition look like? Is there one dominant player against whom you will have to go up? Is that dominant player known for asserting their patent portfolio against startups? So a lot of those aspects. Then of course the technology, and then intellectual property. How strong is the patent portfolio? How does it compare with the IP landscape out there? I'm assuming there was a morning session on IP landscape, so understanding the context for that. And then last but not least, for any science and technology company, that how much capital expenditure is required and other expenses required, and is the investment ecosystem out there available to support it. So for example, if you look in India today, how do you see how many angel investors and VC funds in India will invest in science companies, right? May not be as many as compared to say the east coast of the US. So being able to understand that if I am going to start a drug discovery company out of Pune, then I need that supporting ecosystem also in terms of investors and co-founders and so on. Another way to think about technology assessment is that technology is finally a means to an end, right? Technology by itself has no value unless it solves a problem, and eventually all problems are consumer problems, right? Even if you have a B2B company, finally someone at the end, there is a consumer. And so if you think in terms of features, capabilities, benefits, messaging, this is a very marketing view of things, that I have certain features, so I can make this new material which can withstand high temperatures, right? Which enables certain capabilities, that I can insulate certain type of material in some plant, which brings certain benefits. So it improves the safety for my customer, or it reduces energy loss, or whatever it might be. And am able to communicate that value to my customer, that look, with my material you can create a high temperature insulator which will save energy loss for your boiler, which this is how it will reflect to your top line or bottom line. So another way to assess technology would be that what kind of comment can I make about your technology today? Is it just at the feature level, that look, all I know is that I have made some material that can do this, it has some unique properties, but I have no idea what capabilities it can enable for someone, or what value it will create for my customer, and how it might affect someone's revenue or profits. So I suggest that rather than reinvent the wheel, this is a wonderful way of using a tool for technology assessment. It's called Quick Look. It's from the IC Square Institute from the University of Texas, Austin. You can find a sample Quick Look report on the second link. And if you see, there are a whole bunch of questions that they ask when they are trying to assess a certain technology, either for doing a commercialization deal or doing an investment deal. And if you can, I don't know if you can read the questions, but on the left, a lot of questions are around what is the problem, right? Who is facing that problem? What are the current ways the problem is being solved? Is it a vitamin or a painkiller? Means, is the problem really painful, or is it something nice to have, and so on. And then here there are a bunch of questions around how reliable, how scalable is the technology, how many proof of concepts have been done, and so on and so forth. And then a lot of questions around, okay, today what price points are the alternatives being sold at and so forth. So what is most important about Quick Look is it is entirely based on interviews. Okay, so if someone is doing a quick look assessment of your technology, basically they are talking to 20, 30, 40 people with this entire set of questions and trying to get answers from the market or from the different parts of the ecosystem, because just sitting on Google doesn't really help you understand what a technology is in terms of a commercial potential. So this is very powerful tool, and you should look at, and luckily I found a sample quick look reports. Those are not so easy to obtain, they are quite confidential, but there is one in the public domain, so download it before it goes away. But very detailed assessment of a technology from a commercial point of view based on real life interviews. These people all would have spent 1-2 hours on the phone or in person answering questions, and then if they don't get sufficient information, then you can do one more round of that, right. So you are collecting a lot of critical feedback, may not be very pleasant to hear, but at least it's coming from the market. Now another way to think of assessing a technology would be to say that, okay, what is the business case for investing in this technology, right. So the moment you say business case, that means how much revenue can I make from it and how much is going to cost me. Now you might think that, well, I am very early stage technology, I have no idea how much revenue can be generated or what it will cost at scale to sell this. But if you have to really assess a technology, then that's finally this is what it means, right, because technology is a means to an end. It's going to be incorporated into some product or some service which is going to be sold to someone at some price. And so being able to do this exercise at this level of detail, that if I want to calculate revenue, I need to know how much my price is and how many customers I'll get, which in turn means that I need to know how many customers are there out in the market and how I'm going to reach them and how many of them can I expect to capture, which in turn means that I need to know how much I have to invest in production, sales, marketing and so on, and which in turn means that my technology has to go on through some proof points of prototypes and pilots and so on, and for that I need a team, both on the commercialization side and on the R&D side. So being able to answer these questions is very important. You may not have all the answers on day one, but thinking about all of those questions is very important rather than just thinking about this or this, right. And so let me take this opportunity to clarify certain concepts, because I have found that there is a lot of confusion about business case, business plan, business model and so on. So this is my view of things, that business case is you are trying to answer why should I invest in this, what is the financial justification. So as I showed in the previous slide, a very spreadsheet driven view of things. Business plan is something that typically a large company will do, although we hear it in the startup world, when relative uncertainty is low when it comes to both the technology and the customers. Business model is more about dhanda kahan se aayega, who will I sell to, at what price point, how, through which channels and so on. And business development is an act of doing something. It is the act of creating value and then capturing that value. So because my next section after this is marketing, I'm talk a little bit more about business development, which again in the science technology startup world people think of it as ki koi to aur aake karega business development, right. But very important thing to do in terms of commercialization, and business development is essentially about building relationships. It's not sales, you call 100 people like we get calls from Airtel or Vodafone or something. It's about building relationships. So you might be building relationships with the CTOs or the R&D engineers of your potential customers in the early days, and slowly you start building relationship with the technology scouts of those companies, or first you are building relationship with the junior people in some venture fund, and then you start building relationships with the partners in the venture fund from whom you want to raise money, or you are building relationships with some DBT, DST initially when you think you want to apply for a grant, and then you are building or leveraging those relationships. So very important aspect of IP licensing in my opinion is business development, which to put it very simply is about building relationships with all the various people in the ecosystem who you need to make that commercialization happen. So now let's talk a little bit about marketing, which is kind of, business development is overall this umbrella, and then you are doing a specific marketing activity, and then you are trying to do sales. So our first question is, why bother with marketing, right? Why market technology? So market, as I said, market is generally about consumers. Those consumers require things like infrastructure, energy, healthcare, whatever. And in order to fulfill those needs, we have to market to the industry, right? So this is a very high level context of why we have to market, because people want these things and the industry offers them those things, and as people creating IP and commercializing IP, these are our customers, but without understanding that, we can't really make a good proposition to the industry. So in India, if you take a very simple view of why market technology in or from India, right? One common example of marketing technology or IP in India is saying, this will cost you so much if you buy from the US or Europe, we can do it for 1/10 the price, right? Say some stents or some implants. Very simple marketing proposition in India. It's cheaper. As good, it also has CE approval, but it is cheaper. Or you say that, look, if you take this, you can export to someone. Today, only the Chinese company is exporting to the US because nobody else knows how to make this material. I have the technology to make this new material. India, there's no market, but US, it's a $100 million market, and you will be able to export. Or like in the software world, technology's value proposition is simply that we have cheaper labor, so there is a direct cost arbitrage, that the same person using the same internet, I can offer market research services or whatever much cheaper sitting out of Pune or Bangalore rather than in the US. But what's important I think in the science and technology world is to understand the market economics of our markets. So for example, if you look on the left, the market economics of pharma is that when a drug is launched in the market and has a whole bunch of patents around it, it has a huge revenue curve, right? And then the day the patent expires, everybody is ready to come out with generics in the market. So the revenue curve looks something like that. That huge revenue for whatever that patent period is, and then a sharp drop thanks to generics. Whereas if you look in aerospace technology, this is from McKinsey study. So the curve is something like that. That when some new Airbus whatever 370 or some Boeing something is launched, there is initially big demand. Then there is a lull, because the aeroplane industry is a very cyclical industry. It goes more or less with how the world economy goes and through recessions and all. And then again there is a rebound, because now that set of new airplanes have proven themselves, they are better, faster, cheaper. So now there are another wave of orders. If you look at materials, it's kind of the opposite of pharma in that it takes forever for a new material to get established in the market, and a lot of value is captured much later on after a new material is launched, and I'll talk a little bit more about that. So being able to understand what is the underlying market economics, that today if I introduce some brand new material world has never seen before, it's not that it's going to generate revenue by the boatloads anytime soon. It is a very, very long cycle to rolling out a completely new material. And similarly, what is the cost of technology over time? So as consumers, we all know how much prices of computers dropped and smartphones dropped and so many things dropped, right? But cost of healthcare has gone up. So understanding what the cost economics of technology is over time is also important. Because if let's say I'm in the software industry or I'm in the hardware industry, if you look at, for example, drones, right? There are many companies in the US which have gone bankrupt because they were selling a drone at $20,000, and one day the Chinese company called DJI started selling the same spec drone for $2,000. Just overnight the revenue evaporated. So being able to understand how a rapid cost curve like that in technology might destroy or help your business model. If for example something like this happens to your most expensive raw material, you should be very happy, right? But if this happens to what you are selling, it's a different proposition. So talking about materials, this is one way of looking at it, that there is a certain value chain. So if I create a new material or if I create a new implant, it's not that the final person who is going to get the implant put in his or her body is my customer, right? There is a long value chain. I will sell it to someone, that person will sell it to some hospital, then a doctor will recommend it, then an insurance company will say yes, we cover this implant, or no, we don't cover this implant, and then it is put in the patient. So there is a certain value chain complexity, same thing for materials, and there is a certain understanding of the technology by the market. So depending on where you fall in this matrix, the time to commercialization can be huge. So it's a good way of thinking about if you have some technology or IP you are developing and you have to take it to the market, then you have to take the next step and put yourself in the shoes of the person who will buy this IP from you and invest in the production of the product which incorporates that IP and then has to sell to their customers. Without being able to understand your buyer's business case, it's really difficult to be able to commercialize IP, right? So for example, materials, again these are the McKinsey study. Their observation is that whenever a new material has come out, initially the only thing that has been successful commercially is very low end simple applications. So he gives some example of some material where some hula hoops or some toys were the only application for a long time. That's the only place where the manufacturer made money. And after several years, people started realizing that, oh, this is a fantastic material, I can apply it here, I can apply it there. And there were a lot of use cases and trials done, at which point people saw that, oh, this has huge industrial application. And then after another 20 years, that company could keep milking a lot of money. But initially 3, 5, 7 years, just some toy which became popular was the only use, some bouncy ball or some hula hoop or something. So it's important to understand, if you are trying to say that, okay, my IP is all around a new material, right, then you have to understand that this is the times to market and this is how these things are typically absorbed by the market. Same thing with chemicals. Is it entirely new product or technology, or is it a derivative, and is it enabling entirely new applications which people have not thought of before, or is it just a substitute for something? So where do you fall in this? And there are some useful statistics around. If you see here, people are not familiar with the technology, people are not familiar with the market or applications. Takes 8 to 19 years on average to commercialize. So how many startups today have a time horizon of 8 to 19 years, right? Where will the money come from to sustain that long? So important to understand where your technology might fall in. I'll give you 2 examples now. These are 2 companies where I have been involved in IP commercialization or product commercialization, where IP was the main value proposition. So Imperial College London, there is a department of non-destructive testing, and that person, I forget his name, he was professor there, invented some technology around measuring pipe wall thickness using ultrasonic waves. So they created a spin-off company from Imperial College London, and they spoke to British Petroleum and said, look, we have this sensor and you can use it to measure the effect of corrosion on the pipes in your BP's refineries. So basically the technology this is the sensor mounted on the pipe. It sends an ultrasonic signal which reflects, and using that reflection, measuring the reflection, they are able to figure out what is the thickness of the pipe at that location, and if there is corrosion, obviously the pipe thickness is less than what the initial pipe thickness was. So now the way this company took things to market is, they did a deal with BP that they are a university startup, right? They have no idea about how oil refinery works. So they told British Petroleum, look, you have to help us develop our product, and we will give you some exclusivity and so on and so forth. So British Petroleum said, fine, one refinery you can put your corrosion sensors in certain place, and over a 2-year period they worked with that refinery and the corrosion engineers in that refinery, and continue to develop the sensor based on feedback that, look, these refineries are out there near the sea, there is a lot of salt water, so they'll face a lot of harsh conditions. So that orange thing was developed where it's very robust. And they said that, look, typically these engineers or the maintenance staff walk by these pipes and they are wearing a lot of heavy equipment, and when they walk by they might bang your sensor and it will bend like this. So that also doesn't work. So that took 2 years, to the point where the sensors were good enough for BP to say that, okay, we will use this in our refinery. After that they made a deal that, okay, now we believe this works, we don't want you to sell it to anybody else, our competitors. So they said 2 more years we have to have exclusivity, then we will buy this commercially from you. So they sold this to BP across all BP's refineries in the world, and finally after that exclusivity period they started selling across the world. So I got involved when they were trying to sell this to Indian refineries. Now 3 years of business development with Indian refineries, at the end of which they got their first pilot order. 3 years of business development, okay, because first of all figuring out who is the right person to reach in a refinery, right? You can't call Mukesh Ambani, and if you call people 2 down the line, then they have no decision making power. So who are the right people? There are n number of people. This is a wireless sensor. It sends corrosion data back to the control room. So you need the corrosion engineers, you need the piping engineers, you need the IT engineers on board. And these refineries typically are capital expenditure of few $1 billion. You going and putting some unproven technology there, it's a huge risk. They would rather measure corrosion the same way they have been doing for years, right? So they will have to identify somewhere where they are not so worried if your measurement of corrosion is not good. And you can't just go in a refinery and put this. So they have these scheduled maintenance times once a year for 1 month when they know that petrol demand will be less. 1 month before that they will say that this is our downtime for maintenance. So you have to go and install it then. So all this takes a long time. The advantage to this company was that wherever they went, they said we have put 2000 sensors in all of BP's refineries, right? Now when you say that and British Petroleum has a certain brand, suddenly nobody asks you whether this works or not. Now it is a matter of अच्छा कितने में बेचोगे, 100 सेंसर लगेंगे तो वॉल्यूम डिस्काउंट चाहिए और एक साथ तो नहीं लगा सकते एंड सो ऑन. But it took 3 years in India, right? Despite them being a British technology startup, funded, proven the technology in British Petroleum. Now imagine that I have developed this corrosion sensor as a venture center startup, right? And I go to Reliance Refinery. Just imagine the length of the sales cycle. And can I sustain my company that long without making my first sale? This is even more interesting example. Another British company, they had this technology where they had smart meters. So today, in your home, the MACB guy comes and takes a reading, right? Instead of that, they would transmit the signal through a SIM through the cellular network, so that no one comes home for reading, right? You just get all the readings are automatically transmitted. Now this company got a order from L&T in March 2018, right? So we started business development for them in India in 2011. 7 years to get their first order, and I have been tracking this company because I have a lot of memories of sitting in MACB waiting room and Tamil Nadu Electricity Board meeting room and all, just to get a meeting to explain to someone. By the time you have explained to couple of people in the electricity board, next time you go, Jayalalitha has replaced that with some other guy. So Tamil Nadu Electricity Board, in 1 year we met 3 different chairmen, okay, of the electricity board. So then you have to get into doing some POCs and pilots. These are government organizations, so everything runs on RFPs and tenders and everything. And remember, these meters are not going to be bought by the electricity board. They are going to be bought by some system integrator like TCS or someone who manages all that. So you have to sell to TCS or you have to sell to L&T, but you also have to go and create that awareness and interest in TCS's customer, which is the electricity board. And then you cannot sell a meter in India without it being approved by Central Power Research Institute in Bangalore. So you have to go and put out them also. So what a complex sales cycle for this product, right? Now suppose I have developed a smart meter technology. I might say, well, I am not going to go through all this, I am just going to go to sell to some company like Cyan Connaught. But unless I am able to see through their next level of commercialization, no one is going to buy my IP. So understanding the economics of that whole value chain and who is selling to whom and how long the sales cycle is, and do I have that much runway as a company to survive over that sales cycle is very, very important. Okay, so I'll now quickly change track a little bit and talk about B2B, which basically I'm trying to talk about if you're a small company trying to deal with a big company, right? What all you might want to consider. So as a startup trying to sell to a large company, usual issues. Most companies will have something called empanelment, right? Public companies, private companies may have some similar notion that we have never dealt with you before. We are a 2-year-old company, 0 revenue or lakhs of revenue. Even if we buy from you today, tomorrow you are not there, who will support it, right? Or sign this NDA. And obviously as a startup we are always worried that, okay, am I going to end up telling so much about what I am doing that tomorrow the company can say, oh, very good idea, thanks for telling me, now I will implement it. Right? In the startup world this is like a very common concern. And then, okay, your technology may work, you are saying so, but I want to do pilots and POCs, I am not going to pay for it. big problem, very common problem. And then as I said, long and complex sales cycle. After even if you have sold, collecting the payments, right, that is another thing. And now if you think of the other way, when I am a big company trying to buy from a startup, these issues are real, right? Startups are there, not there, they are able to support, not support. It's a huge risk for me to buy, right? You can imagine a refinery buying from that British company. They installed 2000 sensors, tomorrow the company goes bust. Who will maintain those sensors? Who will provide upgrades to those sensors? Lot of issues around confidentiality, because large companies are very protective of the use case they are sharing with you, that I am going to take your IP and use it here. That's very valuable information about the market. So lot of sensitivity around sharing those. So company can be, of course, many avatars for a startup. Could be a user, could be a customer, could be a channel partner, eventually could be acquirer. You might develop jointly IP with them. And in order to commercialize, you really don't have any way out of not working with a large company. So you have to be able to figure out that how you're going to deal with big companies, and given that one or more of these modes are applicable to you, how are you going to deal with some of these issues. So as a channel partner basically means I am a startup, I work with a big company and I tell them मेरा बेच के दो आप बेच रहे हो आपकी चीज़ें मेरा भी बेच दो, right, and you take some commission on top. So typical questions are that, okay, there is a sales team in the big company, they are selling the big company's products today. What is their incentive to sell your thing? Are they going to get some extra bonus? Are they going to get some extra credit? If not, then why bother selling that? So even if the R&D or the head of technology in that company likes your product or technology, the sales guy may say, I don't care, there's nothing in it for me. Same thing with marketing. And typically when you go to a big company and try to sell something and you are a startup, they'll say, okay, you give me exclusivity, like British Petroleum did. Then that comes at a price, right? That means I'm not able to sell to something else, to somebody else. So then are you going to price it more because they are restricting your ability to sell? Or a big company as a strategic partner, that, okay, I don't want you to sell, why don't you integrate what I have into your product or your service and you sell it? Then there are questions around, okay, who is going to pay for the integration? Or if we create something jointly together, who will own it? If we own it jointly, then what does that mean? Does that mean that I can go sell to your competitor? Questions like those. So it's important to understand buying behavior. And again, as an early stage company, you may think that this is all somebody else's problem. But without understanding this, how do you convince someone to buy your IP? Okay, you may say that I am not going to sell the end product, but you still have to sell the IP. So sort of standard way of thinking of buying, that there has to be a trigger. People generally are resistant to change, so there has to be a reason to change. And there is a notion called loss aversion, that people are much more sensitive to losses than profits. And so there is a lot more, you need to convince someone that first of all I'll not cause you a loss, and second of all, whatever I do will be something 10 times better, faster, cheaper, some combination of that. Otherwise inertia is kind of the default state of everything. So understanding buying behavior, and especially in the B2B context, understanding B2B buying behavior, which rarely has to do with technology. It mostly has to do with politics and pricing and process and bureaucracy and so on and so forth. So understanding, for example, Indian companies, right? I've dealt with Reliance. It's amazing how the decision making works in a company like that, right? The middle layer has very little decision making power, especially when it comes to new technologies, because obviously they are taking on risk. Versus if you were trying to sell to MNC, then how much decision making power is there with the MNC India head versus how much decision making power is there with wherever the MNC is headquartered. So being able to understand that, and when we were commercializing technologies, very counterintuitive lessons we learned, that if we went to a large Indian company or MNC, success rate was much worse than going to a mid-sized family run business, where there was one Lalaji, his son or daughter was just getting into the business, he had much more risk appetite, he was willing to bet on technologies, decision making was like that, right? Pricing is a different problem, their ability to absorb the technology is a different problem. But just one or two people making decisions, willing to take risks, seeing an opportunity. One of the largest deals we did for some technology from DST lab was done with a distributor. This was a distributor who was buying some German material and selling to some large companies in India, and he was seeing how much how much monopoly that German company had and how much of the value was captured by them. He was just a distributor, making his whatever 5, 10, 15% on top. Not a technology company, no R&D, nothing. And he was willing to pay not only crores for the technology, but on top of that invest another 10, 20 crores in the factory to incorporate that technology and productize it, because he knew as a distributor how much business there is, right? So everything that there was to the kisko bechna hai, kitne mein bechna hai, kaise bechna hai, he knows everything. He just doesn't have that technology. So a lot of times, especially in India, we found people coming saying, here is a data sheet of a European company sensor. If you can make this, I will buy the technology from you today, because he knows everything. Kitna demand hai, where to sell, how to sell. He just doesn't have the technology. So being able to figure out, who is the right person from a customer point of view, and many times it is not the obvious ones. It is someone different. And typically in a large company, figuring out how to navigate the hierarchy and the bureaucracy and the politics, because designations don't mean everything. Real power may lie somewhere else than in the title. So this is where I again come back to developing relationships. Very, very important. And relationships in a B2B context don't get developed in a month, or when you decide acha abhi bechne ko tayar hai. That is too late. You have to build these relationships very early on. And it's also beneficial because today if you go and try to tell someone that I would like to meet you, and you are able to convey to them that I don't have anything to sell to you, I'm just coming to you for advice. It's much easier to get that meeting than if you tell someone I want to sell you something, can I meet you, right? Or if you're going to a conference and meeting people from the industry, that's a very better way to build relationships over lunch or dinner or whatever, rather than sending an email saying I have this IP, I want to sell it to you, will you meet? So figuring out who to meet, and what is their role in the company. Are they the one who are going to write the check, or are they the one who can stop you from entering? Because typical problem trying to sell to a big company, there is a R&D department, they will tell Lala ji hum hi kar denge, aap kyun wahan se kharid rahe ho. Standard problem trying to sell technology to a large company, right? So they are a gatekeeper. They may not make the deal happen, but they can stop the deal from happening. You had a question? Okay. And then finally, selling IP or selling technology essentially is about overcoming objections. So the best way to deal with this is, Darwin was famous that he had the best argument against his own theories than anybody else. And so being able to write down all possible objections that someone could have with your what you are proposing, so that whenever you are trying to meet someone, you have already answered whatever you can think of, and that sends a very different message to the buyer than saying, oh, I didn't think of that, or I don't know the answer. So again, I'm going fast through these. We'll figure out a way to make these slides available to you. Okay, so fine, we understand it's important to sell and it's important to build relationships, but how much to sell for, right? And valuation. So I have some very high level thoughts on valuation. Valuation is a function of many things, right? The easiest thing to value is the 100 rupee note or the cash in your pocket, because the value of 100 rupee note is 100 rupees, right? There is no debate about that. Anything else you try to value is difficult. It requires some model, some mathematics, some assumptions. So I have just listed that the most easy thing to value at the top and the most difficult thing to value at the bottom, right? And IP is obviously more toward the bottom, because IP is a means to an end, and that end will be a product or service which will make someone profits, which will be paid out as dividends, and when that cash is in your bank, then its value is whatever it is. And so I'll just talk a little bit about, if you are generating revenues, how to think about value or what context to think in, and then of course IP valuation. So before we talk about revenue, sort of talking about distributions, I'm sure most of you are familiar with this, that on the left is something called a power law distribution. If you think of if you plot the wealth of people in the world, right, there are very few Bill Gates on the right side of that axis, and then there are many poor people. It's a power law. Whereas if you think of plotting the height of everybody in the world, then it's a normal distribution, right? There will be some very tall people, some very short people, but more or less everybody is 5, 5, 5, 6, 5, 7. And a similar distribution is what is called the Zipf's law, right? That if you plot log and log, it's a linear. The reason to talk about this is that a lot of times we we read about things that someone got $1 billion valuation, or Flipkart was valued at $20 billion or something. It's important to have a sense for how many companies are there which are generating revenue of that order, right. So if you look, for example, in India, this is revenue per year, and that is the number of companies, right. The very few companies in India that generate 1 lakh crore revenue a year, and there are many companies which are generating 10 lakh revenue a year. So why I am saying this is because lot of times startup business plans are like really an exercise in imagination, right. Everybody says hamara revenue 100 crore ho jayega, but how many companies are there which have 100 crore revenue? Of those, how many are in your sector, and are you able to break down that, okay, for me to have 100 crore revenue, if I price something at 1 crore each, then I have to have 100 customers every year. Are there that many? Am I be able to sell to those many customers? Otherwise what happens is that there is IP, and then there is some projection in an Excel, and there is no connection between the two. So having some context for what revenue is possible for a technology like mine, and if I am going to sell this to someone as IP, not as the end product, and that person is going to make this kind of revenue, then how much can I expect for my IP, right? Because he has to invest not just in the IP, he has to invest in making the product, buying for the raw material, sales, marketing, and n number of other expenses. He can't possibly, if he is making 100 crore revenue, not going to pay you 10 crores for the IP, right. Certainly not all on day one. He may pay you as some upfront and much more tied to royalties. So having a sense for, am I talking 100 crores, 1000 crores, 10,000 crore is very important. And if you go to, for example, NSE website and look at Nifty 50, which is India's main stock market index, and look at the revenues of those companies, it's an eye opener, right. Or if you say that how many companies in India, listed companies, have more than 1000 crore turnover, you will realize that there are not that many. And so before our Excel spreadsheet start talking 1000 crore revenue, we should be aware of how many companies in India today exist that even have 1000 crore revenue. Okay, so we'll come back to IP, and talking about IP valuation is like the best thing is to say beauty is in the eye of the beholder, because there is no right answer for what is the value of IP. First of all, you have to understand how is IP monetized, right. So in the technology world, a lot of us talk about I will transfer this technology, or I have a bunch of patents, I will assert these patents against someone because I believe they are infringing. That is what is called direct monetization of IP. Or if let's say I have some patents related to 5G telecom standards, then I will contribute it to a standard essential pool, patent pool, and I will get some royalty. Whereas indirect monetization is basically that I have IP, I have some patents, I am going to practice it, means I am going to incorporate it into my products and I am going to sell those products. So understanding how our IP is going to be monetized is very important, because in the biotech case or in sort of very early stage science companies, rarely will you do indirect monetization. Chances are you are going to end up licensing the technology to somebody who will then take it to the next level. And the same way, how is IP accounted for? And this is a little bit more corporate view of things, but IP commercialization through technology transfer, where you tell someone I have this new cool material, you can use it in your product and you can sell it at a premium, is very different than saying I have this patent, you are infringing it, if you don't pay me I will take you to court. Okay, very different, very different way of commercialization, very different way of accounting for that IP. And on the corporate end of things also, how IP gets accounted for is very different. So if I am a large company with thousands of patents, the value I will put on those patents is going to be very different than if I were to license the same patents to my competitor today, right. So it's very context dependent, and there are a various range of scenarios on where you would value IP. So as I said, if I am trying to price a product which is protected by a certain patents, the value of those patents might be very different than if I am trying to liquidate my company and someone wants to buy it from my current shareholders, and what value they will put on the patent. So how is it accounted for, when is it valued, all this has a strong impact on what is the value of your IP, and at an early stage science company, more or less IP is the only thing you have to value on, right. And then how is IP valued? I won't go too much into this, because if you just go to Google, there are n number of explanations on how IP is valued. Typically there are three ways of IP valuation: market, income, and cost. What market says is that, okay, I have this IP, someone else bought it from a third party for so much, my IP is similar to their IP, therefore it is so much, right? So market comparable. Obviously, it's not easy to do apples to apples comparison because not every patent or portfolio matches another, but it is one of these three ways in which you can triage on the value of IP. Another is income, which is to say, if I take this IP and convert it into a product, I can generate so much revenue from these products. It will cost me so much to sell those products and make those products. Net profit will be so much. If I discount it and use net present value, this is the value, which means that you have to be able to go through that whole exercise of creating that profit and loss calculation, right? And the third is cost based, which is a very simple way of saying that it cost me so much to make this IP, so it's worth so much. Or if someone else has to create the same IP from scratch today, it's going to cost them so much, so it's worth so much. So normally IP valuation is done by doing all these three things, which give you a range, and then the actual number at which the transaction will happen will of course depend on what context you are doing that IP sale or licensing. There are a lot of challenges in IP valuation, as you can imagine. If I were to try and create a profit and loss projection of some early stage IP, pretty much everything is an assumption. So the value of the IP can be hugely varying, depends on whether the IP is being given through a technology transfer deal or through a patent assertion licensing deal, and depends on how litigative is your particular area. So if you look at, for example, telecom patents, very litigious area. So the value of a telecom patent is going to be very different than a value of some, say, consumer good related patent where people don't really sue each other that much. What I'll show is a few examples of market values of patents. So there have been a lot of studies done about trying to estimate patent values. So good or bad thing is software and biotech patents tend to be the most involved in commercial deals, whether they are sales or acquisitions or assertions. And a typical software patent, through various studies based on actual deals that have happened, is roughly of this order, $250,000, right? So if you have a software patent today, and this generally assumes a US patent with some family around the world, it's roughly worth $250,000. But then the next level of detail is what's interesting, that was the average. The median is 1/10 of that. Okay. So most patents are actually worthless, but few are worth millions or tens of millions, so they skew the average to $250,000. The median patent is $25,000 on average, which means half of software patents are worth less than $25,000, which means they are not even worth what it costs to get them granted, right? If you count the effort that went into that research and then the patent expenses themselves.
Can you go back when you say previous one? When you say value, is it lifetime value?
So these were this is based this is based on mostly sale data. So for example, IBM sold 50 cyber security patents to some company. That deal was worth X, divided by 50 is this. So at a high, at that cut it is worth $250,000. Then when you start getting in the detail, you realize that first of all it's average, not median. Median is much less, and then of course things like telecom patents, the average will be more than $250,000, because this is software, right? Software can be related to 5G algorithms. It can also be related to some software patent for a user interface. That is going to be worth much less. So averages are dangerous, but at least it gives us a sense for what they are like. And so it's again here it's a power law that, like Bill Gates, few people are that rich. Similarly, few patents are worth billions or millions. Most patents are worth nothing or less than it cost, right? And this is again important mental model to have, because if you have 2-3 patents and if you try to commercialize, then it is important to be able to benchmark yourself that, okay, first of all, what type of patent is it? Second of all, how broad are my claims? Where all have I filed? A typical patent in my industry is worth how much? And do I have a portfolio or do I have just 1 or 2 patents, and so on. And you can see that the most valuable patents are of course where the infringer was a very large company who paid a huge amount for it, right? And then you look at lower down, that my patent has broad claims, but it has never been litigated. So if it goes to court, obviously the other party is not just going to pay up they will say that this patent is not valid because it's obvious or not novel or whatever. So, how much has it withstood the test of time and test of scrutiny in terms of licensing and litigation, the more valuable it is. Because everybody thinks their baby is most beautiful, right? So, most inventors think that patent is most valuable. So, I am just trying to give some context for that. Okay. So, let us talk about selling now, because this is all fine, but finally nothing happens until something gets sold. So, I wanted to talk about difference between entrepreneurial selling and professional selling for a little bit and be able to tie it back to IP licensing. So, this is sort of first time technology entrepreneur's view of the world, that I will create something, I will have a prototype and people will come running to my office and buy it from me, right. But reality is a little bit more like this, that I will do some proof of concept, I may solve someone's problem, I may get some beta customers who took mercy on me, or someone introduced me to them, but I may just remain in that loop. Or once in a while I may come to product market fit, where I have figured out how to sell, whom to sell, how much to sell at, and then I will have actual customers, and at some point I will make profits. So, this is where professional selling plays a role, that I know what to sell, I know who to sell to, I have an engine that I need to now run very fast and very efficiently with minimum losses. So, a lot of marketing lingo and lot of talk about channel partners and sales incentives for sales staff and when to hire a new salesperson and so on. But I assume that most of you are on the left side, where you have to have a much more entrepreneurial mode of selling, where it is again about building relationships, figuring out what the problem is, figuring out what IP needs to be created, building a team and so on and so forth. And this is mostly about mindset, not about tactics. Whereas, so professional selling, there are a lot of books, there is a lot of experience out there, and it's mostly about tactics. Whereas, early stage selling is mostly about mindset, because you are at evangelize mode rather than in execution mode. So, certain characteristics of early stage selling are, it's not scalable. You cannot do it because it's so time consuming and it takes so much energy that it's not at all scalable, and it's not very cost efficient. And it's very consultative, that acha aapko ye problem hai, maybe I can solve it, let's try this, then let's do a couple of proof of concepts, pilots, then we'll do a deal. And so, I have found that this is very similar to tech transfer and IP licensing, because a typical IP licensing deal is like this. You don't do the same IP licensing deal over and over in the same way, unless you have some patents that relate to some globally accepted standards like 4G or 5G, where it's mostly about, look, any cell phone smartphone you make which is 5G technology, you have to pay me 0.1% royalty. That's different. But for most of us, when we talk about IP commercialization, it is a entrepreneurial sale, right? And initially you might be selling to Dr. Premnath ki hamara DBT grant ke liye proposal accept kar lo, or after that you might be selling to someone that why don't you let me do a proof of concept with your company, or you might be selling to a potential co-founder. So, that is not very scalable selling, but that is what matters at this stage. And even though it is different than professional selling, it is still useful to think in terms of this, that typically every sale has these 5 obstacles, right. There is another way of thinking about this BANT, budget, authority, need, trust, that whoever you are selling to, do they have the budget to pay for it, do they have the authority to sign that check, do they need it, and do they need it now. Unless you are able to clear these 4 or 5 obstacles, you cannot close a deal. And so, when you are trying to sell, and again I am defining sell very broadly here, it could mean you are selling to a investor, it could mean you are selling to, you are trying to persuade a very good employee to join your company, whoever. There are these 5 very high level ways of thinking. That suspect means I think that I should pitch to this investor for money. Prospect means that okay, he has shown some interest in talking to me. Opportunity means we have had a couple of discussions, and at a high level they want to invest in material science startups, and I am a material science startup. And then okay, I want 1 crore, I will give you 10% equity in my company, or I will give you my technology for 1 crore, and then negotiation. So, useful to think about a selling broadly defined in this way. and so it's always a probability game, right? That unless you are talking to enough people, enough suspects, you will not be able to close a deal. And I think it's very important to understand in the early stage startup world that you cannot just go talk to 5 investors or 5 customers and nothing comes out and you say, "Arey, kuch nahi hua." There is a certain probability. Is it 1 out of 50 or 1 out of 100 or 1 out of 1000? That depends on what business you are in. But without thinking in terms of probabilities and understanding that unless I approach 100 people, I should not expect that I will close a deal. And so that means I have to approach 100 people. Right? And that's where the entrepreneur mode kicks in. And same thing, that a lot of persistence is required, which many technical founders say, koi aur karega, I am good in my lab, I can create some good technology, I can write some patents, ye mera kaam nahi hai, calling people, emailing people or meeting people and chasing them. But that's what it requires to close any kind of deal, investment, IP license, product sale, anything. And this is sort of, I like this statement, not my statement, that a lot of technical founders say, wo sales banda MBA leke aunga main, I'll give him some equity in my company, he will sell. But the reality is that no good CXO joins a startup till it's reach at a certain stage. So founder has to do the selling, commercial selling, investor selling, technical selling, all selling. Okay, so again, who sells? Founder sells. And what I have found, especially in science startups, there is one company here with whom I have worked very closely on this floor itself, that we groomed one of the people working in the lab to generate leads. Okay, he offers technology as a service. And sitting in Pune, she managed to generate hundreds, thousands of leads. And sitting in Pune, we managed to close deals of $20,000 for a biotechnology as a service, not selling drug molecule. So didn't hire any MBA, didn't hire any VP of sales. Person with science background working in the lab who understood the technology well enough, because not rocket science, it's a matter of persistence and understanding that I have to reach 100 people to expect 10 responses, and if I get 10 responses, probably one will convert to a sale. Very, very important to understand and accept. And the sooner you start grooming some junior people who have reasonably good technology capability but may not be completely inclined only on doing the technology part, because if you hire an MBA, I am an MBA by the way, it takes a long time to educate us about technology. But if you hire a technology person, it doesn't take too long to educate about marketing and sales. It's very simple, right? So it is important to keep that in mind and groom people early on. And when you start to scale, it's not that a sales guy joins you today and becomes productive tomorrow. There is a huge lag. And so it is important that even if you start seeing some customer traction, you have to factor this in, that okay, now I have too many leads, I cannot handle them, I don't have time to respond to all the customers and write proposals, then I need to hire well enough in advance so that that person is productive. Or if I hire someone, I can't expect too much productivity from that person until whatever that lag time is. Okay, so now talking about out licensing a little bit more specifically, there are many reasons to out license, right? Money is not the only one. It may be as important to just prove credibility, that the money may be very small, but the fact that someone took IP from me and was willing to sign and pay me something establishes that what I am doing has some market value, right? It could be very important from a valuation point of view. So if you are trying to raise money from an investor, and if you say that no, I have not done any sale so far, or versus if you say, yeah, I just recently did a out licensing deal. Because imagine if you are an investor and a biotechnology company is coming to you, my ability to evaluate the technology is very less. I am going to rely on some third party to evaluate it. So what will I do? I will think, acha, mere network mein kaun hai? I will forward the presentation to them and say, does this technology make sense? But if I see that some commercial deal has happened, some company has licensed this technology, then suddenly my confidence level goes up, because I don't have to spend as much energy validating the technology, that this is not all vaporware or some imagination, this is real, someone paid money for it. So many reasons to out license technology. And licensing in our world is technology licensing or IP licensing or both. And the reason to differentiate this is because IP licensing or patent licensing is essentially comes down to carrot or stick licensing, right? And carrot licensing is, I have this new technology, I'll license my patent to you, I'll give you some know-how, you can make good things out of it. strict licensing is you are infringing my patent, I'll sue you. So which path do you want to go down to? Technology licensing is different, or in addition to this, in the sense that no one is going to license a patent just by itself. You have to offer know-how, you have to offer some consulting services, and there are n number of knobs that you can have in a licensing agreement, that I am licensing this technology to you for India exclusively for 3 years, with an option to continue the exclusivity for another 3 years, and you can only use it to you in the chemical industry, and you have to pay me so much fixed amount every year as royalty whether you sell or not, and if you make more than X% revenue, more than so much revenue, then my royalty rate drops to so much, and so forth. So being able to understand what are the various knobs that you can adjust to in a licensing deal is very important. This is a slight tangent, but is very important if you are working with anybody else to develop the IP, and I have some personal experience with this because at TCS we work with universities and startups both, that there is a sort of somewhere underlying assumption in people's mind that the person who created the IP owns it, also can commercialize it, but it's not so. It is a matter of negotiation between two parties, right? That you may pay me to create the IP, and I may be okay with you owning it, or I may continue to own it, but I may give you exclusive rights to commercialize it, and so on. So if you are working with anybody else, working with NCL or working with another company, large company, startup, whoever, it is very important to understand that this default assumption is not true, that whoever creates IP owns it, can use it and commercialize it. All of these can be carved out as separate ownership rights or separate rights and are negotiable. And again, this is a little bit from the software world, but still it's important that if two parties come together, then when we start working, both of us already have some IP to begin with, right? So that's what I'm calling background IP. And when we work together, we'll create new IP, which is foreground IP. And along the way, we may improve each other's IP, improve whatever background IP we had, which is derivative IP. And while doing so, we may use some third party's IP. So do we have enough clarity that what is our IP going in, what new IP is being created, can I modify your IP and sell it? Very important. So that's why I've titled this co-innovation or collaborative R&D. I don't know how many of you are working with anybody else, but very important to get this, because most disputes related to IP happen when people start seeing big money. Until then it's all, "Arey mera dost hai, hum dekh lenge baad mein," right? But when big money kicks in, suddenly everyone pulls out the contracts. Ki look, it says I own the IP. So important to keep this very clean when you're working with any other entity, government or private, whoever, that who owns what IP going in and what's coming out. And IP licensing deals typically are always structured deals. It's not like you go in a shop and buy toothpaste, you pay 20 rupees and you get the toothpaste. Never like that. It is always a structured deal, which means I'll give you XYZ, and in return you'll pay me so much today and so much when these milestones happen, and so much in royalty. And then if you don't generate so much revenue and don't pay me so much royalty, you lose the license or you lose the exclusivity or whatever. And it need not always be a license also. It can also be an option to license. So let's say I am a big company or I am a lab like NCL, and you are a startup asking me for some technology. I may not want to restrict myself by giving you a license, because you may or may not be able to raise enough money to take it forward. So I will say, okay, I'll give you option to license, and you try it out for a year, and if you are able to raise money by then, and if you see some promise, you can convert it into a license agreement. So many ways to structure this deal, but they are always structured deals. They are never just one-off transaction deal that I pay money and I give IP. This is some interesting quotes from studies done and interviews done with people who have been involved in biotech startups licensing IP or technology to pharma companies or selling those companies. So what the above quote says is that if I am an entrepreneur or an early stage investor, I am going to call up the business development person in the pharma company who may buy my technology 5 years from now or 3 years from now, and I will ask him, if I got this to you 3 years from now, will you buy it? Or what are you looking for to build in your portfolio for the next 2-3 years? And only then I will invest in that company. Because if I can't see that next exit, why will I invest in your company? And flip side of that view is that, okay, I am a early stage company, I have built some technology. I license it to someone. immediately my company's value drops in the eyes of an investor, because I had only one jewel and I gave it to someone on some terms. I don't have 10 jewels in my portfolio, right? So there is a trade-off between licensing out some IP as a company versus selling the company, or versus building a portfolio of IPs and licensing them or selling them one at a time. I'll give you very quick examples of 3 Indian companies, all in the healthcare area. So this is a company called Vitus Pharma. I think it's in Hyderabad or Bangalore. They are focused on antimicrobial resistance. Early stage company. They are funded by Indian Angel Network, few crores I think. And so if this from their website, right? They are very clear that these are the important value inflection points in the journey of their company. They have 3 candidates in the pipeline at different stages of maturity, and at some logical point they will either license one or more or sell the whole company. And they are very focused on antimicrobial resistance, which, as you may know, is a very, very hot topic today. A lot of large companies are looking to build their portfolio in this space, and so presumably the founders and the investors have thought through the end that antimicrobial resistance is a big problem. Many antibiotics don't work anymore, and if we are able to take even one thing here, we are looking at a huge deal. And if you Google for antimicrobial resistance startups, US or whatever, you will find that couple of companies have been sold for 100 million or so, just for having 1 or 2 candidates at this stage. Hot space, very focused founders, clear on what they are doing, and sitting in India, they have raised money from Indian Angel Network, 1 round. I think this was 2016. Another company called Bugworks, again this from their website. So publicly they are disclosing their strategy, that we will take it till phase 1 or phase 2. My guess is mostly phase 1, and we will license it out. Okay. And so when they are working towards that goal, that okay, we know what we have to do, and as soon as we get to phase 1, we should start talking about this. And obviously that is too late to start building the relationships. So much before that, they are going to start talking to those companies that are interested in whatever areas their technologies are focused on. Now this is sort of my favorite example. Indian company Curadev Pharma has a pipeline. Initial success was in immuno-oncology. This is again from their website. You can see that they have laid out the value inflection points. They are sharing what areas they are working in. If you can see on the leftmost, it's mostly cancer. They did a $555 million licensing deal with Roche. Okay. So this to me is wonderful, in seeing an Indian technology startup doing this kind of deal. So the good news is the 555 million. Imagine the amount of validation they get if someone like Roche is willing to do a deal with them. And they were focused on immuno-oncology, and if you read around that time frame, very, very hot, lot of big deals happening in the US, companies getting acquired for $1 billion, $2 billion in the immuno-oncology space. They had a molecule. Typically how it happens is there are these whatever 10 big pharma companies in the world, 3 have a good immuno-oncology pipeline. CEO of the 4th and 5th, पेट में दुख रहा है, मेरे पास कुछ नहीं है, जाके उठा लिया कोई तो immuno-oncology company, right? Now the reality is that out of that 555 million, only $25 million was paid upfront. $530 million is in milestones and royalties. Okay, so you can imagine just less than 5% is upfront. So my point earlier about structured deals, that those numbers are very good for PR. Of course, it's a huge validation, but that is far from reality in terms of amount realized. Okay, so we'll quickly talk about exits. What I mean by early exits is that a lot of time, especially if you are exposed to the Silicon Valley hype, point is that you should create a company to change the world. Okay, but I think you should probably create a company with as much eye on early exits. Which early exit, I mean build the company with a clear intent to sell the company, or at least sell the one important technology, so that you have validated what you are doing and you actually have money in the bank. Okay, so just to, in India, what might it mean? It might mean that okay, I sell my company for few tens of crores or few hundreds of crores. typically it means that the founder's return on investment is roughly 10x including opportunity cost. What I mean is, if today you could have got a job in some company earning say 20 lakhs, 30 lakhs a year, that's your opportunity cost, right? You do that, and instead of that you are doing this company for 4 years, so 80 lakhs, 10 times that, 8 crores. That's kind of what an early exit is, that instead of doing a job I did this, I made 10 times my opportunity cost. That's a good enough early exit. Okay. Could also be a partial exit, especially in the science space, because if I have a portfolio of technologies, I need sell only one. So Curadev, if you take, they have 8 things in the pipeline, only 2 of them were licensed for 555 million. So they have 6 other things. But imagine the amount of validation, confidence, bank balance, everything that one deal gave them. The reality of exits in India, we did some study on this, is until this whole venture capital boom took off maybe 10 years ago, and it's not taken off as far as science is concerned still, that the typical exit time frame from founding is 10 to 20 years, not 2 to 3 or 5 years. And typically it's a distributor like company started doing some R&D, built some products of their own. One example of which is this Pune based company, that I think 35 years they were in business before they were sold, right? Decent amount, $70 million, but 35-year-old company, not like a startup ki venture investors put money, fatafat built kiya and so on. Sushrut. Yeah. So I think his mom started the company as right. Yeah. Pitre. Yeah. Biotech world, most sweet spot is this late preclinical, early clinical stage. Again, this is more global. In India, we don't have many such deals, but you saw Curadev. Again, it was in that sweet spot. And of course, a lot of startups here, for example, are doing medical technologies, not biotechnologies. So there, both the amounts and the time frames are less. The amount of money you need to raise is less. Most deals happen in the US, licensing deals, exits or whatever. And so if you see companies in India that have, Conshore Medical, I don't know how many of you have heard, or Mitra Biotech, right? All of them sooner or later have moved their presence to the US. Means CEO sits in the US or head of sales sits in the US, because finally all the deals are happening. So I think the reality is that you need to think US from day one if you are wanting to have any meaningful IP based deal or investment into this kind of companies. Now coming back to this 555 million, what they have done a lot of research that a lot of such deals happen in the US, right? Reality is that only about 30% of that is realized. Okay, so first of all, only 20% is generally paid upfront. Curadev got only 5%, and only 1 out of 3 chance of earning milestone fees. So that 555 million, removing the 25 million, 530 million, multiply that by 0.3. That is roughly the value of that deal, realistically, probabilistically rather. Okay, because rest all gets, obviously not every milestone will happen on time, things will change on the startup side, things will change on the licensee side and so on. So total deal value is mostly for PR, but of course it's a validation, and I think in India it's a big deal to do that kind of deal. But important to understand, because if you're trying to do a deal and the buyer is trying to skew most of the value to milestones, then you need to be able to mentally discount that I'm not going to see all that money, chances are. Nevertheless, large companies love early exits, because large companies don't have that great innovation pipeline all the time. They are looking outside. They may not have a lot of entrepreneurial talent, but they are good at scaling. So given a proven molecule, they are very good at packaging, branding, selling, or given something is at phase 2, they are very good at running phase 3 trials. They have the money to do that. So it's important to start thinking about this early enough. And in India, again, this doesn't exist much, but if you are looking across border, then the designations to look for people on the other side are what is called corporate development. These are people in large companies who are tasked with scouting for startups to acquire. So there are technology scouts, but then there is corporate development, which is generally involved in buying out companies. So there is a whole process to that. That is yet another sale. Same thing, you have to chase 50 people, one might happen, and you have to do it early enough, because these typically deals take 6 months, but before that they will probably have a relationship with you for 1 or 2 years as a licensor or whatever strategic partner before they will consider buying out. So that's it. As I said, lot of concepts. Sorry if it was too broad.
Let's just thank him for the.
Yeah, yeah. Thank you.
Questions?
Am I on time? Way past time?
No, you're
Oh,
okay.
okay.
90 minutes. So, I have a quick question, which
Yes.
is that for the guys who are looking at possible acquisitions at a later stage, is it a good idea to get into some of those sort of partnership models?
Yes.
Because, and if so, what if they pull out? If those guys pull out, then are you cluttering up your IP, cluttering up your company with relationships which will hurt your ability to sell to somebody else? And how do your investors sometimes investors are wary of strategic investors or strategic partners just because
Yeah.
you're tying up with one part.
Yeah. I mean, it's typical pro and con situations. First of all, rarely acquisitions happen by a corporate without a relationship before that. Okay. Some partnership, sales partnership, technology partnership, or simply the company being a customer of the startup. Rarely will an acquisition happen just like that. So there is no doubt that you have to build those relationships with the company. The danger with the technology partnership, like Premnath is saying, is that the IP is a huge problem, because first of all you have to be very good at defining what you own before that partnership starts, and invariably you are going to be at a huge disadvantage when negotiating with them, right? Because you go to legal will try to claim everything as their IP, and then depending on who is championing your case in that company, he will be able to fight with legal saying नहीं ऐसा तो ये unfair है, उनका भी IP है, उनको भी कुछ own करना चाहिए, and so on, and then 6 months, 12 months, whatever. So if possible, a customer relationship or a channel partner relationship is probably, or even a high level MOU is a good way to get started to understand how the politics works in the company. Technology partnerships are unless you know what you are doing, you are right that IP issues can become a big problem, and when you file patents around that, most of the time they are going to want joint ownership of the patent. So then unless you sell your company to the same company, trying to sell anybody to else, no one else will touch. So I don't think that means that you should not try and partner.
Any other questions?
Yeah, how these royalty rates are decided in different sectors, let us say engineering sector and the software sector, how does it vary actually?
There is no, there is no real thumb rule. There are royalty databases that you can buy if you go on the net, but I don't think that there is any right number. What I have seen is that first of all you need to think in terms of upfront fee, milestone fee, royalty, right? That is number one. Number two is you need to be able to figure out what is the basis for the royalty. That itself is a huge gray area. That is the royalty basis revenues? Is it profits? If it is revenue, is it gross revenue, net revenue? Okay. Should it discount selling expenses? Should it discount taxes, and so on? So agreeing on the basis for the royalty. And second, being able to agree on what the revenue might look like and what the corresponding royalty might look like, assuming some royalty rate. Let's say I assume 5%, right? Am I able to figure out, project my licensee's revenue well enough that I can calculate the royalty amount given a certain rate? If I am able to do that, then I can see the context, upfront fee, milestone, royalty, right? Rarely will you find someone willing to do a deal where upfront fee and milestone fee is more than 20, 30, 40%, 50% of the total deal value, correct?
Of the royalty component.
So that way you can iterate and say, अच्छा अभी ये तो दिखा रहा है कि I am making 90% of my value from upfront fee and milestone fee and only 10% from royalty, which means I as the licensor have no skin in the game. तुम्हारा बिका नहीं बिका मुझे क्या फर्क पड़ रहा है, मैंने तो 90% बना लिया. If it's the other end, that's also not fair. कि look, you are basically devaluing my technology completely, and my technology might be great, you might be very bad at selling. Why should I get penalized for that? So being able to say that, okay, now there is some logic to this proportion, that I deserve some upfront because I am put some cost in it, some milestones, so that I have transferred my technology to you, and your pilot plant is up and running or whatever, and then sort of win-win situation where the better you do, I also get more royalty. But is the actual royalty percentage? Oh, I don't think there is any industry standard. Even within the software industry or within the telecom industry, royalty rates are vary a lot, because it's a function of, it's a commercial deal. So it depends on what negotiating leverage each party has in that transaction.
The databases are though available. How you
Ah.
make use of it is a different matter.
Ah.
So, for example, the Association of University Technology Managers,
Right.
which is relevant for all the CSIR labs and so on, in the US puts out something called a licensing survey. So you can buy that. Okay, so you'll get without, with some anonymity, you'll get some numbers, and you can work out what in different sectors what kind of numbers have been used. But as he said, another issue is what, say, a US university can get, can you get? That's another question. Okay, I mean, the same guys in Eton, for example, doing the deal in US and India might behave differently. Right?
Maybe art of negotiation.
Because and I think it is better to think of it as one knob in 10 different knobs that you can tie. If someone says 5% royalty is too high, 2% I'll give you, you say, okay, I'll give you non-exclusive.
Yeah.
Or you limit the field of use, or you limit the geography, or you limit the time period of the license. There are so many other ways to negotiate.
So one thumb rule which people use, but please don't use it blindly. Okay, as a starting point is that if you're projecting your cash flow discounting process and calculate your profits and then get it to today's value. Okay, one thumb rule that they use is that up to about 20%, okay, or 125% of your profit could be attributed to, say, a technology, right? But you can imagine that will not work if it is if your technology advancement is contributing in a very small way to the profits, right? If this guy's sales effort and everything is very large, you claiming 25% of the profit is not okay.
And
so you have to use your judgment.
And typically you will put royalty on revenue. So now if it's 25% of profit is 20% of revenue, assuming normal margins, then your royalty rate is already 5%.
Yeah.
Right?
Yeah. And it's important to recognize that it is that much only, because people claim the moon in the sky, thinking that it should be much higher percentage of the revenue. But this is what the reality is.
Because sorry, just one point that whatever someone pays us for our technology, person is going to have to invest 10 to 20 times more in selling it, making it and selling it. We should never forget that, right? Because he is just taking it as one of the inputs to sell. And then we are trying to claim a percentage of the revenue. With not just the IP is not going in the revenue, and number of other things are going in the revenue.
So for the startups, that's your argument with the guys you're licensing from. Vice versa kind of a thing. I think there was a question.
Correct, yes.
Yeah, the one thing that like you said, once you make a deal, the valuation of your company is going to go down enormously.
From a venture capital point of view, right, may go down, yeah.
Mostly it would.
If it's core technology.
Because as you said, now we have nothing else to show.
So unless you have other things cooking,
So
like this Curadev or others.
Thinking on this was most of the time, and I think this is because we have this notion somehow that an IP is for a product or a process. So my feeling is, and when I look at some of those proposals, they are single product companies.
Right.
So I don't know what will they do after they do this.
Correct.
So a better thing for a good startup is to look around a concept.
Right.
And say, this is the skill base I have around which I can do many things.
Right.
So you develop a core IP, or it may not be core IP, it could be but you keep such that you keep on developing subsequent IP on this.
Correct.
So even if you sell this, you have some other carrot to show to your venture capitalists.
Correct.
Have you seen people doing this?
So I mean the Curadev is a very good example because they have 8 things in the pipeline. The Roche deal was only around 2.
Okay.
They have 6 other things. Given that deal is fantastic because no one is going to ask them ki is your basic know-how and technology any useful, because what came out of that technology as the first 2 candidates are already validated in the market by someone. So chances are the next 6 things are not going to be completely unpractical, right? But see, first of all, there is a lot of assumption that goes that first of all you have that much understanding of the market. Second of all, you are able to raise enough money to keep at it and build such a pipeline. Third, that this deal with such a deal with Roche will come soon enough that you will not run out of money, because you may have developed something great, but the nature of IP licensing is such that the sales cycle is very, very long. Okay. So luck also plays, I think, a big role, even though you may have all this. So see, this has been perfected by people in the US East Coast, that there is a standard business model. Ex-pharma guy comes, starts a startup in a hot area, angel investor funds it, take it to target, then another guy funds it, take it to preclinical, then start talking to his ex-buddies in the pharma company, jaake bech do. Okay, that is going on there nicely. Here there is no such ecosystem.
No, that is another very interesting thing. When we look at, like you said, who is the guy who is an ex-pharma? That means he knows the area so well that he knows precisely where the gaps are, and that is where he makes a startup.
Right. Correct.
So those are very senior people, who have spent almost a lifetime or at least 15 to 20 years.
Yeah, true.
So those are the ones.
Or their advisors to young people who are foolish enough to do it.
Correct.
That's true.
That also works.
By the way, the Curadev founders are also ex-pharma people. I mean, contrary to our notions, typical successful entrepreneur starts his company in the early 40s. Although our view is Flipkart or Sachin Bansal, 25-year-old and all that. Typical science, technology, engineering.
Technology startup.
Even software startups in the US, B2B software startups in the US, typical successful founder is early 40s. Because like you are correctly saying, you have to understand the market well enough before you can create something.
So by the way, this whole idea of suspects, prospects, and so on and so forth. Do you think startups who are beginning to sell should be, or guys who are selling IP, they should be actually creating that funnel and tracking it?
Yes, absolutely. Yes.
And does it, really work in practice for an average? Do they have?
See, I'll tell you it this way, that it takes a long time to build these relationships, but on a given day it takes very little effort, because most of the time you are waiting for the other guy to respond. Okay, and now that really, right, in a typical B2B sales, it's not that he's consuming 8 hours, every person in that sales funnel is consuming hours of your time. So the way to deal with that, rather than getting frustrated, is to have so many things at the top of the funnel that on any given day you have one conversation going on which is only going to consume 10 minutes, half an hour of it. So absolutely it's important.
So question which would be again, with that respect is, when should we start engaging, with the prospective customer? So even if it's software, there is an IP, anybody can spin it off unless you are, and the startups, it's so speed is how quickly you can come is again judgmental, because it would depend on when you hit a technology roadblock. You don't know, the skill is not within your team. You have to go out and look for somebody who can come and fix that problem for you, and then you move ahead. So what would be the right time that you go and start building and start talking?
So you take the Silicon Valley view, which is one extreme view, that before you start even thinking of creating something, you go talk to your potential customer कि अगर हम ऐसा बनाएंगे तो आप खरीदेंगे क्या, कितने में खरीदेंगे. If not enough people answer yes, then you should probably not create that. Okay, so that is one extreme view. But I think it still applies, because again what I have found is when you go to people saying, I want your advice, that what is going on in this industry or what problems are you facing, people are much more open to talking to you than we have something that, okay, I have done this, will you buy it? So I would say that it's never too early to go talk to a potential customer, right? I mean, you just have, it's opportunity cost in terms of time.
So
that's about it.
So that would be just about inquiry about their problems and requirement rather than you say pitching actually our product or.
And that we are thinking of developing something as, see, nothing, first meeting mein no one's going to share anything real with you. Only after 2, 3, 4 times you have met them will they start sharing that, look, this is not really required, instead if you can do this, I will buy it from you. Okay, that is when you start getting those insights that, oh, I was thinking that the problem is this, but actually the problem is that the market is facing, and if I solve that problem, then I have some business. And that is why having these conversations early and building those relationships when you don't have to sell, the day you are in a position कि अभी तो बेचना ही पड़ेगा, it's too late, because the length of the sales cycle is so long. Typically in India, B2B sales cycle is, in my experience, 2 years. Imagine taking 2 years to sell something. Very tough. When I say B2B, I mean you're selling something meaningful worth crores or tens of lakhs or tens of crores or whatever.
So according to you, if many of these startups have to shoot for 100 crore exit.
Yeah.
Okay, guys, get busy. Okay, I think any last questions, or we should.
Any comments? You disagree with anything? Still, you can feel free to.
Okay, let's thank Kaushik again.
Yeah. Thank you. Thank you. Thank you. Thank you. Thanks.
Thank you so much.
Thanks. I enjoyed it. Yeah.
And of course, as usual, it's a pleasure to have you here.
Yeah.
Hopefully, we'll get many more chances to listen to you again on some of these themes as well. Yeah. So we'll close here with this session. Okay. Nikita, do you want to make any announcements?